Good morning, everyone. My name is Adam Rennett. I'm the IP Law Fellow here at the Center for Intellectual Property Information and Privacy Law at UIC John Marshall. I'll be emceeing the event for the most part. During the event, I will be introducing each segment and providing details on event logistics. There are 5 things that I want to go over very quickly before we get started. The first is that you can access all the program materials. Chris has joined us very kindly. But you can access all the program materials during the virtual receptions or during the breaks. There is a tab at the top left-hand side of the screen. You can click and you can follow the link to access those. Second, we're delighted to announce the publication of our spring 2021 newsletter. As of today, there is a link in the top right-hand side of the screen that you can use to access that, and it highlights a lot of the things that the center has been up to since fall of last year, actually since spring of last year. So it goes over quite a bit. Third, if you have any technical issues, you can reach out to me directly via chat or by my email. I know a lot of you have my email, or you can chat with the student ambassadors. They're identified by the help desk type after their name, or you can actually go and visit the help desk at the bottom left hand of the screen. I'd like to issue a special thanks to our student ambassadors, Sabina, Audrey, Natalie, Adam, Denise, and Emily, for assisting us today. Fourth, as I'm sure you all have noticed after having joined already, the big thing about our events is that we offer the opportunity to mingle and actually speak with both speakers and attendees. This isn't Zoom, so please feel free to move to any table you want. If there's anyone you want to speak to, just go ahead, double click, join their table, and feel free to do that. Finally, at around noon, after the third session, we will be transitioning to room 2 for the rest of the program for the afternoon sessions. I will prompt you to do so, but if you do not see my message in chat, there is a link at the bottom right-hand side of your screen. So please make sure to click that whenever you're prompted. Our student ambassadors will be on hand to assist, and they'll make sure everybody can actually move to room 2, and then once they get into room 2, make sure everything is working fine. Without further ado, I want to introduce Professor Daryl Lim, who is the director of the center, and bring him up to the stage.
Hi, good morning, everybody, and thanks, Adam, for that introduction. I want to start, of course, by thanking Adam, who just joined us as our IP Law Fellow in January, and has already been hitting the ground running and doing a terrific job. We also want to thank the law school and our colleagues here at the law school. It's always a group effort, even though attendees tend to see a few people, but really it's a group effort, a team effort, and we're very grateful for the opportunity to work with a terrific bunch of people. Finally, I want to thank Chris Karani, who we will hear from in just a moment. Chris and I started this conversation in a coffee shop, and we were thinking of putting together a conference on design law, and that's why you see design law is a big part of it. Because we think that that's an important area and one which we should bring people together to talk about. And this theme of conversations is one that you're going to see all throughout the day. This is not a conference where you're going to have talking heads one after the other. This is an exchange of ideas, and it's also an exchange of ideas across disciplines. This is a characteristic of all our events. You never just have academics or practitioners talking in silos or government people. Every panel, we try to have a good diversity in every aspect, including diversity of views and industries. And so hopefully this gives you a good cross-section, a good feel of some of the most pressing issues of our time. And indeed, most of these issues do cross boundaries, whether you're talking about health and social justice, whether you're talking about antitrust and access to data, whether you're talking about copyrights, trademarks, and patents, which today, in many aspects, especially if you look at the last panel, touches on the issue of whether or not you can protect interface code and to what extent copyright is the right instrument for that. So when we think about intellectual property rights these days, I think a sophisticated thinker will have to look beyond the traditional silos that we've been brought up in law school to think about, and to really have broader conversations across disciplines and across areas. So this is what this conference attempts to do. And Chris Karani, if you are there, please join me on stage and add your own welcome to the panel.
Good morning, Professor Lim. Again, this is Chris Karani from McAndrews. Thank you for that warm introduction. I wanted to just have some opening remarks and comments. As Daryl had mentioned, the impetus of this idea for this conference started a few years back over a cup of coffee. So remember to take time to take that cup of coffee to spend and just dream a bit about bigger things. And during the conversation was talking about how there's these branches of law where when I go to conferences and there's sort of a pocket of folks who are experts in one area, and maybe just down the hall there's another pocket of experts in a different area talking about similar issues, but in totally different branches of the law. And sometimes the policy interest or policy goals in those different branches lead to a totally different response about how to react to that. But there's not a lot of conversation going on. And albeit the genesis started in the context of design and copyright and trade dress, it's as we started talking more, we realized that there was a lot of this insulation of ideas. So bringing folks together from all different pockets, not just in as a matter of issues and legal issues and disciplines, but also, as Daryl mentioned, I think one of the great services that the center does is bringing academics in the same think tank with respect to practitioners and in-house, because there's a lot to add to the conversation. So with that, we've got a jam-packed day of a lot of different, it's all hand-picked speakers and voices that we're going to hear from, a lot of different perspectives. So with that, I'll hand it back over to Daryl, but thanks again for allowing this to sort of grow, and also within the confines of your entire team there at UIC, John Marshall. Let's have a great conference.
Thanks so much, Danny. Sorry, thanks so much, Chris. I was thinking of Danny because Danny is coming up right after. But as Danny joins us on stage, I just want to also quickly thank our sponsors, Analysis Group, coming in as a gold sponsor, VMF, that's from Argentina, coming in as a bronze sponsor, and our annual sponsors, McAndrews, as well as Greer Burns and Jen Law. So I hope you all have a great event today and learn something, debate, have fun. Thank you.
Hello, everyone. So for our first panel, I'd like to introduce you to our moderator, Professor Danny Sokol. Danny is professor of law at the University of Florida Levin College of Law. Just as a quick reminder to all the moderators that are here, or I will probably have to repeat myself at least once or twice, but if you want to introduce your panelists, please only their names and their affiliations. Attendees can go on to read their bios and the materials if they want more details. Danny, would you like to get us started? I will bring the panelists to the stage.
Thank you. We're going to focus this first panel on the intersection of antitrust, IP, and privacy. Joining me on this panel are Bill Choi of Alex Partners, Divya Mathur of Analysis Group, Dan Spolber of Northwestern University Kellogg School of Management, Liad Wagman of the Federal Trade Commission, and Annie Xue of Xue. Okay, sorry. Yeah. Of Gen Law. So thank you, panelists. I'm going to do something a little bit different to show you how we can disrupt the world with this interface. We're going to go in reverse alphabetical order by last name to just get some opening comments to frame our overall discussion. Annie, I'll have you begin.
Thank you. Yeah, even if you do not reverse the order, I'm still the first one because I'm Annie. Yeah. Hello, everyone. I would thank the organizers for having me. My name is Annie Xue, partner of Beijing-based GEN law firm. I specialize in antitrust and data protection. My great pleasure being part of the panel. So in the past years, first the EU and then the US have started the enforcement campaigns against the big tech companies from the perspectives of competition law and personal data protection laws. But China and the regulations over the tech giants are tightened on multiple fronts as well. First, tone from the top. So, President Xi and the central leadership at the two top meetings of the party at the end of last year raised specific requirements to enhance antitrust enforcement and prevent the so-called disorderly capital expansion. Secondly, China released the antitrust guidelines in the field of platform economy to tackle the hot button issues such as exclusive dealing, big data and algorithm-driven discriminatory pricing, refusal to deal, and so on. Thirdly, the government has already put Alibaba under investigation for suspected monopolistic behaviors, and the parties who more than a dozen of transactions are fined for not securing the merger review clearance before closing the deals. And many of the parties, actually, they are, platform operators or big tech companies. So lastly, almost on the same day, the platform antitrust guidelines were released. TikTok's owner, ByteDance, filed a lawsuit against the Tencent for its blocking people from accessing content from Douyin on WeChat and QQ. So actually similar lawsuits have also happened before. In short, China has already joined the global trend of enhanced supervision of the gatekeepers. However, as a recent central government work report duly noted, the government supports the platform's efforts on innovation and international competitiveness. So it remains to be seen where the new trend will go in China. And I believe the experience of the EU and the US will also impact the Chinese policies. So I really look forward to hearing the insightful viewpoints from my panelists. Here are my 2 cents. Thank you very much. Yeah.
Okay,
hi.
Thank you. We're going to now move on to Liad.
All right, thank you, Danny, and thank you, Daryl and Chris, for organizing. At the outset, let me just state that these thoughts are my own and not of any organization or agency or the FTC or its individual commissioners. I have studied the economics of digital and information markets over the last 15 years. And while many of my projects are focused on digital privacy, lead generation, and informational costs and benefits, they also point out to the value of information more broadly and the value of digital ecosystems specifically. And lately, I've begun to focus more on the latter directly by assessing, for instance, the consumer surplus generated from digital services. And I'll be happy to share some quick results this morning. So the digital ecosystem is fast evolving, it's complex, and both consumers and firms have been beneficiaries of the economic value created. And so I briefly want to mention just 3 lines of work today that I've done along with colleagues. And these works illustrate the dimensions of the potential benefits, costs, and risks in these markets. And my general observation is that value creation and innovation are still happening at extraordinarily fast rates, and this raises the stakes for any intervention due to the potential for unintended consequences. So take, for instance, some policy proposals from across the pond, such as a mandate on data interoperability that may be imposed on a market, perhaps in an attempt to address some competition concerns. So while firms can benefit from sharing data with each other on a voluntary market-driven basis, for example, it can be another source of direct or indirect revenue, they may not do so uniformly with all other firms. But crucially, uniformity does not necessarily imply efficiency. And so mandating uniformity, for instance, as a duty to deal can at times be inefficient and lead to unintended consequences. And so any such policy needs to weigh the benefits of uniformity with potential costs. So for example, the impact of a duty to deal in terms of data sharing on firm incentives is largely unclear. New trade-offs can emerge as a result, and for instance, as far as how to collect and how to store raw data. If a firm is required to share, for example, clickstream data, then it will also need to save this data. And aside from the potential effect on privacy and data security, that may also shift firm resources from one innovation or one activity to another. It may also redirect other efforts of employees and potentially lead to detriment, cost to both consumers and firms. So as another example of unintended consequences, consider that there is some talk of designating firms as particular classes, as the so-called gateway firms. In other words, different set of rules for different groups of firms. And if the intent of such intervention, at least in part, is to enhance, for example, privacy, then asymmetric regulations such as this may distort the incentives to adopt state-of-the-art privacy standards by entrants from the ground up at the product design stages, and may expose consumers who are early adopters of new products to added risks and maybe change their mind about adopting these products in the first place. That is to say, regulation in one dimension can cause unintended consequences in another, and we see it so much with privacy and competition. Similarly, while forming a standard, say for interoperability, may create more competition in one dimension, technology is highly fluid and fast evolving, particularly as far as software is concerned, and standards may lag the pace of innovation. Okay. So to illustrate some of these points, in a paper published some years ago in RAND, a colleague and I studied the opt-out provision of the Gramm-Leach-Bliley Act, or GLB, which governs data privacy in financial markets. And we compare these opt-out provisions to stricter opt-in provisions enacted by local counties in California. And this is about 2 decades ago, right? But there are still insights that apply today. So in order to share or sell consumer data to non-affiliated third parties, firms or lenders would have to give consumers a chance to opt out.
We seem to have lost you. So until we find you, I'm going to move to Dan Spolber.
All right.
Thank you very much. Good morning to everyone on the panel, and I'd like to thank Daryl and the conference organizers for inviting me. It's a great pleasure to be here. The main thing I would like to say is that the nature of competition is in the process of change. Traditionally, competition, at least the theory of industrial organization and economic analysis generally, focused a lot more on price competition. But over time, we have gotten a greater and greater focus on innovation. And by this, I mean not just price competition, but price plus non-price competition, in which firms are introducing all kinds of innovations, not just digital platforms, but really a full range of technological change from 5G communications, AI, additive manufacturing, and so on. It's too little time to go through everything. So I wanted to place my remarks in that context, that innovation competition is changing the nature of antitrust as we recognize that firms compete in more complex ways. I wanted to talk about the 2 main themes of the conference, if you will, and that is first I start on talking a little bit about privacy, and then I'll talk a little bit about antitrust and intellectual property. So first, let me start with antitrust and privacy. This is an important area in antitrust law and policy today, and I think economists can be very helpful to attorneys. I'm sensitive to this point since there are many attorneys at this conference. I'm one of the few economists, if you don't mind my saying so. So economists can be very helpful because measurement and empirical estimation and modeling can be applied to better understand the topic of privacy. A recent study by Engelhardt and Narayanan at Princeton, looking at the top 1 million websites, measured web privacy in a variety of ways. And they found, for example, among their many other findings, that third parties are present on websites and that these third parties are tracking online activities in a variety of ways. One of their key findings was that Google led the list of third parties. They found that Google trackers were present on 75% of the top million websites. The runner-up wasn't even close. It was Facebook with about a third of the top million websites. The tracking and many other aspects of digital innovation has raised antitrust concerns. Recently, the House report on competition in digital markets, focusing primarily on Amazon, Apple, Facebook, and Google, suggested that, quote, the online platform's dominance carries significant costs. It has diminished consumer choice, eroded innovation and entrepreneurship in the U.S. economy, weakened the vibrancy of the free and diverse press, and undermined Americans' privacy. So this is a very important question. Is innovation competition creating benefits for consumers? The ultimate goal of antitrust being to maximize consumer benefits, and to do that, antitrust, of course, seeks to protect competition. So among the questions we can pose here are, do consumers really know what information they are providing to online behavioral marketers? Do consumers know the market value of the information that they're providing? Do they know the cost to themselves of providing that information? So not just the value to others, but what's the cost to themselves of that information? Do consumers really know who the third parties are on the websites that they visit? I was surprised by the third party aspect of tracking, and so I would guess that the average consumer is not aware. Are they aware of alternatives to providing information? I recently read a website that listed alternative service providers, and I hadn't heard of many of them. I had heard of DuckDuckGo in search and so on, but other areas had very specialized providers I was unaware of. These suggest that the lack of transparency and privacy issues may represent anti-competitive behavior. I don't know if that's the case, but lots more analysis and empirical investigation is needed. And so the question is whether these problems can be addressed by antitrust, by regulation, or perhaps by voluntary disclosures, or better voluntary disclosures by companies. I think that protecting consumer privacy would be pro-competitive. I want to say a brief word about antitrust and intellectual property. This is another important area. Here, I think that there is a major change in progress, and one of the big changes is that there's a recognition that IP has become much more important for competition. In other words, the traditional view, I think, of many was that patents and other forms of IP were anti-competitive in the sense that they conveyed some kind of market power to the patent holder. But I believe there's been a major shift here. For example, Illinois Tool versus Independent Inc. in 2008 eliminated the presumption of monopoly for patent holders. So here again, I think economic analysis can be helpful to attorneys in understanding what is the value of IP, how does IP affect competition, is IP licensing pro-competitive or anti-competitive. The antitrust guidelines toward intellectual property licensing have also now eliminated the presumption that IP it conveys monopoly to the IP holder. What worries me, though, is that there has been a kind of backdoor sneaking in of the presumption of monopoly for standard essential patents. I believe that standard essential patents are pro-competitive, and we can talk about this a little later, but I worry that the presumption has snuck back in, that while we recognize patents are pro-competitive, some allege that standard essential patents, which is where all the action is, are not pro-competitive. And so we should talk about this, I think, a little bit. I believe that standards enhance competition, provide ways for new firms to enter the market, and therefore standard essential patents are pro-competitive. All right, so I don't want to take more time since we can come back to these topics of privacy and intellectual property, but I think I should stop there. It's a delight meeting with you, and I look forward to your comments.
I'm having a problem on my screen. Leah reminds me of my grandmother. I can hear her voice, but I can't see her.
I see everybody.
Yes,
I'll
but
take that as a compliment.
he's there and you can all see him. So I'm going to get off the screen. He'll continue what he was saying and I'll jump back on. But if he's really not there and it really is all in my head, again, just like my grandmother, then we'll go to Divya.
All right, Danny, I'm here, and I'll take that comparison as a compliment. Happy to be part of the family. So I think I stopped discussing some of the potential trade-offs, and I was given an example of a subtle change.
Is he there?
Yeah, we see you. We see you, and we see Leah.
Is Leah actually speaking?
Yep.
He was.
Oh, okay. So keep speaking and just let it doesn't appear on my screen.
Hey, Dan, we'll text you when it's all done, okay?
Okay.
All right. Thank you, Danny. This comparison was pretty subtle. It was between opt-in and opt-out defaults, and it led to some pretty interesting differences. It's kind of a natural experiment that was done in 5 counties in the San Francisco metropolitan statistical area. And the result was that the counties that adopted opt-in provisions for information trade, for less privacy, basically, resulted in less efficient matching between borrowers and loans and higher mortgage rates and defaults and potentially foreclosures. In other words, when data flows were choked up, when the faucet was sort of the valve in the faucet of data flows was turned down, we saw inefficiencies rising in that market, and we're talking about 20 years ago almost. So it's quite apparent that these trade-offs were showing up early on. Now, more recently, there have been studies of the General Data Protection Regulation, or GDPR, including some of my own recent projects. So one example I was going to give in a paper that's now published in Marketing Science, my colleagues and I show that the effects GDPR has had in terms of depressing investments in the European technology ventures to the tune of 26% decline in the number of financing deals, with the brunt of these reductions incurred by younger consumer-facing ventures, although business-to-business ventures also incurred negative effects. And we show in a subsequent study recently highlighted in Competition Policy International that foreign investors were deterred from investing in EU ventures as a result of GDPR, with foreign-led deals decreasing by almost twice as much as domestic deals. Now, on top of that, we find that much of the decline is in what's called first-round deals. These are the first-round deals that take ventures off the ground. And arguably without them, the ventures just can't take off, or they go and seek funding elsewhere. So even if those ventures could seek funding elsewhere outside the EU, think about the potential frictions added to innovation and the entry process. Think what this means in an overall sense about potential unintended consequences here. At least some desirable ventures that could have come to fruition may have not, or may have come to fruition outside the EU, and investor networks that could have provided networking and mentoring and international marketing and revenue channels may have not been accessed. And so economic value that could have been created in the EU may have moved elsewhere or simply failed to be. All right, now the EU is proposing various fixes to GDPR, and that is all fine and good, but even those fixes might have unintended consequences. And so I think as economists, as Dan said, we have a lot that we can contribute to this discussion. Now, there are some recent studies by a team at MIT that uses surveys and experiments to assert that there are large amounts of consumer surplus derived from digital services. And many of those services are on smartphones and other devices. And I have a study of my own that looks at it recently, and specifically looks at the technology layer, software developer kits in the mobile ecosystem. And this technology layer that we're not so exposed to is what facilitates the development of apps. And many of these technologies, over 90%, are released by third parties, so they're not released by the operating system developers. Now, using a data set on these software development kits, I'm able to show that they're associated with tremendous gains in both creation of apps, but also in early venture funding for technology ventures, and also in technology-related jobs. So I think there's this link that can be established or can be pointed to between these third-party technologies that are released, new ventures being created, new jobs, and tremendous amount of consumer surplus in the mobile ecosystem, in the digital ecosystem. So combined, all of these results imply that technology is fast-moving. Little changes, even subtle changes between opt-in and opt-out, can have tremendous impacts on consumer surplus, on firms, on innovation, on entry. And so these trade-offs, these consequences need to be studied, hopefully before intervention is done. So with that, I'll let Divya take that.
And I can see you again, so it's wonderful, and I could hear you.
I'm not your grandma, right? And I'm not a cat either. So.
That's right. I was going to, in fact, just say that. And you're not a cat. You really seem to be you. Divya, you don't have a cat. You have a dog.
Indeed. And hopefully you can all see me and hear me and not see or hear my dog, so I can just get started.
Okay.
Well, good morning, everybody. And thank you to Daryl and Danny and the John Marshall Center for inviting me. It's a pleasure to be here with all of you. I'm an economist at Analysis Group, which is a litigation consulting firm. And much of my consulting work is in the competition space with the focus on technology, media, telecom, and issues as such. This is a really exciting time to be a practitioner and a competition economist. We've all seen the huge growth of technology platforms, which has not only created whole new industries and new business models, but it's also really forced everybody, regulators and practitioners and policymakers, to think hard and perhaps reassess the defining principles and framework within which we analyze competition and consumer welfare. And I think the intersection of privacy and antitrust is actually an excellent example of this focus. So traditionally, as we know, privacy and antitrust have been thought of as distinct areas of law, enforced by different regulators and governed by different standards, legal and potentially economic standards. Privacy typically is concerned with consumer protection. It doesn't really require evidence of monopoly power or harm to the competitive process. And in contrast, antitrust, at least in the US, is concerned very much with consumer welfare and looks at evidence of market power and potential harm to the competitive process. But in recent years, many folks, I think credibly, have argued that privacy can raise antitrust issues, particularly in the case of digital platforms and in cases where you think of data as being a very important dimension of competition. Advocates, I think, of this approach have proposed several potential theories of harm. I don't know if we'll have time to talk about all of them, but maybe I'll list them briefly and see what we can cover. One theory of harm is that privacy is this dimension of quality over which firms compete, especially in zero-price markets like search and social media. And at an extreme, the fact that consumers don't turn to alternatives may be evidence of market power. Another concern that has been raised is that privacy violations can lead to the accumulation and use of data in a way that increases barriers to entry and potentially allows dominant companies to maintain monopoly power. I think a third theory of harm is that dominant platforms can use privacy as a pretext or an excuse to not share data with rivals, which may create issues. Like I said, I don't know if we'll get into all of these issues, but I do want to note that there's at least one reason, probably others, that we want to be careful in thinking about privacy as quality. And that is because a very fundamental difference between privacy and other sort of product dimensions, such as price or quality, comes from this real heterogeneity in terms of how individuals value privacy and the trade-offs between privacy and quality. So, as consumers, we may all want lower prices, but we may not all want lower prices that result in lower quality. In other words, if we impose limits on how a firm can use data, that can affect product quality. So in social media platforms that are supported by digital advertising, limits on how data can be used can limit the usefulness of targeted ads to consumers, as well as their value to advertisers, which of course then can impact the level of investment by providers and others. I think both Liad and Dan have touched on some of these issues. Regulators, I think, have acknowledged that we have to be careful when we look at privacy as quality. And given that consumers have different tastes and your privacy cost may be my privacy benefit, identifying lessening of competition from privacy or for privacy can be challenging. I think it's also important to note, as both Liad and Dan have, that broad strokes regulation that maybe is heavy-handed or too blunt in this dimension can be costly and can have a lot of unintended consequences, both in innovation, but also, ironically, in diminishing competition if it unduly burdens smaller firms and makes it harder for them to compete. I think the last thought I have is, we've talked a little bit about competition and privacy, but there are many critical, I think, public policy and broader issues at play here. In some sense, we're in the midst of a global pandemic, and COVID-19 has really exacerbated the spotlight on these issues of privacy. Technology that can track or monitor individuals can help slow down or help us respond more effectively to the pandemic. But it also, of course, raises concerns about privacy and government overreach. And I've been struck by some of the statistics, survey-based statistics that have been coming out that, more than half of Americans now potentially back anonymized smartphone tracking in an effort to combat the pandemic. So I think there's this really interesting question about whether the pandemic will pave the way for a new age in digital surveillance, or, for our purposes, perhaps reset our perspective on some of these very important issues about data privacy. These are interesting times. A year ago, I think we had pivoted this conference from in person to remote, and here we are 365 days later, almost to the date, talking about the implications of this. So let me pause with that in light of time and turn it over to other speakers who can hopefully also both be seen and heard. And I look forward to a really fun discussion.
William?
All right, thanks, Danny. You can hear me okay, is that right? Okay, great. Well, Danny, thanks for moderating, and Daryl, thank you for the invitation here. I also am an economist at Alex Partners. I do have to make the disclaimer, all opinions are my own and don't necessarily reflect the views of Alex Partners or my colleagues. Again, I am very excited to participate, although we do have several economists here, and I'm quickly recognizing the law of diminishing returns as I was going through my ideas and hearing some great ideas from the other panelists. The reason I was excited to participate today is that my practice areas do cover antitrust, intellectual property, and patents. And I do quite a bit of consulting work for companies related to statistics and data analytics. In particular, I do help companies with understanding pricing, discounting, using user data or their client or their user data. I'm also involved on litigation matters related to AI and data breaches. So again, I was very excited to be here, and thank you for the invitation. So a lot of the topics that I had in mind have been covered by some of the co-panelists, so I'll keep my comments brief. So just to state an obvious point, successful big tech firms have large user data. What's not so obvious is, has the success of big tech firms been caused by the possession and possibly abuse of user data? So as a matter of privacy and antitrust, and if potentially abuse has occurred, what would be the consequence of loosening big tech's grip on their data in terms of competition, product quality, and innovation. I think some great questions have already been brought up. Let me just add 3 of my own, and then hopefully we can get started. I guess the first question I have, or the first thing that I potentially would like to talk about, is what is the evidence of the abuse of market power by the big tech firms with respect to data? The second question I have in mind is, do consumers really care enough about privacy? And are they willing to make the trade-offs between privacy and potential product quality? And the third question is entry and innovation at risk when the incumbents have these large user data sets? So with that said, I'll being the last, I'm not sure if I was crazy about this reordering, Danny, but I'll keep my comments brief.
So since you were so gracious to be last, I'll then ask the first question first to you.
Okay.
How do we deal with what is a growing sense of tension in some of these different areas that you all have identified? Antitrust, privacy, and IP. And I don't just mean in the United States, but globally.
Well, there is, let's start with the big tension. And the way I think about it is, you have these big tech firms that are obviously very powerful. Just to give some statistics, the 5 biggest tech firms collectively make about, 1/10 of all corporate profits in the US. They have recently acquired at least over 300, potentially 400 small firms over the past few years. As one panelist raised the question, having the user data, does it give these big tech firms some entrenchment in terms of their market position? And is there a risk that they are going to abuse their data? I think the attention is with respect to privacy and antitrust. Whether they have an incentive to abuse their data or not, and the consequences if you loosen their grip of their data, what are the potential fallouts? Will you see lower product quality? Will there be a competition for privacy? I mean, I think one issue that has come up in the UK is about, if there is encouragement of competition, you will see companies engaging in, as part of product quality, enhancements of privacy. I don't know if that's the case. In my experience, I have not seen the evidence that consumers care enough about privacy that would provide an incentive for companies, even in a competitive landscape, for them to incorporate or introduce privacy into their products. Now, with that being said, I think there's a recent trend with Apple, Google, in terms of focusing or pivoting towards privacy, but I think one can argue whether that's due to consumers caring about privacy, or whether that's creating a competitive advantage for them with respect to the other big tech firms.
Ask the same question. Maybe now I'm going to go out of order a little bit. Let me ask the question to Annie then. Same question. You have a very different experience in that you're based in the People's Republic of China. How do you view these tensions both within China and then also as you view it comparatively, since I suspect so much of what you do is interface with people in Europe and the United States as well, who are looking for guidance and frame it based on what they know. And then so how does this play out?
Yeah, I think in China, actually traditionally, probably we do not value privacy very much. But with the establishment of the privacy regulatory framework, I think more and more the average people are paying attention to their personal data, their privacy issues. And now we can see not only, the regulations, for example. Years ago, we have introduced the national security law. That's the very first law that's, addressed the privacy issues, because previously almost all privacy issues, privacy protection issues actually were addressed in kind of a lower, by rules at a lower hierarchy rules. And this year, it's very likely that our personal information protection law and data security law will be finally released by the National People's Congress. So generally speaking, I think the awareness of the importance of personal data are increasing in China. But when it comes to antitrust, I think it's very important to have a consensus on the value and policy goal of antitrust, whether antitrust is a good institutional tool to address privacy issues, or just leave it to the data protection authorities. Otherwise, I'm afraid that we may have the risk of double jeopardy and significant increase of the odds of type 1 error. And actually, many commentators, including some industry people in China, they say that the strict data protection rules in the EU, like the GDPR, actually are driven by industry development and economic growth considerations. That's my thoughts on the privacy versus antitrust. Yeah.
Try a different perspective. Leah, though you're speaking in your personal capacity, you work for the U.S. government, specifically the Federal Trade Commission, that sometimes has written all kinds of reports or made statements about some of these interface issues. To the extent that you can talk about this kind of interface and the potential tensions, what might you tell us that is informed both from your academic and professional government experiences?
Yeah, I would point our viewers to a contribution by the United States to the OECD in June 2020 that focuses on the interface between privacy and competition. And I think there's a statement there that it's a joint effort by the FTC and DOJ. Given some perspective about how enforcers might be looking at this. Now, obviously, among other objectives, a privacy concern, we would be looking at where the harms are. So a primary goal of an enforcement regime is to deter prohibited, harmful or otherwise undesirable conduct. And so in doing so, enforcement should mitigate harms that are not adequately mitigated or compensated by other available remedies or through the market, perhaps due to some systematic and durable market failure. Right? And there have been numerous FTC enforcement matters under Section 5 of the FTC Act that are based on false, for example, or misleading material statements or omissions in firm conduct. And from the flip side, while merger review, for instance, is concerned with competitive effects, the analysis of these effects may, in individual cases, involve some examination of data or data rights held by the merging parties, right? And so there might be consideration, but I would keep in mind that competition and privacy are distinct policy goals, right? And policymakers need to make some decisions there.
Turn to the duality of Liad. So we have the academic side, and then I'll ask Dan for that, and I'll have the professional side, and I'll turn to Divya for that. Dan, your reactions. You may in fact have a new book, for example, on the interface of competition and IP. Do you want to give us a little preview of that, because that goes to some of these potential tensions that you've identified?
Well, I thank you very much. I would like to talk about that, but if you don't mind, I wanted to just tie up a little bit the discussion on privacy, and then we can maybe go and talk a little bit together about intellectual property. So thanks for that question. I wanted to say that, you know, I'm going back to William's comment that consumers may not really value privacy that much. And so I would say that from my point of view, that seems to be an open question. In other words, I don't know. Do they value privacy? One might suggest, well, people give away all kinds of information all the time, so they benefit from targeted advertising, so maybe they don't value privacy. On the other hand, it could be that consumers are completely uninformed, and so they do all kinds of things that looks like they don't value privacy, but actually they do. They just don't know what they're giving away. In other words, they don't know that their personal data is highly valuable for the companies that are using that data, so they're unaware of what they're giving away. And at the same time, they're unaware of the harm or cost to them of divulging this kind of personal data. So I think in the absence of further study, we don't really know how consumers feel, because I don't think that they know fully the alternatives. In other words, are there alternative companies available out there that they could switch to that would give them a different mix of services and privacy? In other words, they may not know what the options are in the marketplace. Now, what I wanted to say as a general proposition from the point of view of antitrust and economics is this. I think economists are a little bit behind events. In other words, we haven't kept up enough in the following sense, that the traditional paradigm of perfect competition was very focused on price. In other words, is price greater than or equal to marginal cost, right? And then imperfect competition was supposed to have remedied that by bringing us a very general view of competition. But again, we started to worry about price. Is price greater than or equal to marginal cost? In other words, are people exercising market power? But in practice, the antitrust agencies and court cases and so on have worried a lot about things like unfair methods of competition, which takes us outside the simple realm of price and marginal cost, actually much more complexity in the real world. And I think that these issues have come to the fore in the digital marketplace as never before. And so it's incumbent upon economists, I'm really focusing on academic economists when I say that, to start to worry a little bit. I take Divya's point that it's not just more privacy equals more quality. I think that's a great point. But I would say that more knowledge and consumer choice is an aspect of quality. In other words, it's not whether or not I choose to divulge my private information, but am I allowed choices? So another Princeton study looked at 11,000 online retailers and found that there were all kinds of manipulative techniques that were used to get consumers to, reveal data or make improper choices. So it was a question of whether consumers really knew what they were doing. If that's the case, then we get back to the issue of whether or not there's fair or unfair competition. And here there's a role for antitrust. In other words, are these companies competing fairly? Because we want to promote competition. That's the goal of antitrust, right? Or at least the mechanism of antitrust. The goal is consumer welfare and economic efficiency, but the mechanism is there competition. Competition will bring consumers more choices, and then consumers will be hopefully made better off by that competition. So I think we're at a moment where I think the online marketplace is not as new as it once was, but it's new in the sense that we haven't fully it allowed consumers to be informed about their options. And this may have led to the situation where there are leading firms and very, very small upstart competitors, which may offer different mix of options. So again, I come back to my theme. It's not about price only. It is price, but it's price plus other aspects of competition. So I wanted to talk about that aspect. I want to get to IP though, but I want to stop here so we can get to IP in a few minutes. I didn't want to monopolize the chat.
And as you know, monopolization is not great. Sorry, go ahead, Divya.
I just wanted to comment on one thing Dan said, which really resonated with me, which is that I think this is absolutely right, that the right question is not necessarily, at the heart of this so-called privacy paradox of how much do consumers value privacy? Are their actions inconsistent with, their stated preferences? What I wanted to note is that how you answer that question and the data you use to measure that is critically important. And, both as a practitioner and as a PhD economist, I worry sometimes that courts don't really use the appropriate methods. And so the example that comes to mind is this German Facebook case, which I'm sure you're all familiar with. The court has held preliminarily that Facebook's terms and conditions illegally enabled it to use aggregated data, both from Facebook and combined from WhatsApp and Instagram. And irrespective of the conclusion, the court heavily relied on this so-called market study of stated preferences that went out there and asked consumers whether they would choose less privacy intrusive services if these were provided by Facebook. And how you frame the question, especially in a setting like this, is going to heavily determine the answer you get. So just to kind of close the loop on Dan's point of, it's a very important question. It needs to be addressed properly. Surveys and stated preferences certainly have a role to play, but how you design those surveys and whether we can all collectively be more creative. For example, the latest furore between Apple and Facebook, where Apple is saying, I'm going to change how consent works. I'm going to make consumers opt in to sharing their data. Some of those really give us natural live experiments. And I think irrespective of where you land, asking the question rigorously and appropriately, I think is extremely important for everybody. I know you want to talk about IP, so I will stop now.
Well, I quickly add to what Divya said and Dan said. Preferences may also change, right? They may change in the aggregate as a society collectively, but they may also change for individuals, and even on a daily basis and even within the day. We've seen some changes in the US, for example, after 9/11, there was a sea change in how the balance between security and privacy was perceived, right? And there was a sea change in terms of legal changes afterwards, different states adopting different, for example, wiretapping laws to represent the preferences of their constituents, or at least their legislatures, right? And it's likely that we'll see something similar after COVID worldwide, right? So individuals' preferences might change, society's preferences might change, and it's a big question for policymakers how to take that into account.
Well, let me just ask, what is the evidence you're seeing that consumers are unaware of the information being collected? Because, and again, I had that viewpoint at one time. I think my mind has been changed based on what I've seen from some of my experience, is that consumers are very aware of the fact that they're being monitored, their data is being collected. But I think, as Divya's point, is what type of data that some consumers don't particularly care about. They like the recommendations. They like getting free stuff. They like not having to pay for search or connecting with friends. And I mean, again, I had the viewpoint that consumers may be in the dark about what's. My opinion hasn't changed. I think consumers are very aware of what's being collected.
We can move to IP.
I can start.
Dan, why don't you start? Shall we say that your book is both sort of stating something that for which you have a basis, but yet at the same time is, I think, quite incendiary to many people.
So the book Danny is referring to is called The Case for Patents, and it just came out. And I long ago when I started studying innovation and so on, I thought everybody liked patents. And after a brief while, I came to the view that nobody likes patents. I came out with the kind of shock to discover that patents were viewed negatively by 90%, let's say, of academics, and it's probably more. And law professors, economists, and so on were writing negative things. And I found also, I call it the perfect storm, that at one point the Congress, even at one point the executive branch, the judiciary, not to mention the press, and of course academics, were all united, along with lobbying groups, in opposition to patents. The idea was that patents somehow conveyed market power to patent holders. Of course, this has been rejected many times. There were debates in England 100 years ago on exactly this question. And if you read those debates, which I have, it's amazing that it's almost verbatim what we're saying today. Some people would say, yeah, patent's a monopoly, and others would say, no, it's not, and for the same reasons we have today. So it's not a new argument. The difference is that now IP matters more than ever before. Companies compete with new ideas, with better products, better production processes, new kinds of transaction methods, digital online platforms, and so on. And so innovation has come to the fore. It's been estimated, and patents, therefore, even more. It's estimated that of the S&P 500, 85% of the value of the companies in the S&P 500 are intangible assets, including goodwill, but also including patents. And therefore, it's become more important than ever before. The short answer to the question is do patents convey market power is this, that patents restrict usage of the technology, but they do not create market barriers to entry. There may be market barriers to entry in any market, but that's a different thing than the IP. The IP is not creating the market barriers. There may be other factors of the traditional kind that create barriers to entry. So my book begins with this point, and which has now been recognized by Illinois Tool and by the Antitrust Guidelines toward Intellectual Property, which is that patents do not convey the presumption of monopoly. But my book goes further in the following sense. That's just the beginning. Intellectual property, patents are just the beginning. A patent is nothing without commercialization. In other words, unless the technology is used, unless the innovative products using the technology are created and production processes that apply the technology are put into practice, then nothing happens. But so patents are not just a recognition of the inventor's contribution, but rather they're step one in a long chain of events called innovation and competition. And for this reason, I suggest that antitrust should view its role as promoting intellectual property, not limiting it, because it's the beginning of competition. So my book is emphasizing that patents are not just protecting the inventor's returns, but rather patents are providing the foundation for commercialization of the ideas. In other words, they help companies get together through licensing, through sale, through cooperative R&D, through the creation of innovations that use the patented technology. And so I emphasize the great role that patents play in reducing transaction costs and increasing efficiency of transactions in the market for technology, or if you want, the market for ideas. And so patents play a role in the commercialization of new technology. They foster competition, they enhance competition. And so from an antitrust point of view, I think antitrust should not only protect intellectual property, but should view infringement of intellectual property as anti-competitive behavior, and should, to promote competition through innovation, you need to support strong IP. We've weakened the IP rules, and so I think antitrust has a role to play in protecting competition going forward. And it's a short version.
Dan, because now you've gotten a number of Q&A postings, so I thought maybe the rest of us can work through that. The first one, and I'll leave it to the panel, perhaps if businesses were depending on a lack of protection to create their business model, shouldn't get funding or be in, where'd that go? Or be in business, question mark. So I guess that would be a discuss, but let me give two more so that everyone on the panel can pick and choose which one they want to answer. Do you see a qualitative difference in competition effects between SEPs and non-SEPs? I'd like to hear your thoughts in the context of the telecommunications industry. And a third one, perhaps, where Dan notes there are negative perceptions of patents, to what extent would he characterize these as negative perceptions of patents generally, or specific obligations to particular regimes? And then we also get a comment about what gets lost is humanity, the benefit of free music versus the cost of infringement to the everyday musician. Thoughts? Wow. We have a lot of different directions that we can go in, and I'm going to put William on the spot and say, why don't you get us started by answering one or more of those questions, and then we'll move around. As is often the case in these kind of conversations.
Unmute.
Sorry, I was on. After a year, I still haven't mastered the mute button. Okay. Sorry, Dan. I'm sorry, which question do you want me to address? There were several questions there.
Kind of like the buffet meals that we can no longer have. Your choice.
Well, and part of it is, I'm going to confess, Dan, you went through those questions a little too quickly. So, yeah, I need to.
That box, the Q&A box, but basically the choice is, what is the humanistic value of IP versus infringement? One was specifically about standard essential patents versus non-standard essential patents. One of them is simply a nice way of saying, is Dan full of it? Or another one was, you know what, if you don't have IP, you should just get out of business.
Maybe I can jump in on one real quick, William,
sure.
You get a read on them. I think some of the negative perceptions might have to do with patent assertion entities. And it's kind of a small plug here. The FTC had a study that was started in the end of 2013. And the study was released in the end of 2016 on patent assertion entities. And you can read about the results from the study on the FTC website. Just to quote some of the results there, the common type that was found in the study that accounted for 96% of all patent infringement lawsuits was what the report called litigation patent assertion entities. And I think there's some argument to be made that there's economic value to these entities, and some arguments to be made that that it's inefficient. And you could read the report for yourself and make your judgments. I think that is very different from a startup looking to get a patent on its innovation. So I'll stop there.
Yeah. So I'm not sure if this addresses the question, but again, Dan, I don't think he's full of it. I agree with many of your points. Although I will say, just in my experience, there is the view that patents are pro-competitive, I think, is up for debate. I think that there is a lot of potential in terms of what's been there, the over-patenting. There's defensive patenting. I mean, one of the areas that I cover is AI. There is a tremendous amount of patents being granted, applied for with respect to AI. I've read a lot of those patents. It's not clear to me what differentiation there is between some of these patents and what the novelty is. So I don't disagree with the fact that patents are important. I recognize that patents can be, as one famous economist said, an engine of growth and innovation. But if I were looking at the statistics of what is being patented, especially with respect to AI and the latest technology, and also back to 2008 when we had a boom in patent litigation around the cell phones and telecommunications. It is not clear to me that, and I may be leaning one way, that patents are necessarily pro-competitive.
I mean, and I might just add one sentence to all of this, which is even talking about patents and whether they're pro-competitive or not in these broad brush strokes is a little complicated, because it depends on the industry you're talking about and the nature of the costs and how you need to incentivize innovation and what you need to do in order for that to happen. So a world of technology versus the world of pharmaceuticals versus manufacturing techniques. You know, I'll be the economist and just pose the question as opposed to answering it. But it is an important question, which is that thinking about the fundamentals of the underlying marketplace is critical in order to sort of land on what your view is on patents.
Do you have any thoughts? Yes.
Yeah, I just want to chip in from the perspective of the interface between IP and antitrust, because I have been working on ICP cases for years. Actually, just as Daniel said a moment ago, actually nowadays in the United States, it has already come to a consensus that holding an ICP is not equal to holding a dominant market position. And I'm glad to see that in China here, we also have the consensus, because if you look at our IP antitrust guidelines and our departmental rules concerning abuse of market dominance, so it specifically expressly states that holding an IP is not equal to holding a dominant market position. But still, again, I think many times actually industry policies may kick in and make certain jurisdictions more friendly to implementers, and some other jurisdictions more friendly to the patent holders or to the NPEs. So that's why we can see, across countries, anti-suit injunction and even anti-suit injunction have already come into play. Yeah, and including China, the UK and the US, the courts are kind of competing for jurisdictions and for the rights for the jurisdiction to set up the global rights. Yeah.
So yes, to follow up on Annie's point, I think it's very true that we see a tilt, and it's in different industries and in different countries that favor IP holders sometimes, and sometimes that favor implementers. I think that what should be the case is that antitrust policy should strive for neutrality. In other words, neither favoring IP holders nor favoring implementers. Why? My main point here is that almost all, I'm putting aside patent pools for a second, practically every patent license is the result of bilateral negotiation. Almost every patent licensing is a contract that's bilaterally negotiated. And in the marketplace for IP, this negotiation works very well. And the problem is that when people go to study this or talk about it, they talk about the legal cases. Now, this is, I believe, a bias on the part of people in law, that there's nothing more interesting than discussing a legal case. But statistical analysis has shown that patent cases or patent disputes are less than 1% of active patents. In fact, there are about a third of them, and properly adjusted for the number of patents and GDP and so on, it's actually not that much litigation occurs. The litigation is interesting, and some of it may be spectacular, but it's rare. Almost 99.6% of the time, private negotiation works, and it works very well, and the market continues. And despite the important patent disputes, almost all the time, it works quite well. Now, let me say a word about standard essential patents, since that's very controversial now. Now, here's the problem that I have with this this part of the world. People say, you know what? I love patents. Great thing. I love inventors. I love the small inventors. I love the person whose patent isn't worth anything. But as soon as the patent is of some value, in other words, the patent may play an important role in contributing to a standard, say 5G. Well, I'm not sure, people say, that I like those patents. So the idea is I like all patents except the cutting edge major contributions. But that's the whole point of the patent system, is that everyone who can tries to invent, and some of those are very important and make major technological contributions. So we shouldn't single out the good ones and say, I love patents except the good ones, but rather I would say that standard essential patents are very important because they're in the standard, not all of them, because some are just said to be essential when they're not, but some of them make major technological contributions. They help support the standard. The standard doesn't make the patent makes the standard. And so we shouldn't reintroduce the presumption of monopoly for standard essential patents. Rather, what we should do is say, do standards promote competition? I believe they do, and we should beware the tilt toward implementers, even though they are the big lobbyists here, and at the same time we should, of course, not tilt toward patent holders. And in fact, with one exception, almost all of the standards organizations, and there are about 1,000 of them, have made a huge effort to be neutral, to encourage private bargaining. And so if we take the lead of the standards organizations, they have, I think, by and large, with a little exception, been neutral.
Pause there, having framed these broader issues, to then say, I want to take us in a slightly different direction. Dan suggests, well, you know, private contract, we typically don't have a problem. Whether it's IP or antitrust or data privacy, many of these concerns are concerns that we're seeing in front of Congress right now. We're seeing in front of European legislators and in certain jurisdictions in Asia where there is a rethink of, do the institutions work or do they need to be realigned in some way? So let me push from specific type examples to simply, do we have the right tools? Your thoughts, I'll open it up. Who wants to go first? Or I'll call on someone. Divya.
I was going to volunteer. You just beat me to it, Danny. I'll just kick it off with the view that I think economics is a very, very powerful toolkit and gives us both methods and frameworks that are very flexible. And so I fully appreciate the notion of perhaps we need to move beyond the consumer welfare standard. Perhaps we need to very carefully think about non-price elements of competition, be it quality, be it choices, be it innovation. You know, in my mind, there are two separate questions. One is, what are these dimensions that need to be considered? And the second is, do the existing frameworks allow us to consider those dimensions? And I think my answer to both is yes. There are alternative elements that need to be considered, but our toolkit allows us to do so. The question of whether the institutions have it right and whether we need a different regulatory body, I have views on that, but I think there are folks on this panel who are probably have more informed views, especially those who are regulators and have worked closely with them. So I'll stop there and hopefully kick it off, and Danny won't need to cold call on anybody.
Do the institutions work? Leah, you work at one of those institutions. I'm sure there's an official position that, of course, you will tell us about.
Right. So obviously, my personal view, I'm an economist, a technologist, and so I try to stick in my lane, right? But I would say that there have been calls by the Commission for some additional authorities like civil penalties and addressing the common carrier exceptions. And so, there have been calls for some such changes, but I think the view on a lot of other things is that the current frameworks, have what it takes to address many of the issues that we're facing.
Annie, you have a series of institutions playing roles in China. How effective are they working together?
You mean the antitrust enforcement agencies? Oh,
now
actually,
that there's a single agency, is it different?
Yes, I would say now they have more uniform tone and methodologies, and I think they're more efficient right now, at least at the central level. And in terms of the legal framework, actually right now our government, our people's Congress are thinking about amending the Chinese anti-monopoly law to incorporate kind of more modern factors such as big data, algorithm, and the technology, such kind of thing. And actually, the release of the antitrust guidelines in the platform economy actually is also an effort of the government to provide kind of more handles for the industry to carry out their compliance, and also more a guideline for the agencies to do the law enforcement. And very interesting, actually, months ago, I saw on the website of the FTC, it said that the FTC joined the Antitrust AI program, organized by Stanford University. And a couple of weeks ago, I saw a Chinese government's official website. A news said that the Chinese government, that local Chinese antitrust agency actually is applying a internet plus supervision kind of initiative, and they incorporate some kind of modern technologies and big data, algorithm, that kind of factors to monitor the competition behaviors of the business operators, especially in the e-commerce world on a daily basis. I think that's a very interesting phenomena across different jurisdictions. They're thinking about the same thing.
Okay.
Just about out of time, but I want to give William and Dan just an opportunity to briefly give their sense of, do the institutions work or do we need tinkering? Whatever these institutions are, the judiciary, agencies, the USPTO, antitrust, you name it.
Well, just very briefly, I think that tinkering is probably the right word. We've talked about today how economists have viewed market power, and I think we need to rethink what market power means. It's not just about, previously we used to talk about If a company raises its price, what percentage of customers are they going to lose? As one rough definition of market power, that's not true today, given the dynamics. So yes, there's tinkering. Just on the patent side, I am concerned about I think an over patenting of AI. Just back in the day in the 2000s, I saw a patent for a stick to be thrown for a dog to retrieve. I saw a patent for how to swallow a pill. I'm seeing patents today about how to do what are common statistical methods. So I don't get the impression that those are pro-competitive. But again, I'm in the recognizing the time, I'll stop there.
Well, I think that there does need to be some reform, because the marketplace is running far ahead in some ways of the antitrust institutions. For example, the courts in eBay, particularly the court in eBay, imposed some very serious restrictions on the ability of IP holders to obtain injunctions. And we need injunctions to encourage the respect for intellectual property and to support private negotiations. So I worry a little about eBay. And so that would be a possible area for reform to strengthen intellectual property rights. I'm also concerned about how innovation is entering into merger policy. I think that is an area for additional discussion. If you look at the 2010 merger guidelines, they've made a lot of progress down that road, but I think a lot more could be done on mergers, but that's a big topic, and we're running short of time. I just say it, and then thank everybody. What a great discussion. So much fun meeting many of you. I know some people very well, but some I just meet for the first time.
Well, I want to thank everyone on the panel and everybody in the audience who had used the Q&A function. We got to some of the questions in Q&A, not to all of the questions, but if you look at everyone's glamorous websites, you can find their email addresses, and you can follow up with them by sending them an email if you wanted to know the answers to some of these unanswered questions. And in fact, to William's point, we might even see some kind of overly broad patent granted to somebody emailing a question. With that, Daryl, I turn it over back to you, or Adam.
I'll say, unfortunately, you get me. So I'd like to thank our panelists for a wonderful discussion. And again, as Danny said, please feel free to check out the speaker bios, their links. If you have any questions, I'm sure they would be kind enough to answer any that were not answered during the panel. Social justice. It will be moderated by Latif Matima. I will invite him up to the stage here. Latif is a professor of law at Howard University School of Law, as well as the founder and director of the Institute for IP and Social Justice. Latif, take it away. I will invite the others up to the stage.
Well, great. Thank you very much, Adam. It is a pleasure to be here. I'd like to thank John Marshall for organizing this wonderful conference, and my good friend, the director of the IP program, Professor Daryl Lim, for his typically extraordinary work in organizing the conference and conceptualizing the program. Today, for our second panel, Health and Social Justice, we have a stunning array of panelists, and I won't take the time to read all of their bios because, of course, you have them available to you, and that would take all day because they've done such amazing stuff. But I will at least introduce them. Our panelists include Amy Campbell, who's the Associate Dean for Law and Health Sciences and a Professor of Law at John Marshall, the University of Chicago John Marshall Law School. Paul Coletti, who is Associate Patent Counsel at Johnson & Johnson. Oops, I just lost that window. Karen A. Elliott, who's a shareholder at Porcinelli, PC. Anna Santos Rushman, was an assistant professor of law at the St. Louis University School of Law, and Karen A. Sebastian, who was counsel at Howell, Schuster, and Goldberg, LLP. And so with that, to our substantive discussion, welcome everyone. And I thought I might start us off with sort of a general question, because certainly both health and citizens have been very much on all of our minds and on the minds of everyone in our nation and indeed around the world in recent months, and obviously most of the entire past year. And so I'm wondering, how have these recent social crises, everything from obviously the pandemic, issues of racial inequality, climate change, how have these social crises and the national attention on them affected your perception of the relationship between, on the one hand, the purpose and structure of the intellectual property legal regime, and on the other hand, our need to address IP-related social deficiencies and injustice? In other words, put it differently, does or should the IP system impose a social conscience, if you would, or any specific social responsibility obligations on IP rights holders or users?
I'm happy to kick things off.
Great, thank you, Karen.
Thank you, Latif. It's a pleasure to be here today at the Intersections and IP conference. I think for me, I've always been someone who is sort of a believer in the classic economic theory behind IP protection. The idea that if you have a robust intellectual property system and you incentivize research and development investments through things like patent protection, then you're going to attract the best and the brightest, and hopefully the result is going to be cutting edge technology that benefits society as a whole and increases economic welfare. I think for me, over the last year, while I continue to really believe in the first part of the equation and that it's important, incentivizing innovation, I think for me, the last year has really brought into focus that we have a lot of work to do in terms of the second part of the equation, making sure that innovations are equitably distributed throughout society. I saw a recent statistic in the context of the COVID vaccine saying that, by February, something like 100 countries had received vaccines, but like 80% of that was concentrated in like 10 countries. And it's one data point, but I think it illustrates the work to do in terms of equitable distribution.
Yeah.
I'd agree with that. And just with what I've seen, I think there's two sides of this that we really need to be looking at. One side that Karen mentioned is just involving access to the benefits that technology provides, patented technology. All technology is generally intended to provide some benefit, but is there an objective threshold where it's reasonable for everyone to be entitled to a patent holder's technology? Another aspect that I'd also like to explore and that I've been thinking a lot about is just ensuring that all inventors have an equal opportunity to invent, seek patent protection for their inventions, and then receive the rewards that stem from the right to exclude. I'm looking forward to this conversation. Maybe some of my panelists have more insight on how we can make changes to the legal foundation. But like Karen, I am initially a big believer in how the system is set up, and I have hesitation in making any sort of sweeping legal changes that might have unintended consequences, particularly those that might harm those that it's seeking to help. But regardless, I think there's a lot we can do right now in holding ourselves and each other accountable. So I think our current answer is in demanding and facilitating social change rather than looking at trying to make legal and policy changes at this point.
Okay.
I'll take a stab. Hi, Latif, thank you. And thank you, Daryl and Adam, for inviting me. I guess before I get started, I have to be real careful because I obviously do work for one of the companies that makes the vaccine. So I do have to say that the opinions I express are mine, and I also have to be really, really careful about talking about our vaccine because we're a highly regulated industry, and I can't be perceived as promoting something that I'm not allowed to promote. So every once in a while, I might catch myself if I go too far. I heard what Karen and Taryn, what you both said. While I understand the positions, I think I take a more glass half full thought about what's happened in the last year. I actually think there has been a good amount of sharing of IP, starting literally from the Chinese sharing the virus virtually immediately upon discovering what the virus looked like. As well, I know that in the composition of all of our, not J&J's, but all of the clinical trials, particularly in the United States, there was a appropriate, significant emphasis on ensuring that every class, age-wise, racial composition, ethnic composition was, gender composition was appropriately represented. It would seem like that would be a layup, that it should just always be that way. And of course I would contend that it should be, but I think we have to admit that has not always been the case in the past. So I'd like to think that things are trending upwardly. Certainly, I agree with both Karen and Taryn that more can always be done, but not to pat us on the back, but maybe to tap us on the back.
Yeah. Amy?
Yeah. Yes. Can you hear me?
Yes.
Great. Okay. So I also welcome everyone. I'm glad to join this esteemed panel, and thanks, Daryl, for including me. And at first I was like, why is Daryl including me? Because I don't really do and live and breathe in the world of intellectual property, but I think a lot about health justice issues. I also want to be careful because I am someone who has yet to be vaccinated, but would like to benefit from a vaccine. So I do not want to, I want to keep, in good graces with our vaccine manufacturers. But I just wonder what this year has taught me is, or shown, illustrated, not just for me, but for so many, that why would it take such a global disaster, really sort of a tragic global sort of consequence, and some real significant probably government action to get us to a point where there could be at least broader. Certainly, we're sitting in Chicago right now, and we're seeing that the distribution has its hiccups as well, but we're trying to work towards equity, but it took a lot. But I'm just wondering, we are in a disruptive time, and so maybe it's an opportunity to use this time to sort of disrupt parts of the system that aren't working and to rethink, rather than tinker. I know the last session we talked about tinker. Is it an opportunity to transform so the intellectual property system meets the needs that we think are important about why we are innovating in science and what the purpose of these medicines are for, right? This is not to say anti-corporate or market, but how do we make sure that the system we have meets the goals we want? And so it's not, this is an opportunity to sort of build back better, as our president might say. And maybe we should take that opportunity to sort of rethink goals, who's defining the goals, and how the system is being designed.
Anna? Oh, you just muted. Okay, great. We can hear you now.
All right, so good morning, everybody. I'm delighted to be a part of this panel. Many thanks to the organizers and to my fellow co-panelists and our moderator. I have a disclosure to Mike, which is I cannot see Karen and I cannot hear Karen. So I might just repeat everything that Karen said. I can hear everybody else. And I'm going to give a quick take on the question that our moderator asked, and then I was advised to just dip out for a moment and try to log in. So I will disappear after this. So my quick take on this question that probably we could discuss for the rest of the day has had me think about a particular economist that spent a lot of time thinking about the patent system in the late 1950s, so Fritz Macklove, who said that, based on what I know, what we know about the patent system, I would not recommend implementing it, at least not in a place like the United States. But I also, based on what we know, would not recommend getting rid of it. And that's how I've felt about many of the things that have happened in the past. In the past year, I think we have a perfectly functional system that, on paper, actually splits many of the burdens and many of its benefits in a relatively balanced way. When I teach health law, and my students know that I care about things like who gets the vaccines, or the populations who need them the most getting them ahead of the ones that are, still indicated, but perhaps could afford to wait a little longer. Are health goods in general during the pandemic and outside the pandemic affordable to the populations that need them the most? So they automatically think, so that means you don't like pharmaceutical, right? That means you don't like IP rights. And the first thing I tell them is that show me a vaccine, or for that matter, a lot of other types of pharmaceutical products that has been produced in the 21st century or even before that, without the intervention of the private sector. So I do think that, particularly when it comes to things like vaccines, the patent system is actually necessary at this point and avoidable, and actually affords a lot of room for people creativity. We've seen some of that begin to emerge now with the pandemic, and I would say even before. Now, there are many things that are really not working in practice, and I do think more creative. I'll end this first just series of thoughts by saying that I don't think COVID has changed much. I think it has made things bigger. It has made the needs bigger. It has publicized the need for us to use the rights, the sets of rights that we have at the disposal of inventors, but also the mechanisms we have at that people who care about affordability and equity can use. It has given publicity to this, but many of the inefficiencies we're seeing, we saw them in the previous pandemic, 2009. Most of us did not realize we were in it. We saw them during the polio vaccine crisis. So I'm happy to discuss what I mean by creativity and what's like, but this is my general take on where we stand, and I will disappear hopefully for 1 minute.
Yes, great. Well, thank you. Hurry back. So, listening to our initial responses, there's something really interesting that just sort of rises to the surface. We all seem to be in agreement that there are social needs that IP can impact in a very favorable way. But on the other hand, and this may be surprising to some of our attendees who aren't involved in intellectual property law on a regular basis, although we acknowledge that there are these needs, the prevailing understanding or interpretation of the way the intellectual property system is structured, it doesn't actually require that the system be directly and specifically responsive to those social needs. As some of you pointed out, that the system is dependent upon economic incentives, and the expectation is that those economic incentives will direct IP endeavor in the direction such that all of our needs will be met. And as some of you pointed out, in some ways, it seems as if overall the system is working, but it sort of gives us this fundamental question that, well, if the system is structured in an economic utility direction, but we know we have these social needs that the system is not required, not explicitly required to address, is there a fundamental tension between the way in which our IP system is structured on the one hand and the needs and obligations of social justice? Or is it possible for us to not just by chance align these two, or not just in the moment, meaning we did it in connection with the pandemic, probably because we had to, right? But is there a way to re-envision, rethink, reinterpret, fundamentally change? I mean, I'm putting all those options on the table, right? Including some, right, that some of you have said, well, let's not go that far, right? But is there some way, okay, to realign things such that the social needs and goals that everyone agreed need be addressed can indeed fit into the objectives and the purpose of the IP law, or are they just fundamentally intention, no way to resolve that conflict? Who wants to solve this for us?
I don't. I was just going to say I don't think I have an answer to that, but I wanted to. Your question made me think of something that Paul mentioned, which was, kind of the glass half full or a silver lining to what the past year has been like, is the opportunities for sharing and collaboration that have come up. And I think collaboration between different kinds of entities, companies and research institutions from, a diverse maybe countries or, income producing areas can really foster innovation and at the same time, hopefully increase equity as well. That was one thing I wanted to pose to the group.
So there has been some collaboration. Okay. Were you about to say something again?
Yeah, I was going to say this makes me think of, before I said, let's be disruptive, carry it through. But that's something that I'm really interested. Are there ways to think of this market, that sort of market condition that we're in as a market for public health, right? And so the economics is about advancing health as a social good. These laws should, can they be supporting that way? Can our intellectual property be some way conceived as supporting and advancing that social good? And I was reading about an initiative that might be familiar to everyone. It was new to me, but a Drugs for Neglected Diseases initiative, but through Doctors Without Borders. And there they were harnessing the market in interesting ways to have a market sort of for the least well off, right, with the greatest need, right? So how can you create demand side where you work with individuals and populations who are facing things like malaria or, hepatitis C, different sorts of HIV, things that are happening. You harness sort of a demand, but you create a market of sort of a lower cost use, sort of competitive licensing, different kinds of schemes. So it seems like they've been quite innovative and thoughtful, and they've relied on, to Paul's point, it has relied on, it's sort of a nonprofit initiative, but it has relied on collaborations between governments and corporations at a global scale. And so it seems like there are ways that we could think of intellectual property as advancing, as a tool for advancing the public health. And there are models that exist to illustrate how to do that.
So in other words, that kind of combines the two comments so far, that there has been collaboration in these circumstances where really, really needed. And one way to ramp that up would be to take a problem-driven approach to identify specific areas in which there's need for endeavor, there's need for IP activity, target that, and then to structure the approach that it would invite and encourage collaboration. Okay, great, Paul?
So I was just going to say, and even though I am the patent attorney for the drug company sitting on this panel, Amy, you're absolutely right. My company, as well as many others, we do participate in access to medicine initiatives all around the world. And I think it's wonderful. I think it's a great thing that we do. The one area where it would seem that it doesn't address is research into really exotic diseases, diseases that there are only a few people existent in the entire world, but that need help. Now, in the United States, of course, we have the orphan medicine, orphan drug, provisions, and we address it that way. But what about people in other countries? That it is much more difficult. However, again, glass half full. Those initiatives for lesser developed countries where we are able to provide relatively either cost-free or low-cost access to medicines, that is, I would contend that that's an economic solution and really not an IP solution, but nonetheless it addresses the problem. And so I think it's wonderful. And if we can figure out as a world community ways to do that, I think we're doing well. I'll stop there.
I'll add that I agree with that. I think that the system is set up that we can leverage it in positive ways. And a lot of that comes from just arming people with knowledge and having an understanding of how the different players in the patent system are using it, so that we can understand what they're doing well and what they can do better. As we've seen over the last couple of years, an informed public that can demand accountability from the government, from companies, from each other is really powerful. We've seen that through the Me Too movement. We've seen that through the BLM movement. We've seen that power in action. So just asking the players in the patent system, what are you doing to promote social justice and equality, demanding transparent answers and following up to hold each other accountable to those answers, I think will go a long way. It's easy to sometimes cast patent owners just categorically as those trying to monopolize the industry to the disadvantage of certain people. But as we're seeing through Paul's examples and other examples that Amy was giving, there's a lot of companies out there, a lot of patent owners that use their patented technology for the betterment of the world, as well as participating in programs to provide access to underprivileged communities and countries. We just need to understand what they're doing so that we can look at what can we all do better and hold ourselves and each other accountable to that.
But let me. I think a lot of what you say is accurate. But let me devil's advocate for a moment there, because there are certainly patent holders and patent participants who do have a sense of social conscience. I think we would all have to acknowledge that there are others who don't apparently feel the same way, and it's also not. It's probably not representative to focus on actions during a time of a pandemic as being necessarily representative, right? It'd be very difficult for anyone, if asked during a pandemic, to say, well, I'd rather not, right? Okay, this would not be the time to do that. So what about that sort of structural obstacle, meaning the very fact that either A, someone can, and oftentimes do, they just say no, right? Or other structural impediments. You mentioned at the beginning of the comment that, okay, awareness, knowledge, those sorts of things. And I agree with you. But are there equal access opportunities for everyone to gain that knowledge, for everyone to participate? Because that would seem to be part of what needs to happen in order to expand our response. And I don't mean to just direct this only to you, Terry, but to everyone.
Sure. Yeah, I think there's kind of two parts to that. Again, I see two sides of this that are important. The side of providing equal access to benefiting from the patent system, and then on the other hand, providing equal access to the technologies, the benefits of the technologies that are protected by the patent system. I think on the latter, one of the difficulties is trying to establish any sort of bright line rule that goes after the bad actors of the system. We've seen the difficulty of addressing complex issues in the patent troll context, where there's not a way where you can establish a bright line rule that won't end up harming the people it's intended to help. So that's where, and it seems like kind of an easy answer, but I don't think it is, where we focus instead on the social aspects of holding each other accountable. On the one side, just promoting diversity within companies, within law firms. A lot of corporations are typically the largest patent filers, but we see that many of these organizations have the lowest participation rates for diverse inventors. So looking at holding companies accountable, and we see that through social media, we see that through the power of just the public in terms of asking these questions of companies. And I think over the last year, we've really started seeing companies respond positively, saying that they are going to look at these issues and address them in meaningful ways. Same with law firms, but just asking these questions of each other, and not just asking and letting it go, but following up and holding each other accountable. I don't want to take up all the time. I could talk about this a lot, but others want to jump in.
Yeah, no, and of course you're absolutely right? Because I think one of the key comments that you just made is that this is everybody's responsibility, right? I mean, the fact of the matter is that yes, corporations have been responsive, right? But government has a role, right? To the extent that there are structural impediments to the patent system, to the lack of diverse patent holders and a diversity in innovation and inventorship, that's not solely the responsibility of corporations. And in fact, probably if you were certainly, given the time that I spent in big law in the 80s and 90s, and for what my students and alumni tell me now, certainly if you were to compare the diversity record in corporations to the diversity record in many big law firms, corporations are way ahead. So everyone needs to take a hand on this. Anna, you had something you wanted to add.
Yeah, so I like how you framed this in structural terms, that and structural imbalances that we've frankly been dealing from pretty much the inception of the patent system. I very much appreciate a lot of the fixes, like the ones that Taryn was talking about. One thing that does worry me is that they're very surgical. There are some perhaps too surgical for my taste, right? So thinking about the problems that have already been raised in connection with certain types of health goods, the types of fixes that we're seeing now, and I call fixes to some of the things we see in terms of representativity and diversity, for instance, or some of the mechanisms that are now more popular to transfer patent protected technology. All those things are good things, are necessary things, right? They will help us probably with vaccines, because vaccines markets are so specific. But that more fundamental tie between intellectual property and the market-driven approach that works, on a number of levels. But we've talked already about neglected diseases, which vaccines intersect with, but it's not a perfect overlap. Rare genetic diseases. Even certain types of common cancers, right? The early stage work that could be done in cancer R&D, that's not done because we tend to favor later stage cancer R&D. So I'm thinking about very specific areas. And I often think that when we talk about IP, we mean different things, but this structural idea that we're tying things to market results and market incentives is still not going to get sorted out the way some of the imbalances we're seeing, for instance, with vaccines might after the pandemic. So the pandemic has a catalytic effect. We can, anytime there's a prompt, we're fairly good at addressing one particular type of health good or category, but I still worry that from an access to medicines perspective and from an investment perspective, which, is something that obviously companies can benefit from on multiple levels, and which will align nicely with social responsibility. agendas that they increasingly have. I worry that we're not doing enough in that sense, that structural imbalance, which I see it as health technology specific, is still not going to go away. I am a firm believer that we do have the legal tools. As I mentioned, that's what I meant by creativity. But I don't think that the prescription, for instance, we're using for vaccines and say COVAX, which really is not about IP when we think about it, right? It's a contractual structure. It's a risk pooling structure, but it's not about IP, frankly, although it has an IP component to it. I think it will work with some vaccines. It will not work with other vaccines when we start using mRNA technology for different vaccine purposes. So I think we need to have conversations about particular health goods. And of course, we know that be it the South-North divide and diseases that are endemic to each part of the world, be it the case of populations of patients that are in the US and other northern countries, but have a certain type of diseases, I think we're still not paying enough attention to them, in spite of many good efforts in academia, in the public sector, at company levels, etc. So I think we need to talk about things sometimes in health law and in IP at a more granular text-specific level.
Mm-hmm. Mm-hmm. Yeah. It's I think where this is sort of teeing up, this is sort of like a two-step process. I mean, you're basically, Anna, what you've just laid out is that, okay, so there is a fundamental issue, flaw, however you want to characterize it, that we just have to acknowledge that an economic focus or economic emphasis, assessing both the objectives of IP and assessing using only economic methods to assess its success, it can do some powerful things, and it has done some powerful things. But we just have to be realistic about the fact that economics only, it's obviously going to leave some things unaddressed, because some things, some IP needs, social needs, they're just not profitable, right? So, but let's put that aside for the moment, right? So in other words, no approach is perfect. So it's not a heinous criticism to say that the economic emphasis approach is not going to fix everything, right? And so we have to think about, okay, so how do we get to the place that the IP system can be expanded or re-envisioned or just re-approached, not necessarily fundamentally changing the IP, such that these other things can also be addressed as part of its mission. But perhaps on the path to getting there, we can look again at some of the tools, mechanisms that we've used so far that have been successful in this regard. What Paul talked about in terms of some of the approaches for exotic diseases, what Amy, you talked about the big market for public health approach. What are some of the other things that have worked in this regard? Are there other things that you are aware of that we might look to, other examples, whether current in terms of it specifically in connection with the pandemic, government efforts, additional private efforts, NGO efforts? Are there other, or beyond the pandemic, other IP social needs? What are some other positives? Because if it seems that the more that we look at the positive efforts, right, the more that we come up with not only solutions, but the more that we can say, yes, the current system, here's more examples of it working, and pointing to directions as to how we might further adapt the system to work even better. So what are some of the other examples of some things that you think of?
Well, I'll give you one, but it is on a grand scale, admittedly, and of course that makes it not applicable to everything, Latif. You heard the announcement by the president standing with our CEO and the CEO of Merck a couple of days ago, saying that Merck was going to help J&J make vaccines. I mean, there could be no more significant dive into collaboration than two major pharmaceutical companies making the same vaccine at no profit to help the world, not really only the American public, but the world. I mean, this is wonderful. However, it is at a humongous scale, because we're in the middle of a pandemic. What do you do when you need a couple of hundred vaccines? And, you're not talking Merck and J&J, but you're talking, a much smaller entity and another much smaller entity. I don't think you're going to have them collaborate via the government. They might choose to do so on their own. But how do you get at that? That might be the question. As Anna said, I'm not necessarily sure it's IP. I think it might be economics. What are the economic incentives as compared to, is IP preventing anyone from getting into the field? I truly don't have an answer for that, but that's from where I sit, that's a much more significant question as compared to the larger scale.
Anyone else? Good. Yeah, go ahead, Dan. Oh, you're back on mute. Hit it one more time. Good. You're good.
You think I would have learned this, right? So I would also add that I think we have a timing problem, again, particularly for the types of health goods for which there won't be global demand, right? And the timing problem, which is somewhat intertwined with IP, I think is best illustrated in my mind by an initiative that I think is incredibly important, and that we law professors, a couple of law professors and lawyers for it, which is the COVID pledge that's currently in place, and to a lesser extent some of the patent pools, for instance, that we've seen. They had to be reactive, right? In the context of the pandemic, they had to be reactive responses. I think we are too reactive right now, from a structural perspective. I would like to see some of the things that were worked out during the pandemic, because we know there will be another one, and if not a pandemic, a significant transnational public health crisis. I would like to see some of these mechanisms that came together quickly, not only negotiated ahead of time, and they don't have to apply ahead of time. They can be conditioned on a pandemic or an epidemic or whatever the trigger event we might want. Take place, a declaration of something, for instance. I would like to see these negotiations take place before a public health crisis occurs. And again, this is not strictly IP, right? But it's our responsive mode, and it might work in some areas for long-term planning. It does not work in the field of public health law, right? When public health law meets the need for access to some of these technologies, even from an industry perspective, right? Coming together, we have 200 different vaccine development projects with a lot of repeat players. I would happily take half of the R&D on COVID vaccines, for instance, that happened during the pandemic. And I know the economics are not, that square, but I would happily take fewer players coming to the table for a little bit more diversity, size-wise and region-wise. If we had a plan in place saying, these are some of the things we will license, or we might not enforce this, but some of the things we are willing to license and the ones we are not, right? So here's the plan for the next pandemic. This is what you'll get to work with, say in January or February of 2020, when the pandemic begins, as opposed to March comes and we're still trying to set up some of these mechanisms. And this is part of using the mechanisms we now have in place, but just in a different way, really a different timeline.
So it seems to suggest that, the current system, economic emphasis nonetheless, that for big problems, big issues, whether these are beyond economic incentives, it seems that there are sufficient motivations to get the players to come together and to think about ways to collaborate to address major challenges. And what you're suggesting is that we don't just wait for a major problem. We begin to put these structures in place so that sort of collaboration becomes the norm, right? And it does seem to work for big problems. As we've all just sort of noted, I'd like to turn our attention to what about the little problems? So for example, what about, health disparities in low income communities, right? On the one hand, it's interesting because when we think about, again, going back to Paul, the exotic disease in a developing nation, to some extent, maybe that gets addressed because there are a broad range of IP needs, some big problems. And when boots are already on the ground to deal with these big problems, it's almost unavoidable that you notice some of these small problems. But on the other hand, here we are in the United States, right? The wealthiest nation in the world. And we have lots of these little problems, meaning in the sense of communities that experience just perennial access to health disparities, individual health disparities. That's not going to be economic driven, right? It's probably not going to be profitable. I mean, there may be a profit, but not the kind of profit that focusing on other issues, right? And it doesn't garner the same attention as we're solving a big problem. And of course, with a big problem in the long run, we see how everybody's going to be affected, or most people will be affected. But for these little problems, none of that is true, right? Profit isn't there, the big cachet isn't there, and we know that the bulk of our society isn't going to be affected because these communities have suffered these perennial issues, and the enterprise has not gone down. How do we start to address those types of problems?
I'll just say the first thing we have to do is we have to sort of recognize that they're we have to recognize their problems, right? We have to talk to the people who could define the scope of the extent of the little problems. I think, it was a big problem because it affected us, right? As a wealthy nation that had the tools, the infrastructures to do something, right? And it's totally separate. This just came to mind when you were talking, though. But I remember when I was in the city of Memphis, and we presented to the community that we were expanding bike lanes and how wonderful that was. And several sort of areas of the community members said to us, yeah, but, we don't have access to good food. We don't have a safe way to get to school. I love the bike lane, but that's not going to help me eat. And I was like, oh, okay, wait, we were solving our problem, right? Isn't this great? But we weren't really getting to the immediate need. So I think we have to have a system that's more responsive, and thinking about it in terms of intellectual property, and we were talking about structural, it would be really neat, I think, if we could build micro infrastructures, right, or sort of harness some of the technology, the research knowledge, the capacity to ask these questions, to respond, to innovate, to have incubators that are more localized, and how law could help, whether it's IP law, economics, whatever kind of things we could pull together that would incentivize that and make that address those little problems and be successful, again, as the individuals who are involved see is important. Maybe that can be, it answers little problems, but maybe the platform could then be used more globally or to address other kinds of issues.
Yeah. Taryn, were you about to say something?
Yeah, so what Paul and Amy were talking about just was getting me thinking about what we can do using the system or changes that we could potentially make. Right now, the problem that we're facing with the pandemic is one that's very visible, very scrutinized. There's a lot of incentive in the structure, or just the environment that we have right now for collaboration to solve this global problem. But when that spotlight is gone, how do we address the issues that face small portions of the community that really need the help. If you have, on the one hand, a patent holder that has the technology to provide the tools necessary to help that community, but they choose not to, or choose not to make it financially or otherwise accessible to that community. But then you have another party that is willing to do so. But you have this patent holder that has the right to exclude, thereby preventing that other party from coming in. What can we do then to incentivize either a collaboration where you have this other party that's willing to come in and use that technology to help, or just to be able to provide that access in some way? I don't know the answer to it, but it's certainly something that I think needs to be looked at so that we can help on those smaller scales, as Paul and Amy were talking about.
Yeah. I think, oh, go ahead, Karen, I'm sorry.
I was just going to say, what Taryn was just talking about reminds me of a comment that I think was in the last panel, which was mentioning that most licensing happens, from the standpoint of like individual negotiations. And I feel like tech transfer, there's a real opportunity to use tech transfer in a way to increase, the diversity in terms of inventions and ideas. And I wonder if there's a way to incentivize, licensing within a different kind of framework, less of an individualistic framework.
Yeah. And the only thing I was going to add was that with respect to unused IP, this is from my experience at my company. I can't speak for the entire industry. I can't even speak for my own company entirely. But from my experience, when it's unused IP, from my observation, it's very, very rare that we are going to try to prevent somebody from using the IP, because we know that there's a deal to be made. And as Karen said, I think what that means is to get the two parties to adequately, come together so that you can benefit the community, while at the same time the patent holder can profit from the IP. The last panel, I think it was Bill Choi who said, there's usually a deal there somewhere. And if it may, who knows? Maybe Latif. Maybe if the government can step in and broker that deal, as Amy was saying, maybe that's a good thing. It is those micro problems, and they're really not micro. We know they happen in every city all around the country, but it's those problems that perhaps we can figure out economically to address, as compared to worrying too much about what the IP is like. It's really to make the economics work. I would submit.
And I would throw into the mix just an example that I think actually points to a path forward, and it's that of telemedicine during the pandemic. We know IP chases markets, right? So if the market for telemedicine were bigger, which it is now, right, we will see innovation there. Some of it IP driven, some of it not IP driven, but I think collectively it seems that all of us would perhaps agree that more inventive activity in areas like this would be good. Why haven't we had more of this before the pandemic? It was actually a set of laws that have nothing to do with IP, from state licensure laws to Medicare reimbursement and coverage, right? How did we deal with this during the pandemic? Waivers, pretty much, right? Relaxed some of the more archaic requirements that were in place, and we see a boom in telemedicine services. Is this going to endure? It's a separate conversation, right? But I think this shows that one thing we know about IP-driven models, that they chase markets, right? And if we care truly about underserved communities, there are some unifying characteristics. Earlier, I was talking about, health goods being the unifying characteristics, right? Because that's the health good you're going to need because of a particular disease or because you're in a particular part of the world. But throughout the US, we know that remote communities as a whole, right, tend to be underserved for a different number of medical conditions. Ditto with urban communities who have mobility hurdles to face, job-related hurdles to face. So we know, for instance, how to create a better market. And I think, IP-motivated innovators will follow, and so will the others, right? So that's something that gives me some hope moving forward from the pandemic, because there's a new market. There's a much more expanded market that has a huge potential to do enormous good from a social welfare perspective.
And, I really like that observation about IP chasing markets, right? Because in many ways, it suggests to me a connection between IP chasing markets and the need for greater diversity in terms of participation, right? In other words, not just diversity of invention, but diversity of inventor, if you will. To some extent, maybe there are markets that we haven't been chasing because we don't have a sufficiently diverse group in the room to discuss and to identify what those markets are. I mean, one of the really interesting things that this unfortunate pandemic revealed, along with the various health disparities, was that our focus, of course, for example, is on reopening schools. First level, we think about education. At the next level, we think about working parents. So we know we need, but then after we're all working at home remotely, initially it seems as if, well, okay, we can hobble along for a while, but then what quickly we hadn't thought about, but then we immediately are forced to recognize, essential workers have children too. Okay, and essential workers disproportionately come from these underserved communities, right? So even if those of us who are fortunate enough to be able to work from home, I mean, obviously I'm a law professor, I'm very fortunate, I'm able to work from home. If you need an essential worker to do whatever it is, to continue to drive the trains, to staff the grocery stores, right? If they can't have their children in school, if they don't have anyone to look after their children, teach their children, well, they have to stay home. And now, once again, we have the domino effect, right? But without diversity in the room, we would not anticipate that, and indeed we didn't anticipate it until it became a problem. Other thoughts about diversity? Yeah, Paul, please.
Yeah, I was going to say on the diversity front, and this is not the solution, but it's a step toward the solution. I was literally this morning reading a statement from the U.S. Patent Office. There is a significant effort being made by the office now to both ensure that the patent bar is open to a greater diversity. It's some crazy number like 80 or 78% of all patent attorneys right now are male. I suspect primarily white male. And the patent office is trying to do something with that with respect to licensing. I read something the other day. There's this ludicrous standard right now that if you have a master's in biology, you're not eligible to sit for the patent bar. But if you have a bachelor's in biology, you are eligible to sit for the patent bar. And it's an artifact of some CFR regulation of the 50s, but it's never been amended. So there are those efforts going on, which are entirely appropriate, of course. And as well, there are significant efforts by governments and corporations to get inventors of multiple diverse communities. And that is both at the grassroots level, but also to prime the pump by getting more diverse elements into the community of inventors out of high schools, out of colleges. That's going to take a long time, but it's a start. What do you do in the interim? There must be so many other things to do. And I think if we can get both corporations and the governments and the general public to look at those efforts, I think we'll be doing a lot better.
Yeah, and adding law firms as well. Law firms struggle with diversity, and there's an increase in the focus on it, but it's very, very far behind, particularly not just with respect to adding diversity to the firm, but retaining the diversity, providing opportunities for promotion, making sure that there's opportunities for diversity at the leadership level, and having a representation of different people with different backgrounds on teams that are provided to on pitches. And I think part of that can help with that too is that when companies are looking at different law firms for providing pitches, that they look at the makeup of the team that's being pitched to them. Not just during the pitch stage though, but is that same team that was pitched to them working on their matters? Or was that just pitched for the purpose of showing diversity, but then those people are not provided the opportunities to work on the matters? The other thing that I think everybody needs to look at, and along the lines of what Latif was mentioning earlier, we need to start at the school level, at the education level. The pandemic has resulted in a lot of underprivileged children falling even further behind than they would be otherwise, with some kids being able to work effectively at home because they have their parents there to help them, they have access to Wi-Fi, they have the resources that they need, whereas a lot of children don't have those right now. And the impacts of that, I think we're going to see pretty significantly. How do we help them now so that they have these opportunities in the future?
Yeah. I mean, just to pick up on that, it always struck me. I mean, I had been writing about the digital divide, early on, like the 90s and turn of the century. It's amazing to me how now everybody gets it, right? Now everybody gets it because the children of all those workers that we needed. Oh wait, no, they need computers too. But to turn the lens to the other side, to be fair, I think that some of the other things that we can do to positively impact this situation in a concrete way. I like many of the things that you just suggested, Taryn, about, because again, I did big law for about 13 years before becoming a law professor. So, and things have changed like a little time. I mean, a really little tiny bit, right? And we had those conversations back then in the 80s and 90s, and we're still having it now. But I think that turning the lens in a slightly different direction, I think that when entities outside of those communities sincerely try to make a positive impact, something that I've thought about a lot lately that I think we need to do, that is to, when support is given, to enumerate concrete deliverables. I think that what happens oftentimes in a very perhaps good-natured, well-meaning way, a check is written to the usual suspects and the promises are made. But the problem is that we just handing it over to the usual suspects doesn't always work because these aren't the usual problems, right? If the people who do traditional civil rights, diversity work in areas of voting, in housing, criminal justice reform, but many times those people are not experts in IP, right? And to go to those entities and merely say, okay, I know you need support, here's the support, come back with some positive results that will help us in terms of IP diversity recruitment. How would they know What has to be, it has to be more targeted. It has to be, okay, we're reaching out to you because we know you have to be a partner for this. However, collectively now, like we can't just write a check and walk away, and you can't just accept a check and walk away. Collectively, we have to delineate a plan. We have to delineate a pipeline, because what's interesting about that, right, is that, yeah, you guys doing the legacy work, you know where the people are, but you guys coming in wanting to do the support, you know where the expertise is, right? So if there is a group of diverse patent lawyers, right? This group doing the legacy work, they probably don't know where they are, but this group providing the support, you do know where they are, right? So what has to happen is that the patent experts, the corporations, the law firms, et cetera, that know where the relatively small number of patent Black, Latino, excuse me, women patent attorneys are, have to then say, not only here's the check, but here are some candidates, right? Okay. And then at the same time, in addition to approaching things at that upper level, as you know, Paul and others were suggesting, we have to approach the long-term pipeline issue as well. And I think that part of the problem is that in the past, we throw up our hands and we say, well, that's going to take generations, so we get started with that STEM education. But clearly, we have to hit all levels simultaneously, all across the board.
Yeah.
And
so if I could just jump in, one of the things that I find striking about this conversation is that the flip side of many of the things we've been discussing about IP and health is the idea of trust, right? Because we've grown collectively used to seeing the same players, right? And often they're doing good, sometimes they're not, but we've seen the same players systemically be the ones driving the types of services and goods that we offer to these communities and that we fail to offer them. And one thing that I think IP could learn from the public health law sort of handbook, not to say that in public health we do this tremendously well, is that there are ways that we are familiar with in which we can engage with underserved communities, and often communities that don't trust innovation coming from these repeat players, right? So we've been playing this game for 100, 200 years. So there are some tools outside IP that I think could be really, really useful, because there's a matter of trust. We're seeing this with vaccines. We've come together to produce vaccines, and I cannot blame some of the populations who are, who have doubts about these vaccines, right? Given what has happened in the history of medical research in the United States and what has been done to them. And I think IP needs to be attentive to this. And there's been growing recognition, and it's been a good thing of severe racial and ethnic imbalances in multiple entry points, right, to the patent system. But if you allow me, because I'm a law professor, I would like to give a shout out here to actually the John Marshall IP Journal, because as early as 2014, they were publishing Professor Saurabh Vishnu-Kabat's article on gender diversity in the patent bar, which is, to my knowledge, one of the earlier articles on this. So we've been mapping this for a while, and if I don't mess things up, I'm going to put the link to this in the chat, together with the more recent article on the patent gender bar, written by Chicago, actually, by students of Professor Sarnoff, who I think is in attendance today, and finally just one article by Colleen Chen. So if you want to see what legal academia has been saying recently and not so recently about this, I think it is available in the chat now.
That's great. And building on what Anna said, I think that's exactly true. I think in addition to the diversity of the patent bar and the scientists and all, when we think about public health models, there's so much community-based participatory research happening. So could we think about a community-based participatory tech transfer, in terms of, sort of expand it down the line? So it's the people in the room are reflective of the on-the-ground issues that we're seeing. So they're defining what research is happening, but also how it's getting implemented, transferred, commercialized, getting sort of access to it. How we're defining success. So maybe make that more participatory and reflective of more voices.
Mm-hmm. 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 It's really interesting because in a way, what we've been doing in the last several minutes, excuse me, is we've sort of been building upon this. Okay, let's identify some problems that need to be solved, right? Let's start from there, and then let's figure out how we can utilize the IP system writ large. And by writ large, I mean not by itself necessarily, right? How can we just look at the palette of tools available to us, including IP, right, to solve those problems? And it seems that that's something of a non-traditional perspective of IP, right? In other words, at least of the IP system, right? You know, the traditional perspective, let's look at it, let's see, okay, how can we make certain that economic incentives get us to where we need to be, meaning to get us IP? And what we've just discussed is, all right, let's look at the problems that we need to solve, in particular, the problems that are not being solved, right? Because the traditional approach to IP, I'd be the first to acknowledge, has enabled us to solve lots of IP problems, right? Economic incentives do work, right? Issues that they only work to a certain degree, right? Because some things just are not economic. And so how do we start to look at the IP system and say, all right, well, how do we look at it in additional ways? How do we incorporate non-economic values and objectives into our perspective? And I think what this conversation just did was to say, well, one way to do it is to look at problems not being solved, right? And once you put that up on the whiteboard and say, how do we fix this? And you got a bunch of IP people in the room, well, they're naturally going to start thinking about it in an IP sort of way, right? And then you come up with a structure, a solution, an approach. Then the question becomes, how do you incentivize it? In some cases, we've seen that, well, you can incentivize it just by the nature of the problem being huge, right? And opportunities for collaboration. But does that go far enough? Are there obstacles that still remain? I mean, the fact that we figure out a way to get there utilizing the IP system, what do we do with those circumstances in which we know what to do, we know what we need to do, we know what we want to do, but we still run up against the incentive. I mean, there just still isn't sufficient economic incentive to get everybody on the table, even though we know there are problems and we know that they need to be addressed, and we've even kind of figured out how to address them. How do we, in those last group of circumstances, how do we push ourselves over that last finish line? Any thoughts? Yeah, I know. I mean, I asked you guys because I don't have an answer.
That's the hardest problem, isn't it? I was going to say that's the hardest problem. That's really where the rubber hits the road. I don't have a solution for that, Latif. That's, you know, it's hard to get the first mover advantage in that situation.
I think really some of the things you suggested earlier, Paul, about a role for government. Because, you know, it's not fair or realistic to say, okay, private players, okay, you're going to go, I mean, you're already doing a lot, right? You're already collaborating. We've all agreed that they certainly have a better diversity record, you know. But then to say, okay, whose job is it to run that last mile? Right? In other words, here's that area in which there's not going to be any hope for profit. In fact, you're going to lose money. And there's not going to be any great PR, right? And indeed, it's unlikely that there's going to be a great deal of valuable, unique R&D, right? All that's going to happen here is that this is going to be a public service. That's all that's going to happen. You're going to have an impact in an area of society in which, but for your efforts, there won't be, right? And I think in that area, perhaps the place where the responsibility has to lie, perhaps it does. That's where government has to come in.
Yeah, I mean, I was facetiously going to say that's when you call Bill Gates, but but otherwise, I was thinking there still is a role for government, and as Anna was saying, sort of as feeling like a law professor, I also sort of sit in a university and think maybe we also, with government, we also have to leverage our academic partners who, even when things don't pan out and economically and commercially don't, there is learning that can happen from that. And so how can we leverage the value that universities could play, sort of an academic piece of that government, public-private partnership, because I think there's a lot of opportunity, and universities sit within communities and are trying to do more embedded with the community, and so, there's probably a lot of richness there that we could play off of.
Yeah. I think the other thing too is just looking at this conversation, I feel inspired by this conversation. I learned a lot from each of you. We have law firms, academics, and corporations on this panel here, and just talking through it, I think that we've made some steps that there's execution that could flow from there. So starting with just the basic step of continuing the conversation, and how can academics and law firms and the government and companies all come together to solve these problems. Looking at ways that facilitate that conversation, provide the information to people, encourage community and public involvement in these conversations as well. As Latif mentioned, getting the people who have the actual knowledge, who are being impacted by these issues, in the room. And just working through these problems together, I think that there's a lot that can happen even from just facilitating those conversations.
Anna, were you about to say something?
I was just going to add to this, and I think there's a framing issue here, because sometimes we ascribe too much to IP, as we've discussed, right? Mm-hmm. Part of the problem that we've discovered we have, or we knew before we had the pandemic, was that even if IP works the way we predicted to, and if other non-IP components come together, we still cannot manufacture the resulting goods fast enough. So Canadian government is building its own infrastructure, pretty much what they decided they were lacking on as a form of preparedness, right? There are roles for the government that have little to do with IP, and they're more on the infrastructure side of things. But then again, there's a connection between IP and infrastructure. So those are some of the conversations, I think, that are important to have domestically, regionally, and internationally. And on a completely different note, because I've been playing with chat, I'm getting messages from the organizers telling me to tell Latif that there's a question in the Q&A.
Let's see. I see a question here that says, and I think this is the right one. Pfizer was sued for my good friend Josh Honor. Pfizer was sued for patent infringement. Had we not had a Bolar exception, then they might not have been able to develop their vaccine as quickly. Demonstrate the problem with exclusive rights here. Somebody want to tackle that? Yeah, go ahead, Paul.
I'm not sure I understand the actual question part of that, Professor Sarnoff. It seems to say if there was a Bolar exemption, if there was not a Bolar exemption, they might not have been able to develop the vaccine as quickly. I think that's probably right. There is the Bolar exemption written into the case law and into the statute, and we think it's great. But I don't understand what it means by just demonstrate the problem with exclusive rights. I don't know what that follow-up. Maybe you can follow up, Professor Sarnoff, and just or would they not develop it at all? Yeah, that's certainly a possibility. If that's, I think Anna, I think that's what you were saying, that there does need to be the economics, the patents follow the economics, or the IP follows the economics. That would be it there.
Yeah. I think what Josh's question reveals are some of the limitations of looking at the role and function and responsibility of IP solely from an economic perspective. If you interpret the exclusive rights in a very economically inflexible way, okay, without the Bolar exception, then you get backed into a corner. And I think that if we look at what this conversation has demonstrated is that, first of all, it is not incompatible with IP to look at IP from this perspective, right? And in fact, when we do look at IP from the perspective of, okay, what sort of social responsibilities can the IP system respond to, we end up with some fantastic collaborations, some fantastic advances without deconstructing the IP system. So in some respect, it's about perspective. It's about beginning from a particular vantage point, saying that this ought to be a part of it, recognizing that that there are social justice obligations as part of the work of the intellectual property regime. We only have a minute left, so let me just give each of you a few seconds to just jump in with the last comment. Maybe we'll go a minute over, but just any last thoughts that you have before we, because we could have done this for another hour, but last thoughts. Let's see, Karen.
I agree. Yeah, I agree. I think it's been a fascinating discussion, definitely for myself, and I hope for the audience as well. I feel like I've learned a lot, and like Taryn said, I also feel very inspired. And a lot of the conversation gets me thinking about, efforts to promote diversity, within the patent system, and what can law firms do, what can corporations do, how can they incentivize each other, and I think there's a lot that happens, with mentorship and programming, at the corporate level, and also, with law firms, ensuring that women and underrepresented groups are being cultivated to lead teams and being the lead inventor on teams, and just having those diversity numbers where corporations want to see diversity within law firms. I think there's a lot of opportunity there.
Excellent.
And thank you for a fascinating discussion.
Thank you. Paul, quick comment?
My only thank you all. It was a fascinating discussion as well. I absolutely agree with Karen. My only other statement is I think we've really successfully explored the macro situation. It's the micro situation which is much more difficult and really becomes part of.
Well, I was going to ask everybody else, but I think Adam is banging on the door and saying, you don't have to go home, but you can't stay here.
And unfortunately, I do have to interrupt. This is a wonderful discussion, a great panel, incredibly time sensitive, very relevant. I thank all the panelists for their contributions. You can now disperse amongst the other attendees and network at your leisure. And with that, we'll transition away. So, like I said, thanks to our panelists for a wonderful discussion. We will now be transitioning to a 15-minute virtual reception. Please feel free to move about the conference floor as if you would a live conference. Let's see, and once again, if you run into any issues, please contact our student ambassadors. They again were designated by the help desk next to their names, or you can contact me directly. In any event, I will see you back here in 15 minutes. Hello, everyone, and welcome back. Hopefully you had enough time to actually network with some people and maybe even meet some new individuals. We will now be transitioning into our third session, which is Functionality Designs, Trade Dress, and Copyright, and is moderated by Chris Karani, who you met previously. Chris is a shareholder at McAndrews Held in Malloy Limited Partnership. As a reminder he's on stage, good. You can join us up on stage. As a reminder to moderators and the panelists, please keep an eye out for participant questions in the Q&A tab. And in line with that, attendees, please feel free to pose any questions in the Q&A tab for the panelists to address. That's the best way to actually pose your questions rather than general chat. Chris, if you could make yourself visible, and we'll get started.
Thank you, Adam. Appreciate that. Again, this is Chris Karani. We are here now for the third session of today's conference. It's been a wonderful morning with some really interesting debate. We have some tough shoes to follow, or tough act to follow, I should say, but we certainly have assembled a panel here which is up to the task. We'll wait for, I see we have JP, David, and Professor Tushnet, and we'll have Perry, and we're just gonna, I'm sure Beth will be called up in a moment. Wonderful, we have the team assembled here. We are tasked with discussing the ever-present but ever-puzzling issue of what's loosely called functionality. And in large part, this was the impetus for today's Intersections in IP Congress to talk about these issues. There was so much discussion, as I know everybody up here quite well on the panel, but in conversations with everybody, you start talking about design patents, you start talking about trade dress, you start talking about copyright, and you're in these confines of a particular area of jurisprudence. And there is certain sort of accepted norms of how to proceed in each one of those. But in each one of those three IP rights, there is this notion of trying to wrangle with or tame functionally driven design or functionally driven appearance. When the nature of the rights that we'll be talking about in the context of trademark, we'll talk about trade dress for sort of product appearance, and also copyright in the more specific way with visual art and three-dimensional copyright, is how are those things dealt with? And so that's the general topic we're going to talk about. What we're going to do is start off with an opportunity for folks on the panel to give their opening remarks as to their thoughts on functionality and maybe some interesting topics. They're not in a particular order, but some of the key issues to think about, or just the interesting wrinkles in the law, questions that have percolated. So we'll start in reverse alphabetical order just to keep things funky. And we'll start first with Professor Rebecca Tushnet, Professor of Law at Harvard Law School. Rebecca, lead the way.
Okay, so hello, and so for me, functionality, uh-oh, I'm getting a little echo. Is anyone else hearing it? I'm not sure. Okay, looks like it's done. Thank you. So functionality for me is about the question of utility patent supremacy, right? So to what extent does utility patent dominate all the other doctrines, and also other questions of basically election or division of the jobs of the different, even if we don't think that utility patents are supreme, it might well be that each doctrine has its own proper lane. And the one thing that I think we should keep in mind is that there are dynamic effects on a system of allowing overlaps. So, you know, the thing that I often encounter the most is a copyright trademark overlap. And the more welcoming the system is of that, the more effort people will develop, will put into moving what was initially in one system to the other. So trying to get a trademark to extend the life of a copyright, trying to get a copyright to be able to send takedowns where you couldn't, just because somebody was talking about your product, right, and had a picture of your product, and getting access to the DMCA through claiming copyright. And so channeling is the general term for that, or even if there's no election, right? Since modern law has largely rejected the concept of election, but the dynamic effects of saying this field of law is for this purpose, and so we're going to encourage you through doctrine only to try and get the benefits of one. That is, I think, is the key sort of overall concept here.
Okay, so let's move next to my good friend Perry Sedman to the left of Rebecca on my screen. Good day, good morning, Perry.
Hi, Chris, and hi, everyone. Well, let's just jump into it. To me, the underlying rationale of the functionality doctrine is the same for all three forms of IP that we're discussing. And that rationale is to prevent the use of the particular IP to monopolize functional features that should only be monopolized with a utility patent. As Rebecca says, utility patent supremacy for functional features. But what you have now is a case law and statutory law that exists whereby the tests for functionality differ greatly from one form of IP to another. Something that is found functional, for example, in trade dress, could very easily be non-functional under design patent law. Just to review these tests briefly. In design patent law, design is considered functional if it is dictated solely by function. Alternate designs is the accepted way that one proves non-functionality, since the existence of alternate designs that perform the same function objectively and conclusively means that a claimed design does not monopolize functional features that are only monopolized with a utility patent. In trade dress law, you have a very different situation. The Supreme Court in Qualitex and Traffics said a design is functional if it is essential to the use or purpose of the article or affects the cost or quality of the article. On the other hand, you have the Morton-Norwich case, which is used by a lot of courts and by the trademark office. And it says that alternate designs is only one factor to evaluate functionality. Other factors are the existence of a utility patent that discloses utilitarian advantages of the design, advertising by the applicant that touts the utilitarian advantages of the design, and whether the design results from a comparatively simple or inexpensive method of manufacture. To me, the Supreme Court's criteria could be successfully argued to prove functionality by any first-year law student. And under Morton-Norwich, the four criteria taken together, to me, have little to do with preventing the trade dress as a whole from monopolizing utilitarian features, again, that should only be monopolized by a utility patent. Now, moving to copyright. In order to be protectable, the functional and aesthetic features of a useful article must be separable under the confusing and vague Supreme Court standard of stare athletica. Now, very interestingly, in analyzing originality, which is being used more and more in useful article analysis, the Copyright Office compendium says that they will not consider possible design alternatives that the author may have considered when they created the work. To me, again, whether separable or not, if design alternative exists, then a copyright on the entire design ensures that it does not monopolize that which should only be monopolized by a utility patent, that old supremacy doctrine. So what I'd like our panel to explore is whether having different tests for assessing functionality across these three forms of IP makes sense. That's the law. Does it make sense? My position, obviously, is that the design patent standard, dictated solely by function, should be adopted as the functionality test across all three IP regimes. And I'm looking forward to this conversation.
Thank you, Perry. A lot there. We're going to try to synthesize this as we go along, and I know we'll have some retorts. Next, moving to, let's see, in alphabetical order, David Girk, Acting Senior Patent Counsel of the Office of Policy and International Affairs at the U.S. Patent and Trademark Office. And Perry, I didn't get to mention your title, but at Perry Sedman LLC, but Perry, I guess, goes in this realm, doesn't need introduction. David, please, your opening remarks.
Thank you, Chris, and thank you to you and Professor Lim and Adam and the UIC John Marshall Law School for this opportunity to speak here. These conferences are obviously very high regarded, so it's just an honor to be here with all of you and this distinguished panel today. I'll quickly turn to substance, and I'd like to maybe just start by just in this opening remarks period highlighting 2 or 3 points or lenses that I think might be a good way to think through our discussion today. And some of the Perry and Professor Tushnet touched on the first thing I'm going to talk about, and that is to what extent should all these various IP rights be overlapping, or should they stay in their own lane? And I think there may be varying views on that point. And if you think of a Venn diagram, maybe to what extent should the circles of protection overlap? A lot, none, just let it fall where it may be. To some extent, I think U.S. law seems to suggest we evaluate each of these rights for the most part on their own criteria. There's some overlap, and except for some maybe specific instances, we just evaluate each according to their criteria and eligibility requirements. And there may be instances where applicants or innovators may have protection in design patent and trade dress, or design patent and copyright. So one thing take away is, and I won't get into international, I know we may get into international things later, there are other places where perhaps there's expressed delineation between some of these rights by hard law that says if you get one, you can't get the other. Also, I think as we prepped for this, I was reminded of the fact that when you look through Professor Sedman mentioned this when he was going through some of the criteria, when he was talking about the terms, actually for design patents, the word functionality, that's not in Title 35. The word that's used is ornamentality, and that's the threshold criteria as compared to trade dress and copyright protection, where, for example, in trade dress, protection is prohibited where the subject matter as a whole is functional, or in copyright, works shall include works of artistic craftsmanship insofar as their form, but not their mechanical or utilitarian aspects are concerned. And certainly I'm not a trade dress or copyright expert, but pointing to that, it seems that functionality is dealt with a little bit more directly by those two, whereas functionality has arisen in the design space as sort of the counter to the criteria of ornamentality. That how do you know if it's ornamental or not? Well, you kind of look, is it just functional? Then it's not ornamental. So I think there'll probably be some discussion maybe on some of those points as we go today. And then finally, I think each of these IP rights do sort of serve different purposes. They have different criteria. And I think in my head, at least, I think that helps define the different flavors of functionality, and to what extent I almost think of in football, like a arm, keep your arm away from the functionality, a stiff arm, if you will. I think there's variance in how close we were allowed to get in this functionality concept across the different these IP rights, with designs maybe being allowing the closest because of the subject matter dealing with designs and ornamental aspects for articles of manufacture and seemingly functional or utilitarian products. So with that, I'll stop. I don't want to take too much time here on these remarks. And again, thanks for the opportunity to be here. Look forward to the discussion.
Excellent. Thank you, David. We're going to get into many of those topics. Next, going to move to Beth Farrell, who is a partner at Finnegan, Henderson, Faribault, Garrett, and Dunner, and certainly somebody who has long practiced in the field here with respect to design rights. I've had the pleasure to team up with her on a lot of committees over the years. Beth, your opening remarks.
Thanks, Chris. For including me. This is always great to get together with folks and have these kind of discussions, because I feel like in my day-to-day life, I don't end up talking about these topics as much as I'd like to. So I guess what I'd like to talk about is, and I find that the topics that others have raised are really interesting. I kind of approach this a little bit from a more practical standpoint. And I'm not saying others aren't practical, but you know, I've been in situations where you're trying to apply these various tests, and mostly what I do is design, but some trade dress as well, where you're trying to apply these tests in a court situation, you know, to a judge, potentially to a jury. And I find that what is really important is that we have tests that are easy to understand and easy to apply. And I recognize that from the perspective of those who are sort of steeped in the history of this, that maybe the tests that we have are not completely doctrinally consistent, maybe, I don't know, or there may be something that happened 100 years ago that suggests maybe we should have a different test. But at the end of the day, I like things that you can explain, and I like things on a couple fronts. One, I like that I can explain them to a judge. What we find in most of these patent cases is that some judges have very little experience with utility patents, but then they have even less experience with design. And so we're trying to, you know, say, hey, judge, you sort of know about utility, then let's try to explain design to you, but it's a little different. And so having really clear tests, I think, is really important. I think the other piece of this is that helps a lot when you are counseling clients, whether they own design patents or whether they're accused of infringement. Having clear tests where you can say, listen, I see this design patent, I understand this, how this is going to be interpreted by the court, and let me give you an idea of whether you have a strong case, or if you're on the other side, you know, should you be worried about this? Do you need to settle, or is this one you should fight? But when we have a lot of inconsistency and you know, language in different cases that kind of seems to go in completely different directions, it makes it really hard to counsel people on both sides. And if we want to have an efficient system where people can resolve their differences, hopefully without going, you know, all the way to trial, it's always very helpful if we have clear guidance. The other thing that I think is important is that we recognize the value of good industrial design to our economy. I mean, I think there are lots of products that are sold, they have wonderful functional features, but they are really, the driver of them is that they look good. And, you know, I feel like if we want the American economy to do well in the future, we need to protect those things that people have invested in. And if we find that our IP is not doing that, and this could be true of lots of different things. I mean, I personally, being the mom of twins, found the case in which the blood test to decide whether or not your children have you know, some sort of genetic problem, when they said that wasn't patentable, I was like, I'm sorry, I went through the old version. This seems like an amazing improvement to me. How come we can't protect this? And I feel the same way about design. I feel like if someone's investing a lot in the design and that's helping them sell their product, that we should, as a system, figure out a way to protect that, whether it's virtual reality or augmented reality or something that moves in the future. I don't think that's a reason that we shouldn't protect things just because we don't really know how to do it, or it requires us to do some creative thinking. Because I think that that's a really important thing to keep in mind, is that in my mind, we need the IP system to be in service of a developing economy and not something that kind of holds us back. Thanks, Chris.
All right, thank you, Beth, and I appreciate the desire for some pragmatism in the conversation. Also, I think that's also a part of the equation. Let's move next to JP Ciardulo, partner at Foley and Lardner, and someone who has been very active with respect to trade dress litigations, and specifically wrestling for a long time with the issue of functionality in that realm. And a lot of this going on today was sort of bringing these different voices of people I have a lot of contact with and hearing what's going on in their worlds, and then trying to connect these, because different approaches for each one of those. JP, please, some of your thoughts on this functionality issue and perhaps how it bleeds, and hearing from these other branches of IP.
Sure, and I also I want to thank you, Chris, and the rest of the organizers for inviting me to this. It really is a privilege speaking here today with you folks, and I do think that this is, I mean, as has been said, in my daily practice, I don't normally get to have these kind of conversations, and even in some of our preparation sessions, I found that it was very useful for thinking through issues and coming up with new ideas. I think this is very valuable. And as Chris said, I come at this from the point of view of someone who's done a lot of litigation in trade dress law specifically. I wouldn't purport to speak as much to design patents and copyright, at least in this context. But I can tell you, in the trade dress litigation world, I also try to take a pragmatic approach. A problem that I've identified in the law and the way it's practiced is what I would say would be too much of a reliance on per se rules that are divorced from the particular facts of a case and the particular marketplace that's at issue, and also sometimes just a reliance too much on using words to try to articulate tests and designs and descriptions of things, when this is really about visual arts and something that people understand more on a level of something that's visual. In my view, just based on my own practice, what the inquiry is really just about, at least in the trade dress context, is fair competition. And just as there is a spectrum of distinctiveness for word marks, what the concept that's formed in my mind is that there is a spectrum of functionality. And at one end are basically things you normally think of that should be protected by utility patents. If there's something that's just really a mechanical widget, there's not that many other ways of doing it. You can't really stylize it in some way. It's not really fair that somebody would have a perpetual effective utility patent monopoly on that. At the other far end of the spectrum would be purely arbitrary designs that aren't dictated by their function, that are more sculptural, and no one really has any business copying that unless they're trying to trade off a brand. And in the middle is this spectrum of things that have varying degrees of stylization. What I would say is that there's a functional bones to it. So think of like the frame of a car, but they may have different sort of flesh on the bones, a skin or a stylization. So what's the body styling on the car? Like a Volkswagen Beetle has many of the same functional attributes as a BMW Mini, but they're sufficiently stylized enough that people can tell them apart as brands. Even though if you were to describe them in words, it almost sound like the same car and accomplishing the same functional objectives. And the goal in sort of assessing the fair competition would be, is it fair that one company would have a monopoly on this particular design? Inversely, is it fair that the defendant should be able to make exact or near exact copies of it? And in terms of how you would assess that, to me, it's essential to be looking at alternative designs. There's sort of no way around that you're implicitly considering alternative designs, and no matter what you're doing with this. And the assessment to me boils down to, what are the scope of equally efficient, equally functional alternative designs that are differently stylized? If there's a lot, to me, then you're dealing with something that it shouldn't be any problem that the company monopolized one of those many different equally functional designs. If there's only a few, then it's unfair that one company would monopolize it. And I'd say just two other things in terms of assessing that. Look at what is the scope of what the plaintiff's trying to protect. Excuse me. If the plaintiff is seeking very broad penumbra of what they would deem to be infringing, well, now they may be seeking too much. If they're basically just trying to prevent, like just don't exactly copy my product, I think you look at that differently. You also, I think, need to look at what's the defendant doing. We've had cases where the defendant's kind of, I would say, invoking the functionality doctrine in a vacuum, where there's not really any standing for it. So, for example, if they copy, the look of a product, but they're not utilizing the purported functions, to me, I'd say they don't have Article 3 standing to be invoking such a defense. It's just that they're almost disproving why they need to invoke it, because they were able to copy the look without the function. So these are just some of the thoughts that I apply to my cases. And I do think that it fits within the framework of some of the other panels have spoken about.
Thank you, JP. I think one of the interesting things of going through that is we've heard about, you know, the desire to want to look at this pragmatically, but it seems like we're hearing a whole array of different policy considerations. And we have two policy considerations I want to sort of tease out today. One being, what are the policy considerations for the rights that we're talking about here? Design patents, trade dress rights, copyrights, and establishing that, because those are the goals that we're trying to seek right there. And then the next is when we talk about this screen or filter about functionality, what is each one of those, what is the policy between each one of those? We've sort of heard Perry state that the policy for the screen is the same itself, but I don't believe that the policy for each one of those rights is the same. I mean, Dave, you talked about the overlapping aspect of all of these, but we do have why would we have three if we could have one if they're all doing the same thing? JP has talked a lot about competition, but the rootings of these. As part of this and working with the team, and it is available in the course materials, there's a nifty chart that sort of tries to organize all of these between the design patents, trade dress, and copyrights, and then going through the policy considerations for each, the constitutional rootings, the term for each right, the applicable doctrines and tests, the key cases related to functionality, and then the key statutory provisions. It's dizzying when you try to talk about each one of those. So we've got people who swim in these waters quite often, and just some comments about the policy objectives of these various IP rights and what's trying to be achieved. I'll start with Beth and then to Dave. If you guys can talk about the design patent side, what is your sort of understanding as to what are the main policy goals that's trying to be achieved by those rights? In sort of short order, then we'll move to the next con, then we're going to talk a bit about the functionality policy.
Sure. So, I mean, I think that generally speaking, design patents are intended to protect functional articles, right? So this is, I think, how they differ significantly from copyright in that it's okay that the underlying article has a function. I mean, the Federal Circuit said that's actually a prerequisite. And at least practically speaking, it does seem to, design patents do seem to go hand in hand with utility patents in that a lot of times a new product is going to have a new look as well as have some sort of new functionality. And I think what we see is that sometimes, and maybe this comes out of the way that they are procured, right? So like, you know, if you've taken the patent bar, then you can apply for utility patents and you can also apply for design patents. So sometimes I wonder whether that's why sometimes you see these design patents that are an attempt to protect something that probably would be better protected by a utility patent. And I think we have some of these tests to try to keep that from happening. But, you know, I often sometimes wonder if we had more of a design rights system that was not so closely related to patents, whether we would have as much issue with this type of overlap.
Okay.
But I'm curious to hear what Dave thinks.
Dave, and then again, this is a conversation, so if others have follow-up, please chime in too. Dave.
Yeah, thanks. I agree with Beth. Raised some good points. I think from a policy as to why do we have design protection, you know, there's always the two theories, and I think JP talked about one of them, the equitable side of things. You know, what's equitable? Same kind of concept in designs, but a lot of times the U.S. is driven, at least if I remember back to law school or even just you know, a lot of writings on these things is really the economic incentive and what's gonna, as Beth said, encourage people to think instead of just everybody creates a square phone or a car that, you know, rolls fine. They add these features that make it fun to be human and as part of that. So there is that spin, but it's in the utilitarian context. So I think that's the driver. A lot of times people also talk about design patents or industrial design more broadly globally as sort of a gap IP right. Although when you think about it, if you look at the Paris Convention, which is all the way back to the 1800s, we're already talking about industrial design there. So it's been around a long time to sort of be a gap provision. And there is, I think it's been recognized for a long time that that's an important area and that needs that IP area. And then the last comment I'll say is kind of just to play on something Beth said. I think one of the things that's come up in design patent space where we've gotten into these functionality issues is really a result of either a mistake or, I don't want to say abuse, but trying to push too far on some of these things, where that's where these functional, like Beth said, someone's trying to use design protection where it's clearly they're not trying to protect the ornamentality, they're trying to carve out a functionality space. And you know, if you're well versed in this area, you might be able to simply bat it away. But design patent expertise, particularly in the judiciary, is not always you know, forefront. And so these concepts can be very complex, and skilled litigators can make excellent cases that can convince, and you can get some bad precedents. So I think those are some of the winds blowing in these policy spaces.
Okay. So, you know, out of that sort of synthesizing, I'm hearing a bit about this sort of utilitarian incentivizing a particular type of conduct as being one of the policy goals, but I'm also hearing this sort of equitable sense that you know, it's almost a Lockean type of theory that it's the sweat of the brow. Someone should be able to co-op after your hard work or the things that are your own particular creations. Anything from let's lead to the other two IP rights to see if we hear some of the same things, and then try to hear some comparison between them. With respect to, you know, JP, you've already talked a bit about the rooting here. It takes its rooting in the Commerce Clause, the ability to have trade mark protection with trade dress falls underneath. Is there a policy to try to create new designs? Is that one of the functions of functions? Is that one of the goals, driving goals of trade dress law?
Well, I think it may be a little bit like what Beth had said, that, you know, we want to be able to encourage companies to protect pretty designs, things that are, you know, take something that may have some functional bones to it and then put a stylization on that is ultimately a brand identifier. I can speak to this maybe by doing contrasting examples of cases. The seminal Supreme Court case in trade dress functionality is traffics. To me, that's at the far end of this, I call the spectrum of functionality, where it was literally just a square road sign on two springs, and the springs allowing it to bend in the wind. I mean, there's not that many other ways you're going to do that. To try to protect that as trade dress, to me, seems like obviously a bridge too far. To contrast that and to show maybe, you know, some of the policy motivations, a case that we were handling for the furniture company Herman Miller involved a very famous chair called the Eames Aluminum Group chair. There were utility patents filed on it back in the 60s, and the utility patents were directed to a means for mounting a fabric or upholstery between two side rails that were separated by a bar that held them apart, held the upholstery taut. And the arguments from the defendant in the case were, oh, well, this whole thing's just functional. Look, it's in the utility patent. And our position was, well, no, the utility patent is claiming the bones. We're claiming the stylization that's been put on that. Within those constraints of the utility patent of, you know, separating upholstery with a couple bars, you could stylize that a whole bunch of different ways. And we had a particular stylization, a particular incarnation of that we wanted to protect, that we felt had become highly recognizable in the marketplace, widely seen in movies, television, and popular culture. And what helped prove the point was that there were other companies, including the defendant, that sold other chairs that used the same underlying bones of structure that had been claimed in the utility patent, but the stylization of the skin on the bones was different. So we tried to emphasize in the case, look, you just sell those, you know, that's fine. And by defining the universe of what we were trying to protect and the scope of it, and not trying to say we're trying to protect everything, I think helped it and drove this policy goal of we're trying to carve out our brand, something that consumers recognize visually. We don't think that they're going to be confused by this other one. Go ahead and sell it. You can use the functions through that. And, you know, we're not trying to have a perpetual patent monopoly.
So you know, from that, I certainly get the point that you know, you're trying to advance the brand. We're trying to eliminate this confusion in the marketplace, but it doesn't seem to be the place of trade dress law that we're trying, just in the same way we're not trying to create new words or new trademarks. That's not what we're trying to, you know, churn out. It's that you're trying to, it's rooted in commerce and trying to eliminate this confusion in the marketplace. And you're just saying you could go to a different design, you don't have to land on ours. But I saw Rebecca shaking her head over there when we were talking about sort of the policy underpinnings, and I'd like to just get some thoughts from her as to maybe this juxtaposition about, you know, design patents and trade dress, and why the heck we have each of those.
Yeah, so what I was shaking my head was at the concept of trademark as incentive. So the Europeans occasionally say this. I've never understood so they seem to mean that you know, if you can get trademark protection, then it helps you introduce even more SKUs of your product. And I've never even understood that part, but that also doesn't seem to me, you know, innovation in any particular sense. Even if you have like 5 different flavors of Crest and you register, you know, a mark for each one, it's not really what trademark is for, which is, you know, helping consumers make decisions in the market. And I think trademark and copyright aren't just appendages to the utility patent system. They have their own justifications, consumer meaning and expressive creativity, respectively. And functionality is a reason that protection under those justifications isn't a good idea. So, for example, when a decision is made for, you know, for functional reasons, it's not made for creative reasons. Like, it takes that feature out of the scope of copyright. One thing, though, that I think we are struggling with is that modern copyright almost completely overlaps design patent. Maybe it doesn't kick in when form and function are united, but there actually aren't that many designs that really truly unite form and function. Maybe the classic Esquire lamp, right? Modernist lamp. Would do it, but one of the struggles that we have with design patent is it doesn't actually seem to have much of a separate role in the system compared to copyright, especially after Star Athletica. One of the things that I do want to caution about is when the infringement tests are, as they are in copyright and trademark, extremely flexible. Right? There's lots of different things that can infringe a trademark, lots of different things that can infringe a copyright because there's a derivative works right. So when their scope is flexible, as it is with both of these doctrines, it actually creates substantially more risk to competition than when there's a fairly rigid infringement test, because you know, Herman Miller may pursue its rights with great circumspection, but frankly, the average competitor thinks that the words unfair competition are redundant and are willing to assert you know, trade dress rights in particular in things like, well, I was the first one who had the idea to make greeting cards that were, you know, photorealistic images that were cut out around the edge of the image. And so now I own that. That's my trade dress. And functionality has to be an expansive concept to fight against that, which is why I end up disagreeing with Perry that design patent has it right, even though I agree that it's a bad idea to have such multiple tests.
So on that,
Chris, can I say something real quick?
Yep,
here?
please.
So I actually don't think that creativity and functional are like opposites. I think there's lots of ways that you can be creative in coming up with something that's functional. And then the other thing that you said,
sorry, I want to answer that, but
sure, go ahead.
Well, so right, so there are actually lots of ways to be creative, right? Serena Williams is an incredibly creative player. Her play is not the subject matter of copyright. So expression is, and expression has to be distinguished from other things that people do. But I absolutely agree, that these choices can be creative in the broad sense.
And then on the point about there being no separate role for design patent in the system, I guess for useful articles, I mean, I know about Star Athletica, but I feel like for useful articles, it is so much easier from a practical standpoint and from a business person's standpoint to deal with design patents than it is copyright. I mean, except for the bar, right, which is the one-year bar, which is why people sometimes end up in a place they don't really want to be. I feel like that's, I guess I can see from some perspectives how that you might think that, but to me, they seem very different in the way that you actually apply for them and use them in the practicality of that.
Yeah. I would just follow on that. Then we're going to let Perry respond. But the Copyright Office and I would say the jurisprudence certainly isn't that liberal with respect to things that are design patented that they can also be copyrighted. I would venture to say that, and having spent a whole career looking at design patents, that probably less than 10% of what's patented on the official Gazette would actually pass muster underneath copyright jurisprudence. It's just not that permissive. And perhaps what needs to be happen there is that, maybe copyright law needs to be scaled back to its more rightful place, rather than trying to bleed over into applied art and other types of industrial designs. But a little bit of channeling function, I suppose, on that. Perry, I think you're on mute. That's the only way we can get Perry to stop talking. I think it's maybe your local.
Right.
There you go.
Well,
great.
I just want to add one thing that I don't want to be overlooked. JP touched on this. Chris touched on this. It has to do with the idea of fairness and the idea of competition, which Rebecca's been talking about. In my experience, in design patents especially, what you have is you have competition, but it's not fair. There are many, many competitors who lie in wait, literally, waiting to see what is successful on the marketplace. In other words, a design that has been invested in and promoted and focus grouped, and all kinds of money has been sunk into it. And these competitors who are, lazy, copy the design as closely as they think they can get away with. And, you hear the word copycat, you hear the word knockoff, and I just don't think we should lose fact that these competitors could go to the same trouble that the originators of these designs did, the protected designs, and sit down, hire a designer, and do their own design that is clearly different from the protected design, rather than hanging on the coattails. And I think that is unfair competition.
Okay.
Why do you think design patents end?
I'm sorry?
Well, when the design patent expires, what was unfair becomes fair. Why?
Well, because the government has made this deal with patent holders that at the end of the term of either a design patent or a utility patent, we'll give you monopoly during the term, and when it's over, it's over. It's in the public domain. That's why.
Well,
Doesn't it end because it's a property right? I was just going to say, and the terms are varied just because, the balancing in determining granting rights and public and, the rights owner, the term has played into that. So I don't know if the suggestion was copyright goes forever or trademark. I guess trademarks is the one that seemingly goes forever, but it was deemed because you're still using it and it's of a different nature. But the point I just wanted to make is it's simply a property right, and that's the balancing. It takes it into account.
Yeah, and I don't want this to delve into right to copy doctrine and those type of Nabisco shredded wheat and all those types of cases, because but the term does figure into this when we're going to be talking about these various tests, and that's what I want to move to here is the various tests used through each one of these regimes. Professor Tushnet brought up a very interesting point about the difference of scope and flexibility and the test for infringement on each one of these. And this is, about a few weeks ago, many of us convened there was a conference at UC Berkeley. Professor Manel has issued a very important and lengthy paper on the issue of design patents just in general. He refers to it as a muddle. Some of us wouldn't go that far, but certainly room for improvement. But in that, it's thinking about these different rights, and on copyright law and even trade dress, whether it's unregistered or not, what you don't have that you do have in design patents is you have a claim. in design patents, you have a claim that has been examined by a government agency, presumed to have competence in what they're doing, and you have a very defined scope that's set forth there. In contrast, when you show up to the doors of an unregistered trade dress case underneath the Lanham Act, you file your complaint, and that's sort of the first time you're setting forth what you think it is. So the screening function, the filter function, comes much later. It is left upon the court to do. So I want to hear about the different tests that are set forth there and how maybe this scope issue might fit into that. And I'll hand over to Rebecca, and then Perry, I know you have some things to say on this.
Right. So, right. And I do come to this from the copyright and trademark side. And the functionality, so I wouldn't even say there is a functionality test so much in copyright. We've just done it in sort of negative space, which I think is a pretty significant problem. So in theory, you're supposed to filter out the parts of the claimed work that are dictated by outside factors that are not expressive choices, although they may well be choices. So a classic example would be anything that's required to physically make the thing. So the fact that there are lines from the mold that the thing comes out of would not ordinarily be subject to copyright protection if they just emerge from the fact of the mold. And with trademark, we've done a little more elaborate of a job. And I think it recognizes that there are lots of non-source indicating reasons to do things. And in fact, because of trademark's function, that is, trademark itself is supposed to assist consumer understanding. When something is in a product for reasons other than that, so they make the product more attractive regardless of who's making it, right? So sometimes I think of it as a but-for causation test. Like if the defendant had just made this thing from the beginning, would it be equally appealing? Or is it appealing, or is its appeal because of the plaintiff's reputation? And that can actually help deal with things that aren't physically functional, but are things that are functional in the marketplace. For example, a heart-shaped candy box is a classic example, because for Valentine's Day, people want heart-shaped candy boxes. And if we didn't have a convention of having a heart shape as signifying love, they wouldn't want it, but that doesn't mean that anybody should have a monopoly over it. So the functionality test in trademark, I think, is actually recognizes that there can be different kinds of functionality, including non-utility patent functionality, that are opposite or opposed to what we want trademark to actually be doing.
So we're going to get to the aesthetic functionality or aspects of that. I want to take well, you have the heart shape, but let me just give the simple hypothetical that we've seen, and then we'll get into the response to it, because you've mentioned this whole part about filtration and filtering aspects out. And I will say that from folks who come more from a design patent bent, or from a design patent bent, where you're coming from a claim aspect, whether it's design patent or utility patent, there is the sanctity of the claim. There is no independent rights in any claim elements. If I have a utility patent claim on an automobile and one of the claim elements is a wheel, nobody thinks you have rights in the wheel, or there's any monopoly concern whatsoever about that. Your right in that element is only in combination with the amalgam. So where I think there's created a lot of tension here is that on the design patent side is this idea of what to do with a functional feature that is claimed as the overall part of the whole. So I'll give the example and throw it over to the team. I've used it in my book. It's if you have a key, just like for opening a car or a house, and on the top of the key, the handle is let's just say an ornamental monkey head. And then there's the key blade. Everything is in solid lines. It would seem that what Rebecca was saying is that you would divorce the key blade portion as part of the filtration process, maybe other things. Throwing it over to Perry and Beth, and then I want to hear from JP here too, from the trade dress side. How would that be handled, this idea of individual elements of the whole in the design patent context?
Well, since your hypothetical stated that everything is in solid lines, even the key blade has an ornamental appearance. It's not just that it performs a function, it's that it looks a certain way. And that way may narrow the overall design patent claim, but it doesn't eliminate the blade from the analysis.
Does it provide you a monopoly right in the blade itself? Let's be clear on that.
No, of course not.
Okay.
And you know,
why not? Why not?
Well, because as you well know, it's the claim design as a whole that needs to be substantially the same as the accused design in order to find infringement. And that monkey head is a significant, shall we say, ornamental element. Although I would think in a trade dress case, somebody will argue, oh, no, that monkey head is functional because you have to grip it between your thumb and your finger in order to hold it and in order to turn it into a lock. Under trade dress law, honestly, everything is functional. And I've seen fights waged in court that suppose just that. And the bar for overcoming functionality in trade dress law is like this. It's almost impossible to, in my experience, to have a trade dress found non-functional. Okay, so back to design patents.
Okay, so we're going through with the monkey key example, and we've sort of established that on the design patent side, at least, that there is no concern. Well, if anybody wants to debate this point, but the idea that somehow you have rights and independent rights in constituent claimed elements of a design patent. In other words, by issuing the design patent with the entire key, do you somehow have, is there any monopoly concern regarding the key blade? Does anybody want to take that position?
I mean, it depends. Honestly, I think part of it depends on prior art, right? So if you look at, Egyptian goddess and what's happened since then, you can clearly at least consider the prior art in figuring out what counts as close enough to infringe. But, suppose it was a unique key cut, then I do think that the doctrine at least faces a problem, although I share the intuition that a court would not want to grant a monopoly over the key cut.
Okay, so let's flip it around here. What if you did have only claimed the key blade, and you got it out the top? And we actually have a case on this. But what would be the outcome there, and why would that be the case? What's the concern? If the claim was directed, and let's just assume for the moment that it is purely dictated by function, that key blade, which is, when you see it on a design patent, I see it on the face of it, and it's just a key blade. You don't know that it's to matingly engage a particular keyhole. It could be a toy key. It could be a key that you're just going to wear as a locket around your neck. It seems like there's a lot of going off reservation, off the road here about what a design patent does and doesn't do as far as its function. Any thoughts on that as far as what you claim? So in other words, in one example, if you claim just the head, is there an ornamental problem? If you just claim the blade, if you claim the entire construct?
So what's is it a key? Is it a locket, right? So the other thing is, it has to be designed for, right? Mm-hmm. So I don't think you could do it freestanding, and I don't think you could do it for a key, but I actually think you could do it for jewelry. I don't think there's a problem with that because it doesn't trigger a functionality problem. But that equally means we have to be really prepared to say, and you can't assert it against anybody who's actually using it as a key.
Okay, all right. It's an interesting point, another unresolved question about are design patents product specific. There's a recent case, but it probably doesn't answer everything about that. So on the filtration issue, let's hear about how it might be handled in trade dress law. If it was, let's just assume you have a very distinctive key. Everybody wants to buy this monkey key. It has acquired distinctiveness. It's not debatable. When it comes to the comparison with the accused product, would that presence of that key blade be considered in the analysis?
Well, I think that the way I look at this, just pragmatically, would be the sort of case-by-case assessment, and you'd have to, present it based on what you thought the consumer's impression of this thing was, and and again, sort of, what sort of range of alternatives might exist. I think that if you may argue sort of implicitly that consumers kind of ignore the physical key portion of it. In other words, the monkey stands out so much that they kind of don't pay attention to the rest of it. I mean, they pay attention to it in the sense that they're aware that it is a key, but beyond that, it's not registering a consumer perception. So you can maybe fairly focus just on the monkey aspect, which to me, I might say, in principle, I don't know why anyone else has any competitive need to use a monkey on a key. If you actually, in your hypothetical, prove that consumers do in fact recognize this as a brand, I don't see why they shouldn't be able to use the monkey key brand. They're not damaging society by monopolizing that. And take a look, if somebody makes a different looking monkey, I'd say they can use that. I think this concept of the severability, and can you kind of excise out certain elements, I've seen it come up in two different ways. One of it is the one you're describing with the key. Another example I was giving the other day when we were talking was, like the headlights on the Jeep. There's like the two circles and there's the vertical grille. And I would think of these features as being things that stand out so much on their own that no matter what else you attach them to, that's the rest of the product, you could strongly invoke that it must belong to that brand. So take a type of style of car that Jeep does not make. If I saw, like a sports car on the street, but it had those headlights in the grille, I might think, maybe Jeep's making sports cars now. And it seems like you kind of fairly excise out that element for an analysis. The other way that I see this come up is, for example, there's a case that we're working on that involved, the shape of like a container, and the location of a certain compartment in the container was in a certain place for certain functional reasons. I could see someone make a sort of superficial argument that, oh, well, because that compartment, has this functional purpose, you would sort of divorce it from the design, and maybe that would affect your analysis. I would look at it and say, well, no, all you really need to do there is say the fact of it being in that location is not something that would make it protectable. But if it has a certain stylization, perhaps it is.
Okay. So JP, you bring up, it's a fair point that no design feature, if you've been around design, no design feature exists in the abstract. Every design feature has a spatial relationship to other features in there. And so, for instance, in the monkey key example, if you eliminate the key blade, you've now eliminated the aspect ratio of the size of the key head to the key blade. You've eliminated any type of spatial relationships or orientation with respect to the key blade. So this idea of divorcing out an element, you end up creating this broad generic claim. And I think this is probably a really fundamental difference between how the design patent side would treat this and the trade dress or copyright side, is you end up eliminating all of the underpinnings of the examination process to begin with. If you want to think about this through utility patent speak, nobody examined or granted just element C. It was only in combination with A, B, and C. So when we start ad hoc, post hoc, start hacking off elements, you end up with something that doesn't resemble that which was granted in the first place. And what you end up doing, as much as people are trying to rein in these design patents, they end up broadening the claims far beyond that whichever was even considered by the inventor. So there's really serious consequences to doing this type of, maybe the guise of filtration, in particularly the design patent context, where there is an effort to try to have a claim. Now, I do know, David.
Yeah, Chris, one thing that's kind of related to that, I think we don't do that for trade dress, right? Like we wouldn't let someone identify a trade dress and then come along and say, well, now we're going to take out these functional pieces because that doesn't make sense, right? I mean, I feel like this is something that judges like to do, this idea under Richardson that you're going to exclude the functional features and somehow not end up with a Franken claim or something kind of really weird. I feel like, in my mind, the time to make that determination is during the examination process, because then I don't think examiners do this, but I would be curious if examiners said, listen, you have this functional piece here. I mean, I think there's an argument Perry would probably make, which is that the functional piece has an ornamental quality, and so we don't need to get rid of it. But it seems to me like figuring out whether something's functional is something we should do at the examination stage before we have the right and we have the presumption of validity and all of that.
Interesting.
Well, but
point.
this is, it's got to be done sometime, right? Because otherwise the scope will just continue expanding. And if the examiner isn't doing it, the court has to do it.
But the problem
Why?
is
I have a question. Why does it have to be done?
Yeah,
kind of coming back to the point.
Agree with that.
Here, the point I made at the beginning is Section 171 doesn't say functionality anyplace. It says ornamental. And so functional, the argument being, if it's only functional, there's no ornamentality. As soon as you have ornamentality, theoretically, you've satisfied Section 171.
Right, but to figure out what infringes, and I think the easiest way to do this might be with prior art, right? So, imagine, a 3-element design. Each element has appeared in the prior art, so the uniqueness, the novelty is in the combination, right? And then someone copies the prior art. The patentee brings an infringement claim. And the answer has to be, no, you only own the combination, right? And so we're always, even if we didn't have a functionality doctrine at all, we would have to do that project of figuring out what it is.
What does that have to do with functionality? Why isn't that just a question of ordinary observer in light of the prior art?
Well,
why doesn't functionality come in at all in that?
My point is that this task is not unique to functionality. Right. So we're going to have to do it. And then the questions are, what are the justifications for doing it?
So on that point, because I think it actually proves the whole reason of why you don't do this. If we have, like your example, the design is a combination of A, B, and C, but A is found in the prior art, B is found in the prior art, C is found in the prior art. There is no effort, ad hoc, post hoc, to go and eliminate these elements. Because we know that the only right that's being provided is in the combination. So there is no effort to try to hunt down and filter out these old features. The right is only, the right that's being granted is in the whole. So on the key example, even if the key blade, one of the 2 elements, is purely functional, its combination with the ornamental key head makes the entire construct something that is ornamental. So again, there doesn't, the only right is for the whole. So why, what is all the concern about hunting down and eliminating elements?
So this is so I think what's going on is that there are actually 2 alternatives. So you're talking about where we're going to have super constrained scope, which I think is right. But it doesn't actually answer questions that do come up with other design patents, like the one where they've dotted out the monkey head, right? We're still going to have to figure out whether the key blade alone can be subject to design patent protection. So we're still going to need a doctrine there, but I think you're absolutely right with respect to the full design.
Okay, so that's interesting because I think that is precisely, the article that I had submitted there for the Berkeley conference was called All or Nothing at All. A shout out to Frank Sinatra. And the thing is that the functionality doctrine, if the key blade is claimed, and someone's here has a question about partial design, and that's all that's claimed, yes, then that's dictated solely by function, and that's thrown out. But once the element is combined with other elements, you look at the entire whole. David, because I want to give time, we're going to have some questions here at 11:55, so we've got 5 minutes, but I wanted to ask about how this was handled on the international front, because I think it sort of helps inform some of this. I'll note that in the system here. And there's a lot about this filtration. In the 171, it talks about whoever invents any new, original, and ornamental design. Doesn't say anything about functional, but also doesn't say anything about features of a design. In TRIPS, you mentioned TRIPS earlier. Members may provide that such protection shall not extend to designs dictated essentially. It doesn't say design features. When you go, this idea of trying to hunt down features, what has been sort of the experience on the international front? I know you do a lot of work at WIPO as far as being an attaché and delegate for the USPTO. What's your sense of how this is being? Are they aligned with us? Is there more discord? Is there various approaches?
Thanks, Chris. And you're obviously an expert, and your book covers a lot of this, so I feel funny talking about this. You could probably cover it just as well. But one thing to highlight, first off, you mentioned TRIPS. One thing to note is that was a may provision. So it's interesting to note that even this functional concept, you theoretically under TRIPS wouldn't have to require that. It says members may provide that protection, may not extend. But that's just one thing to note. I think as a broad scope, there's really two flavors. So we talked about a little bit of multiplicity of designs approach in determining functionality. And most jurisdictions have this concept in there, obviously, because they adopt the TRIPS language, or this is somewhat of a prevailing sort of concept in IP. And the test that sort of come through is this one is the multiplicity of designs approach, where if there's alternate designs, then it's not functional in the industrial design space. And then the other approach that's out there, but is a no aesthetic consideration approach, essentially that the designer didn't really think about aesthetics in that feature, or that's not what drove that. Kind of hopping through countries. The hard part about this is there's not a lot of case law in applying these things, and while the statute a lot of times copies, or whatever the prevailing legal form is in that country, copies the TRIPS language, it's that implementation that is kind of key. So, for example, in Japan, the language is a design solely consisting of a shape that is indispensable for securing functions of the article can't be registered. In Korea, a design made only in a shape essential for a function of the relevant article can't be protected. Canada, features applied to a useful article that are dictated solely by a utilitarian function. So you hear again all this kind of lip service. I think the most notable one is the EU, because they've essentially sort of flipped the approach. They had a multiplicity of a design approach for the most part for a while, where if you could propose an alternate design, then that essentially proved that this wasn't driven by functionality. And more recently, the European Court of Justice sort of rejected that multiplicity of forms test, saying that that the logic being that theoretically there could be 3 different designs, but they're all driven by function, and so this test shouldn't be applied. Which you may agree with that or not, but they've gone a different, more the no aesthetic consideration approach in the design aspect, and they carve out features essentially, and they suggest that you can carve out features that are purely functional, as we were discussing, and I think you suggested from U.S. design patent practice wouldn't be something that would be desired.
So, from that, it sort of, you got 3 main strains that are circling about. You've got the one which you call the multiplicity of forms theory. Perry calls it the alternative designs test, where basically you're saying there are many ways, there are other ways to do this, whether it's one way or another, it's preventing a monopoly or maybe an oligopoly. The point is looking at alternative designs. That seems to be a clean way. The second way seems to be this one you talk about, the aesthetic consideration. That's where you go hypothetically or objectively within the mind of the creator. Did they have design on the mind when they were creating this thing? And then thirdly, the third strain seems to come out where you're looking at the minds of the consumers. Does the consumer care about the aesthetic of a drill bit when they buy a drill bit? And so through those 3, on the aesthetic consideration test, don't you think that maybe you could stumble upon the one design that does provide a monopoly, that there are no other design choices? I mean, even if you had design on the mind, you could have design on the mind and stumble upon a design which was dictated solely by function. So, I mean, does that seem like the proper guiding light?
Well, one thing I would comment on is that in thinking about this and some of the comments that get made, trying to practically implement this, the alternate design theory really makes the most sense in that if you can show multiple designs, it's fairly black and white in that, okay, there's these 3 designs, okay, there's other ways, and you're not monopolizing, even regardless of how much functionality is in it. It's not 100% functionality because inherently you can go a different route and it still works. Whereas these other ones, like you said, it's really pie in the sky kind of thinking what's in a designer's head or what's the consumer thinking about. Is design a factor here? And again, I think I come back to the point, is the point really to be scalpeling out all these things, or is this really just a coarse filter to not use other IP rights to extend like a utility patent functionality?
So David, go ahead.
One quick comment. Yeah. You know, what did the designer have in mind when he designed the product?
They say it's not subjectively is what they say, but go ahead.
Yeah, but you know, have you ever been involved in litigation? You go up to the designer and you say, look, we can only win if you had aesthetics in mind when you design this highly functional product. Now, I'm going to ask you, and I want an honest answer. Did you have aesthetics in mind when you designed this product? What do you think the answer will be? And I only add, duh.
It was a mixture. You know the answer is coming. I mean, and you're watching it play out post. This is the Dokaram decision, the European Court of Justice. And, you know, you talk to practitioners over there, it's just created, I suppose it's created much more litigation, but it just goes on and on and on. And there's no certainty in that particular test. David, you mentioned all of these tests. What's interesting is every time you were speaking about is that it's a design that is dictated by function, or design that is essential. It was not, none of these seem to be this micro analysis of every little feature of the design, because I think if you practice design law, you know that it's only the combination, whether it's utility patent law or design. We're not concerned about the novelty of a particular feature. We're not concerned about the ornamentality of a particular feature and that it's going to create a monopoly right, because we know it's a construct.
Yeah, the only, and I don't want to take more time, I want to defer to my colleagues, but I just want to follow up that, again, in applying particularly this TRIPS kind of language, I think it's easy to take that on board and apply it without thinking through these concepts you raised, Chris, to components. And I think in some jurisdictions they've done that, and they may not have thought through how that really affects the end product by saying, because the language is shall not expect to designs dictated essentially by technical or functional considerations, and they think, oh, okay, well, this part's ornamental, this part's technical, we get rid of the technical, this is then the design. But like you said, there's that changes more than just following that rule. It changes scope and what you're protecting, and a lot of other considerations. So it may be inadvertent. We get those sorts of
Chris, are you suggesting that this filtration of elements that sometimes happens in design patent law should be also barred from trade dress law and copyright law?
Well, it's an interesting question, and I want to throw that to the table. And I want to be clear that when we're talking about aspects, to be very clear that none of us are saying that it should protect, if it's a hinge, that the design patent protects the swivelability of something, or if it's a knife that it cuts its ability to cut, or its tensile strength, or any of these underlying abstract qualities. Not about that. We're talking about aspects. We're talking about visual aspects. So let's throw that out there in our last remaining minutes, because there is a question here that says, what should we filter out then? Should we, when we talk about aspects, functional aspects, what do we mean? Because all the case law seems like they should not be protecting functional aspects. What do we mean by functional aspects?
So can I just, so this is something I wanted to say. So I find this, is there any other way to do it, somewhat puzzling, given that utility patents don't actually have to be better than the alternatives. That's not the standard for getting a utility patent, right? It is that it performs better. That might be the standard for getting a certain drug approved, depending on what drug it is. But you will get your utility patent if it is a novel, non-obvious way to do something, not that it's better. So I do think that's inconsistent. And I just wanted to throw in, since we're talking about Europe, something that the Europeans have, which is a concept called limping marks, which is something that consumers recognize but don't actually use to distinguish and the products. And the great example of this is the Kit Kat bar. Like if you show someone an unwrapped Kit Kat bar, they're like, oh yeah, that's a Kit Kat bar. But that's not how they buy it. And there's a recognition here that is sort of, if it's not performing a trademark function, the fact that people recognize it really shouldn't matter all that much. And I think this ties into the larger question, like what should we be encouraging people to develop as different intellectual property rights? And the reason to do some of this screening is not actually, it's not actually about any individual design, it's systemic, right? We want to tell people, okay, if your objective is commercial, right, then focus on things that consumers can identify, right? If your objective is artistic, then focus on expression. And if you're and design patent is sort of weird, and I admit that, but that's not
so
right.
It seems like when we're talking about these areas, we know that in the design patent case law, the last 3 Federal Circuit opinions were crystal clear that you do not filter any visual or eliminate any visual features of the whole. And so in a large respect, they have created a much more clearer path than what we're hearing on the copyright side or even the trade dress side about this feature-based filtration that we see going on. The tests themselves seems like there's more clarity. The design patent side, it just seems to it only applies to the overall claim. Is the claim design ornamental? Is the claim design novel? Is the claim design non-obvious? We look at it at the claim level, the construct. But this idea about the scope and when that scope is defined, I think Professor Tushnet sort of hit off with this at the beginning. To me, is that maybe an area we can explore, that to the more that we have a defined scope, the less desirous we are to try to excise out functionally driven appearance. But the inverse, as the less that the scope is defined, there is a role for the courts or experts to do that screening function, because that's the front line. That is the only line. Any thoughts there? We've only got a few more minutes left, but I'll let others sort of chime in on that and posit that idea. Barry, we've got you speechless. That's all right. So the filtration part, it's firmly rooted in the copyright side. We've got one last topic here. Well, no, we're going to have to wrap this thing up because we're towards the end. So I think there was one other question here that we wanted to ask. This was for Perry specifically. It says, you had mentioned that there was free riding and that it was unfair. What's your thought there about why that is free riding in that circumstance where you have the expired design patent, or you at the end of the term of a design patent? Is that the free riding that you're talking about? If someone's able to extend the rights, they call it evergreening the rights.
Well, the court in traffics had that issue teed up right in front of them, and they dodged it by invalidating the trade dress as functional. But there you had an expired utility patent, presumably with the subject matter in the public domain, a lot of case law that says the public has the right to copy the subject matter of that expired utility patent. And along comes the owner of that patent and alleges trade dress rights in the same subject matter of the expired patent. Now, I know a lot of my protectionist friends disagree with this, but I believe that that's improper because the Constitution says you can only protect designs for a limited time. And when the monopoly is over, when the patent expires, it's over. And you can't sneak in there with another form of protection, i.e. trade dress, and in essence, extend your monopoly. Do you agree, Rebecca?
I think the bell has rung.
Caught you off guard.
Yeah.
I thought I would have a
Harry,
complete.
I have a question. I want to hear what Rebecca has to say, but one thing I was thinking about when you were talking was, I was thinking about the idea that trade dress doesn't have to be in a new, trade dress rights doesn't have to be a new design, right? Like I could adopt an old design and I could work hard to build my secondary meaning and then I would get my trade dress rights. So I guess I wonder when you connect them together like that, if you're kind of short shrifting the trade dress.
Well, it looks like Adam has appeared on our screen. We got Harry on record taking an anti-protectionist position, so I'm happy about that. But then I guess Rebecca will to be continued. Saved by the bell, however you want to look at it. We will continue this for a future time. I want to thank all of the panelists here. It's a great discussion. More to discuss. Functionality just continues to be a fun puzzle. I'll hand it over to Adam. Thank you so much.
Thank you, Chris, and thank you to the rest of our panelists. It sounds like this panel could have gone on for another couple hours if we had the time for it. So, all right. So, as the panelists leave the stage, what we're going to do here is we are going to be transitioning to our second room. And what that means is when we go back to the tables on the bottom right-hand side of your screen, you'll actually see a button that will link to room 2. So that's where we will continue for the rest of the conference. We are planning for the next panel to begin in 5 minutes. So if we could quickly make our way over there, that would be greatly appreciated. If you need any assistance, we will have our student ambassadors making their rounds around room 1 to make sure that everyone gets to where they need to be. And we will see you in room 2.
Hi, everybody. Welcome to session 2. And as Adam is making his way up, if you were not here this morning, it's great to see you. We are starting our second half of discussion on the intersection of copyright, trademarks, and designs. And Adam, over to you.
Thank you, Daryl. As we sort of get transitioned here and make our way to room 2, hopefully we can get everyone from room 1 transitioned properly and quickly. In the meantime, we will get underway. So welcome back. It's only been a couple seconds here, but our next panel is Infringement at the Intersection. It'll be moderated by Tracy Durkin. Tracy is the practice leader of Stern Kessler's Mechanical and Design Practice Group, and she is also a member of the Trademark and Brand Protection Practice. And she's now joined me up on the stage. So Tracy, go ahead, take it away.
Great, thanks, Adam. Looks like some other folks are coming in. So hopefully everyone got a short break between the sessions, and I think there is a longer break after us. So hopefully you can sit tight for another hour of exciting IP discussions at the intersection. So for this, we're going to talk about infringement at the intersection. So playing off of the prior discussion with the folks on functionality, which was looking at how trademarks, design patents, and copyrights intersect in terms of functionality, we're going to look at it in terms of infringement. And so, I'm still waiting on one more person, but I think as we saw in the last panel, these three things are not mutually exclusive, but they're not the same either, certainly in terms of strategy to acquire them, or more importantly for this session, how to enforce them. So joining me today, and I see still one person is missing, but I'll just talk slowly, are 5 gentlemen, all with experience in this area. First, we have Adam Kelly, who is the Associate General Counsel with Columbia Sportswear, who was happy he was not on the first panel today since he's joining us from the West Coast, so that would have been a little early. Next, we have John Cheek, who is the Chief Intellectual Property Counsel and Assistant Secretary at Tenneco Drive, I think is how you pronounce it, or is it Drive?
It's Drive.
Drive, okay. Then we have Ariel Manoff, who is an alum of the institution sponsoring us today. He's also a partner with Vitali Manoff and Falbogen, that I probably totally mispronounced, in Argentina. We also have Mark Bennett, who is the Robert A. Lucas Chair and Professor of Law and the Director of the Center for Intellectual Property Research at the Maurer School of Law at Indiana University in Bloomington, Indiana. Mark, thanks for joining us. And truly last, because I don't see him yet, but maybe I just don't have enough space on my screen, is Damien Picari. Damien is currently the Regional Director of the Elijah J. McCoy Midwest Regional Office of the U.S. But many of us know us in a role he had prior to that. He was the head of the design protection group and other things at Ford Global in Detroit. So thanks everyone for joining. I'm going to start the discussion today, sort of like the others have, by just throwing out a question to kind of frame the discussion we're going to have today from your perspective. So the question I'm going to start with, and I'll throw it to you first, Adam, is what do you want the audience to know or to keep in mind as we have the discussion today about the intersection in infringement of trademarks, copyrights, and designs?
Yeah, thanks, Tracy. Good to be here. I think coming at it from the perspective of the brand owner, and I know John's on that side as well, you know, really the importance of considering these areas of IP, obviously to be able to enforce them, you need to obtain them, and so that's one element of it, how, you know, whether and how you can obtain, you know, these in particular 3 areas of IP protection, or at least more than one of them on the same product or product technology. And then tied into that, this idea of layered protection and the considerable advantages you have, you know, when you get to this enforcement and infringement stage, and kind of discuss that some with the group and get other thoughts and my own thoughts. And but that's from the brand owner side, looking for outside counsel to be thinking this way and advising and coordinating with these 3 areas. So hopefully that'll come across in the discussion.
Great, thank you. Ariel, do you want to go next and give us your opening thoughts?
Yes, hello. Thank you for having me. When I think about the title of this event, Intersection, I believe that it's really very good for practitioners and for clients, because I noticed along my more than 30 years of practice that the commoditization of the services and the commoditization of the products is really a problem that we are facing as professionals. I believe that we can really improve our practice by this intersection of disciplines and intersection of knowledge. When I am alumni of John Marshall Law School, and I came here more than 20 years ago, and I had the possibility, at that time I was a trademark practitioner with some litigation in commercial law, and I have the possibility to have like a tour of all our disciplines. I learned about patents, about trade secrets, about design, copyrights, Really, this was amazing for me because I can really intersect all this new knowledge with my previous knowledge. And now I am practicing in Argentina for a long time. All this knowledge about the different practice of law in different parts of the world, I believe that is very useful. I think we can help the clients in the best possible way if we use imagination and have the experience of different clients transmitting to other clients and to other services. And for this reason, I believe that it's a very interesting issue to talk.
Thank you. John, do you want to go next?
Sure. Thanks, Tracy, and thanks to the John Marshall team for putting this together. I think we're going to, we've had discussions already about the substance, and we're going to have some substance discussions here. But when I think about intersection, I think about the intersection of the practice and the people, and important to recognize, particularly when we get to the point of an infringement and actions taken around that, that it's different people often, right? If you're unless you're a small kind of one-person operation able to do everything on your own without any outside counsel, which is uncommon. We have people with different specialties doing different things at different times, and that whole practice management can be an important and ever critical part of getting things right. As we look at the topics of the morning on how do we gain the protection to now about how do we enforce. And I think that's something we can't lose sight about. We need to understand the law and the substance and the strategy, but how we coordinate the movement of people in cases and activity can be really as critical as the substance, and sometimes more important. So I think that's, for me, one of the big things to keep in mind as we're talking today.
Yeah, I look forward to talking more on that. Litigation always sounds like a great idea for the business people until they get into it, and then they wonder what they got themselves into.
That's right.
And Mark?
Yeah, thank you, and thanks to John Marshall, and thank you, Tracy. I've got maybe a different perspective on intersectionality to throw out there. I think a design is such a clear example of subject matter that lies at the intersections of various intellectual property regimes. And it seemed to me that a lot of the conversation, particularly of the last panel, covered that. What I'd like to do is think about legal doctrines that are transplanted from one IP regime to another as a slightly different take on the idea of intersectionality. I think that also is a natural fit for design, especially for design patent, which is surely one of the best examples we have of a system that has relied on the borrowing and adapting and remixing of many doctrines in sometimes in very strange ways from other IP systems. So that's my perspective on intersectionality for the day.
It's going to be really interesting too. All right, well, I still don't see that Damien has joined us, but we'll keep going. We'll get his continue. Adam, I'm going to start back with you, if you don't mind. And I hope that feedback is not coming from me, but I apologize if it is. So, Columbia Sportswear, known for making and selling clothes, footwear, camping equipment, all sorts of exciting things. You've got multiple brands that you sell things under: Columbia, Sorel, Mountain Hardware, Prana. I didn't even realize that was one of your brands until I did a little research here. So in your role, when someone brings a new product, or in some cases even just a material, to you to consider for IP protection, what are the first things you think about?
Yeah, so I work pretty closely with, very closely with our product innovation and product design teams. and in particular from the Columbia brand perspective, as you mentioned, we've got the 4 brands in the family, but Columbia really strives to find technologies, product technologies, and typically it's in the materials, as you mentioned, in a performance fabric, which may help with heat regulation, heat management, maybe wicking, cooling, waterproof, those kind of things, but also in the context of footwear midsoles, the different foam compositions and things like that. But when we put those technologies together, we really strive to have a visual element to the technology so consumers can visualize it, see it, understand it, kind of intuitively go, oh, okay, it looks that way, therefore it's going to have this performance effect, this performance benefit. And of course that ties back a bit to the functionality sort of line there that the prior session was focused more on. But because we have these technologies that we really want to have for our important ones, this look and feel to it that really draws the consumer, we also need to look into these areas that protect look and feel, ornamental design, something that could lead to a trade dress and some sort of secondary meaning. So when something's brought to me in that context, we of course look at the utility patent side if it's relevant. And then I think, which makes this conversation interesting, I think that the tendency, both probably for a lot of brands and for outside counsel, is to really next focus on design, because you're talking about a product or a material that's going in something, or a look of a shoe, midsole, that kind of thing. So certainly design patent is kind of number one, but I think it's important, as I mentioned at the outset, to really consider these other areas and coordinate internally with the various functions within the company that need to be involved. From the product design side, if we're looking at something that's got a particular look and feel that maybe has enough artistic expression, with Star Athletica kind of bringing the copyright back into play, or more into play, certainly for the look of a fabric, frankly, or elements of a shoe, and we can talk more about whether any of that's possible to obtain the trade dress, and in particular trade dress and copyright. I think in many circumstances it is possible to do that, and you build this layered protection that can, at fairly low cost, really design is the most expensive to obtain the registration, the issued patent. But these other trade dress and copyright are quite inexpensive. So you can build this layered protection that has considerable advantages, which we can kick around a little bit, and I can touch on a few that come to mind here. But back to a little bit of that question, I need, in that context, either me and my team internally, or looking to outside counsel, which we certainly do, and to John's point, making sure you're getting the right coordination of folks. You really need to plan and strategize in order to determine whether you can, but more importantly, if you can, what steps need to be taken to put yourself in that position to get each of those rights. They all have different requirements, as folks know, to apply, different timing issues. You don't want to miss the opportunity, for example, with copyright, to get it registered for fairly minimal cost, because you need it registered in order to get statutory rights, statutory damages, attorney's fees, which are huge hammers from our, again, the brand owner, IP owner perspective, that aren't necessarily, or really rarely, in the context of attorney fees, rarely available in the other areas that we're talking about. But you don't want to miss that opportunity. Coordinating sort of disclosure, so you're not publicly disclosing and messing up rights. You're doing one that timing wise impacts the other. And then I think so those elements, that's talking to the design teams, seeing what patterns are available, what are we interested in that are going to sell, but also what actually works. Some of our fabric, performance fabrics, again, they've got that functional aspect, but they don't necessarily have to look a particular way. The shape of the functional element to the fabric could be a variety of shapes. It could be more artistic looking, which gets you closer to copyright potentially. So we need to explore that. They don't all necessarily work from a performance standpoint. So it's coordinating those angles, having outside counsel advise on some of that if we're, making sure we're presenting the right questions to the design team. And then the other piece, just to wrap up, what it kind of first I'm thinking about or coordinating with is from the trade dress side, most of the time, and others may have examples where it's inherently distinctive at the outset, most of the time these designs, the color, the look and feel of the pattern, maybe the particular shape, again, all these intersections that we're talking about, most of the time for trade dress, you've got to build up that secondary meaning. But it's important from a brand owner standpoint to start that conversation and that strategic planning early, so you've got consistency in the look and feel of whatever it is in the fabric and the appearance of it. You've got consistency in your marketing, enough marketing messaging so that consumers start to recognize that this particular colored, using our OmniHeat, this silver dot look and feel is associated as a source identifier to a single brand. That obviously takes time, but you have to start that early in the process with those discussions. So that's, there's a lot, there's all these moving parts. As in-house counsel, it's fun because you have to bounce around with all of them and then get to rely on experts in the field, like folks on the call, to really advise. But we need outside counsel, again, to John's point, to be coordinating with colleagues to say, there may be these extra protections here because the varying remedies are really strong. Having the ability to even assert two or more of these three areas we're talking about gives you a lot of leverage against infringers or alleged infringers, because if you've got the legitimate threat of attorney's fees rather than, well, it's got to be an exceptional case in a design or a trade dress, that's a big hammer. And statutory damages, profits in the design context. So when you've got that layered protection, that gives you that real advantage. And I think, and then last, and I'll stop to let the discussion continue. But one other thing that comes to mind in when you get to this infringement and enforcement standpoint, if you've got, again, three, if you're lucky, two of these areas, the story you can tell to a jury, I think could be broader, and you're able to bring in evidence that may be relevant to a copyright claim that's not relevant to a design claim. So you wouldn't be able to bring it in if you were only suing on design or trade dress for that matter. And suddenly you've got this much broader story to a jury that, frankly, from a strategic standpoint, juries are going to be swayed by the story, and it gives you that, just again, another advantage in there to really put the pressure on or give yourself a better chance of winning 1 out of 3. Sort of common sense there. So I'll stop there to let others chime in as well. But that's where I'm coming from, day in and day out on the brand side. It's really that hope to build really a layer of protection that's going to keep this thing, this performance fabric or this midsole really going effectively if you get the right rights effectively, and the protection can go on indefinitely. So
thanks, Adam. That's a lot to keep you awake at night. I think there's a few things I want to dig into deeper on, but before we do that, let me see if anyone has any comments on what Adam said from their own perspective. Damien, thanks for joining us. We're happy to have you. I mentioned that not only in your role at the PTO currently, you have a very long history with design units at Ford. I don't know if anything Adam said resonated with you. Do you want to comment on it?
Yeah, so I'm sorry about late. I was actually on a different browser version where you couldn't hear me. I like the value that Adam brings to intellectual property rights acquisition. When I started at Ford, I inherited an IP docket that was constructed without enforcement in mind. And that is not as much fun or as successful as creating an IP portfolio with the idea of enforcement in mind at the beginning. Your likelihood of success, your ability to protect it, your ability to enforce it just dramatically increases if you create it with that in mind. So what I'm very also interested in is if the PTO does things either in the registration application process or the examination process that hinders your ability to enforce it. And if there's anything that we can do currently or in the future, if we need to change regulations, I'd be interested in hearing that.
Who wants to comment on how the office can do their job differently? Does anyone else want to comment on what Adam said? As I said, I've got a few things I want to poke into more deeply, like this idea of layered protection. If no one wants to comment generally on that, let me just start with that question, because there was quite a bit of discussion at the very end of the last session about, should you be able to tag on trade dress rights or even copyright, after the fact, once a design patent has either been granted or in some cases expired. Sounds like, Adam, you don't necessarily agree that's a problem.
Yeah, no. I think from the brand owner stand, it cuts both ways, of course, because we're certainly, and part of my role is certainly, analyzing potential infringement when we've come out with something new. So there's days when maybe I feel the other way. Well, wait a second, you've got a little too much here, but overall, and I've been in-house for a little over 8 years. So now I think I've honed in so much on what we need to do as a brand owner that I don't have a problem with it, most of the time, because frankly, that's my job now to really protect, and it's the important. It's not every single product, and I don't know if there's a way where you can kind of you can kind of limit it in a way that it's not every single product, for example, which would be costly for people to do anyway. So maybe that's part of it, that it just manages itself that way. But I think if it qualifies, you meet the requirements. Just because the design patent expires 15 years later, if you've built up trade dress and again it otherwise qualifies and doesn't get hit with the functionality, then why not? It's become now a trademark. It's become something that everybody knows is Columbia's or some other brands. So,
hey, Tracy, I think Adam makes a good point, and I wouldn't often disagree with Perry, but this might be one where we could discuss. I think it does come back a lot to the purpose of the rights, and yes, so the design patent is expired. In principle, the underlying purpose of the patent system would allow people to use that design. But if you switch over to the trade dress and trademark side, where the underlying purpose is to protect consumers against confusion, then I think you don't have an impassable misalignment that's there, right? It's a different purpose, and we protect the consumers by giving the rights to the owners of the trade dress. It's really to protect the consumers, and why should we allow them to be confused if there's a protectable right just because the design patent is expired?
But I don't think you should think of extending anything. It's not as though the design patent gave you trade dress rights. They just happened at different periods in time. Your remedies are different. Your damages are different. So I don't see as trade dress extends design patents. you just have two different rights. So, should other people other than Coca-Cola build a bottle with that shape? That's a trademark issue, not an expired design patent issue. So I don't think of it as extending anything. I think of it as they're different periods of time. Yeah, we offer two types of protection. And just like you can have patents in different regions geographically, you can have different IP protections over different time spans for different purposes. So I don't the extension word as appropriate.
Ariel, what's the picture in South America, Argentina on this? Are you entitled? Are they not mutually exclusive?
And the picture in my back. Yes. Well,
the picture on this topic in terms of can you have two different rights in the same design?
Yes. In Argentina and in many countries in South America, there is the distinction in the courts are in general clear, but there are not many cases in order to say, well, our case law is in this direction. But I can say that all the problems that you mentioned are very similar here. We have the same kind of discussions about what is the scope or what is the way to protect better. I was ready to ask Adam what was their experience as company in enforcing their rights. If the experience of the company was more positive with one way or the other.
Yeah, I think based on my experience here and the last few years of enforcing rights that or products that or technologies that have, we believe, rights, multiple rights. I think design is still the most successful, or we've been the most successful in that regard. And maybe that also has some level of self-management, so to speak, within this discussion of, well, are you extending out these rights? Why do you get these multiple areas? It's certainly not an automatic that we're going to get more than a design patent on something. And to Damien's point, you get the design patent early on, and 5, maybe 10 years, it could take a while to build that secondary meaning. And now you've got a totally different right. But to answer your question, yeah, I think design still that's still our go-to, I guess. And part of it's the copyright's growing a little bit again, so that's still, a little new and fresh, so yeah.
Yeah, I noticed that part of our work as lawyers changed a lot in the last years, because we have also to consider how effective are these rights, not only in the courts, but also in the sales platform like Amazon, or in South America, Mercado Libre. I would like to ask you, what is your experience enforcing these rights in this kind of atmosphere, this kind of scenarios?
For the most part, our online enforcement, like on we don't have as much problem in the U.S. platforms, but Mercado Libre or the platforms over in Asia, primarily it's kind of straight counterfeit in the sense that they're just knocking off our branding and our trademark. So we haven't really needed to go to these others, but to your point, that's another potential protection. Obviously, you could, in some places you can use the design for customs seizures or export from China or import into another country. And if you have a trademark that's a trade dress that's registered as a trademark, then you can put that there too. But we haven't run into that a lot. It's mostly pretty obvious trademark infringement as far as our key branding and logos and stuff. So yeah.
Because answering Tracy's question, here in Argentina and in South America, Mercado Libre became a big player in sales. Is really big here. Along the years, we had a lot of experiences pushing them by the courts, by injunctions, to change the approach, and finally now they are in some way enforcing better the rights. We don't have much experience enforcing design patents. But in copyrights and in trademarks, they are quite. They made a lot of progress.
Before we leave this idea of layering, Mark, as our resident policy expert or philosophy or whatever we want to call it, I'm curious to hear what your view is on this.
I'm a little bit worried about that introduction, though. Whatever we want to call it, part is getting me worried. But so
you're the one who always brings us back to reality in terms of what the law really is.
So I've debated Perry on this point years ago. It seems to me I really do struggle with the question. To me, it's hard, and one reason it's not just a simple matter of 2 bites at the apple, which I fear is the way this is eventually going to go. I think the Supreme Court is so on top of those kinds of issues, it worries me a little bit. The thing that I keep getting hung up on is the question of how easy is it really, or hard is it really, to build up secondary meaning. Because I think when we say you're getting 2 bites at the apple, design patent plus trade dress, I think we're saying, the fact that you have a design patent means you can keep everybody else out of the market, and therefore secondary meaning is automatic. So instead of rewarding you for building up secondary meaning, we shouldn't. That's 2 bites at the apple. And maybe that's true in a lot of markets. I don't think it has to be true. And that worries me a little bit. I worry that then we're just too quick to come to this, what otherwise does seem kind of intuitive, like 2 bites at the apple, same subject matter, extended protection, offense to the exclusive, the limited times limitation. I think it's pretty easy to go down all of those paths, but I do worry about the secondary meaning question.
You have something interesting to say, a different twist on that. Adam, you mentioned something that I'm curious what other people and your view on it too, but you mentioned this idea of potentially, with a jury having different stories to tell with different rights. Can you actually have too many stories? I know you had a case recently that involved both design and utility patent, and that can get hard enough probably, talking to a jury that, but can you have too many stories to tell? What's that intersection like if you're enforcing, particularly in court, more than one IP right in the same case?
Yeah, that's a good point. Are there any other, besides you, Tracy, any other, Ariel as well, the litigators on here on some level, but to comment on that. But yeah, I think then and of course, like everything, it's going to be fact specific, but if you've got enough of this, I guess, sort of natural intersection of these separate legal rights, but it's on the same design feature or look and feel, or all the each of the different words we use for the different areas mean the same, element or item, then, maybe the story doesn't get too too big or broad or unrelated, and jurors start to get confused, because you're still coming back to that same, the jury instructions would be important at that point, because that's when they're really going to hear all of the legal elements. But it's still, and I think, maybe this is another topic during the conversation, that there's some overlap there with this, confusion element, and consumers looking at this and saying, consumers as the juror, or juror as the consumer, saying, this looks the same, and this natural tendency, I think, to say, well, if they've got the legitimate rights, then you can't take them. And if you've brought in, some look, and I was talking to Chris Karani about this, a few months back, or a few weeks back, and Tracy, you may be able to explain it better, but some elements of the look of the Apple Samsung, and that, there were the design piece, but then if there was something you could bring in a bigger story, and you're looking at this, more of the element of this phone in a different context, does a jury just have a tendency to say, well, yeah, that's design infringement, even if they were looking at that evidence in the context of the trade dress claim, or most likely the trade dress claim, and that kind of topic, or situation. So, but I think it's certainly a risk. It just feels close enough. The overlap feels close enough compared, like you say, design and utility. Very, even though, again, it's the same thing, very just so different and so technical on one side, and frankly complicated, and then you get to design and kind of simplify it. So
the story that they're just bad actors, right? They've copied so many things. But go ahead, John.
I was going to say, I think, thinking of it from the rights owner's perspective, Adam, you make a good point there. You have this menu to pick from. The more rights you have, but you don't always have to pick everything, right? And we know, even in any litigation, the principles that judges are going to apply, limiting the issues and limiting the time you have and the page count on documents, that there's a lot to picking what are the rights you need to assert in order to win the objective you're trying to achieve, right? And a lot of times it's, throw the whole kitchen sink, everything you have, hit them with a barrage. But sometimes you can pick and choose, and you may not pick and choose the same things at the same time, the same things in the same forum or in the same country. And I think that piece, again, is the coordination piece at the intersection. Where are we going to come and apply effectively what's, fundamental military strategy, if you want to think about it, of where do I attack, where do I prepare to defend, and where do I put my resources, because we know they're limited. But the more you have, the more choices you have.
Good point. That's what I moved on that.
On the overlap, I haven't done an analysis, but at my former employer, there were hundreds and hundreds more design patents than there were trade dress. I don't know if that's common, but trade dress is far, far harder to get, and far fewer than design patent.
Yeah, that actually leads to one more thing I want to, in what Adam said, this idea of partitioning. And, that's unique to design patents in a way. It's very hard to partially claim a trade dress, with broken lines and, sort of things like that. And I'm just curious how much partial claiming falls into your strategy. It's kind of under attack a bit by some people, saying it shouldn't be allowed as part of design patent strategy. And I'm just curious, from an in-house counsel standpoint, how important is that, and do you see it as something unique that is much harder to do with copyright or trade dress, for example?
So, for example, for example, just on the partial claiming, would it be in the context of like a shoe and just claiming the midsole or just claiming the upper? That kind of, I mean, that's where.
Or just a little swatch of material, maybe.
Or just a little swatch.
Like
Yeah, yeah. I mean, we do that. I think we do that and rely on that quite a bit. You know, in part, it gives that with a fabric. I think it gives that if you can get the design claim on the look, the ornamental design of the performance fabric, you know, you're going to get it in more. Somebody puts it in anything. If you've got the partial claim rather than the entire jacket or something, that's certainly going to give. You know, we need to be able to do that to give us that breadth of protection we want. And similarly with a shoe, a lot of times we see things that, you know, our products where, you know, you've got a midsole that either we've already protected the look of that, and it's you know, it carries over, that tooling carries over to a new upper, you know, then we may want to claim a feature of the upper in a partial sense. But I think from the trade dress side of things, I think that in certain circumstances that I think that becomes more challenging, but in the performance fabric, maybe not, because that's really, if the look is uniform, you know, the for example, our lining has a uniform look and it's throughout that product, and we've done a little swatch of it or a little section of it as a design. We're gonna the argument of the trade dress is that just that whole look and feel, and so I don't think in that case we still get that double protection, I guess, or the layered protection, using partial in one sense, but not having that available, arguably in the next sense. So that answers that very well. I'm not sure.
Yeah. Other people have experience with that they want to share?
Tracy, I would just mention the first thing that came to mind when you asked the question was color position marks in trade dress. You know, where you see, I think there's some really great examples from my past life with John Deere, for example, having color position marks for the relative color and position of the wheels versus the engine enclosure on a farm tractor, for example. And you would find that potentially in colored versions of their design patents as well. So I think there are some carryovers that we can think about.
Absolutely, those are great examples. Yeah, thank you. Ariel, are these sorts of things protectable in Argentina? The you know, portions of designs or colors?
Yes, yes, it's possible. The only restriction is one color, but the combination of colors can be protected. We have a couple of cases about protecting chocolates. In general, the courts always look for avoiding confusion in the public, protecting the consumers. Also is the concept of secondary meaning, in some way very similar to.
Great, thank you. Well, I was just going to turn to John, but I don't see his face. I don't know if he can hear us or not. Here he comes.
I'm here.
Okay, good. So, John, you talked a little bit about coordination and, you know, not one thing not cannibalizing another, and sort of more importantly, the various resources that come to play in an enforcement action. You know, oftentimes in-house, it's not even the patent people that are handling the trademark matters. What's your thoughts on that?
Yeah, I think that for me, that's the piece that is often most challenging. And I think it's important, you know, the punchline is, you know, the team structure in that organization being kind of the starting point, making sure that, you know, that you have kind of a quarterback, if we want to use that sports analogy, to pull all the players together and, you know, make sure, hey, this is the play we're running. You know, you go here, you stop there, and I'll throw you the ball, kind of thing. Because it all happens typically at different times, unless you can be really lucky to have this coordinated upfront approach, right? Maybe we're filing utility patents first, and then, you know, once the design is more solid, we can file the design patents. We have to coordinate that, and then the trademark team or attorneys need to do their work, and they may do it before or after. And of course, copyright can come along at any time. So all that coordination can really trip you up, and it's a place to be cautious of as you're enforcing. If you're the defendant, things to think of, you know, who are the inventors versus who are the authors for copyright? You know, do the entities who own all the rights, are they the same entity? Or do you have them positioned around different places? And if you put your IP in a particular holding structure because the tax advisors say this is the best way to do it, for example, does that limit your ability to recover lost profit damages in a case where you've got an IP holding company who's just charging royalties to the rest of the corporate structure? And Tracy, I think you pointed this out in our call, you know, getting dates going into documents in different categories of rights protection that maybe don't match up. Dates of first use and trademarks that don't match up with the creation date in a copyright application you filed in China that don't match up with the filing timeline for your design patent can be a problem. So I think that coordination is key. And I think about it even in the practical standpoint of, you know, how do we use survey evidence? We might use that in our trademark and trade dress cases. We might not want to use it in our design cases, or maybe we do. And then the one that I was thinking about most recently, and this is maybe more of a trademark than a trade dress thing, but as we think about, you know, proving fame so that we can open up avenues for dilution claims, a lot of information goes into that. A lot of story goes into that about the value and the fame of the mark. And if the mark is on the goods, how does that tie into the scope and protectability and the likelihood of confusion from a design patent infringement analysis perspective? So to me, it all says you got to have someone who's coordinating all of it, making sure all the players are doing the right things at the right time. And it's hard enough to do it from an in-house perspective with the teams we have. I can't imagine how you do it if you're a company that doesn't have an in-house person. You're trying to do that. So I think the role of a key player on the outside can be important as well.
Mm-hmm. Yeah, and even just, I think one thing, the trademark search report as potentially being something for the duty of disclosure in the design patent application, if it's, searching a three-dimensional mark, that there's often a.
Yeah, the one thing I haven't seen it in recent years, but issues arising out of focus group studies, right? You put the design out and you get feedback from the focus group. And if you're doing that in the normal context of marketing, that's not typically privileged material. And so now you have to deal with that in your design patent case.
Good point. That's what keeps you awake at night.
It doesn't keep me awake, but it keeps me awake during the day, which is probably more important.
Anyone else want to comment on that coordination effort? Damien, I know you did a lot of patent litigation, design patent litigation when you were at Ford. Anything to add?
A lot of experience with those focus group studies. And that does become quite complicated because you'll have, at least in the car business, I never in my 30 years saw the first sketch match the final production. In fact, they're tweaking that design just before it goes into production, and even sometimes afterward. So what is the design at any point in time is very subject to change, and who the inventor was on version 1 versus version 150 becomes super complicated. Did the design at issue match the design that went into production? So file often.
Nice. Mark, I'm going to switch gears a little bit and turn to you because I know you've been thinking about the design patent infringement test that was first articulated in Gorham v. White here in the US. And I wonder what you think that case tells us about the intersection between design patents and trademark doctrine. That came up a little bit in the session ahead of ours, but what are the implications, do you think, for modern design patent litigation?
Well, thanks, Tracy. Let me say a few words about that and try not to go on too long as a professor here. So the kind of thing that keeps me awake at night is, wondering what was it that Gorham versus White really said in 1871. So maybe me and no one else in the world stays up at night thinking about that. But you have language in there that everybody knows. That talks about the resemblance between designs being such as to deceive an observer, an ordinary observer, inducing him to purchase one, supposing it to be the other. And to a modern reader, that sounds like that could be trademark language, but the case doesn't come right out and say it. However, if you read the full record of the decision and you situate it in the landscape of other cases that were being decided at the time, there really is a strong connection to trademark and unfair competition. Both of the parties were asking the court to choose between a patent standard, which they tied to the expert observer, and a trademark standard, which they tied to the ordinary observer. And of course, the court chose the ordinary observer standard. It didn't say, and by the way, I'm choosing to borrow trademark law. But the court did say ordinary observer and used the language that I just read to you. On top of that, Justice Strong, who wrote the opinion, had just a few months before that decided a trademark case, Canal versus Clark, and in describing the trademark infringement language or standard, used the same language. The wrong is done by deceiving the public, inducing the public to purchase the goods and manufacturers of one person, supposing them to be the other. To me, that is a very clear signal. And then the question, of course, for the people who aren't professors, the rest of the world, people who actually do this stuff, is so what do you do with an insight like that? And let me toss out a couple of thoughts about that. But there's a lot more. I'll just give maybe focus on one example. In general, what the Federal Circuit could do with an insight like that is to enrich its design patent infringement jurisprudence. And that's not a plea to make it more flexible, make scope broader by interjecting trademark or even copyright concepts. But it is a plea to the Federal Circuit to maybe stop insisting that utility patent law inevitably is the default frame of reference for any sort of design patent infringement rule. So what I'm suggesting is that what the Federal Circuit could do is consider whether there's anything worth borrowing in 150 years of trademark jurisprudence since the Gorham case, and be informed by the lessons, positive and negative, and the experience of trademark jurisprudence. And so let me give one example. Again, there are many that you can point to, but let me just give one that has to do with borrowing from the experience of trademark jurisprudence, not so much borrowing discrete doctrine. So in the trademark infringement analysis, evidence of actual confusion, of course, usually demonstrated by survey evidence, is a factor in the likelihood of confusion calculus, obviously. But to date, it's not been clear to me anyway that there's really been any analogous form of empirical evidence used in assessing the ordinary observer's perceptions in design patent infringement. In fact, the Federal Circuit ruled in the early 90s that there was no blanket requirement to present empirical evidence to establish design patent infringement. The idea was you could put a visual comparison in front of the jury at trial, and the jury effectively was a miniature universe of ordinary observers. So that's interesting, but I think we might be entering a new era, and the new era is or could be the era of neuroscientific evidence of visual perception, which, at least according to some experts, promises evidence, empirical evidence of the perceptions of an ordinary observer. So it's conceivable that the time's not far off, maybe it's already happening, when trial courts and ultimately the Federal Circuit are going to be asked to weigh in on the role of neuroaesthetic, neuroscientific empirical evidence in the context of design patent infringement. I think it's going to be really interesting. I think it could challenge some fundamental assumptions about design patent, design patent rules. But coming back to the idea of constructive borrowing from the experience of trademark law, I think that the Federal Circuit and other courts dealing with this ought to be informed by the cautionary tale of trademark law's experience with confusion surveys. So I hope that courts will be asking questions like, how much is this going to drive up the cost of design patent litigation? Will this neuroscientific evidence become a de facto requirement for establishing design patent infringement liability, even if courts say it's not a de jure requirement? You see that sometimes happening in likelihood of confusion cases. Is design patent infringement analysis going to turn into a battle of experts that is all but inaccessible to a typical juror? Do we want that? Would that be a sign of progress or not? I think the experience in trademark law could be informative on all of those practical questions. And then lurking behind all of those is a broader theoretical question that scholars have been asking for some time. In the context of trademark law, the question is, does it really make sense to chase down a notion, an empirical notion of the consumer? Should we really take that as an article of faith, or should we really say, well, we talk about the average consumer, the relevant purchaser, as if it's as if it is an empirical notion, but it's as much normative as it is empirical. And I would hope that if we come to an era of the empirical ordinary observer, we don't forget those sorts of cautionary lessons, and indeed that we continue to ask the question, why did we pick the ordinary observer, and what are we trying to accomplish there? Are we really trying to replicate what an ordinary purchaser would be deceived by, or is that a heuristic for something else that we're doing in the system? So those are just a few comments. There are other, I suppose, points of intersection that I'd urge the Federal Circuit to consider, but that at least gives you an idea of what I'm thinking about.
Reactions?
I'm interested in how PTO could use this neuroscience for patentability, novelty, and obviousness. Would some robot give two designs a score, a similarity score? How would that work?
So I wouldn't purport to be an expert on the technology, but my understanding is that people who are experts purport to be able to do empirical assessments of visual comparison. And while I've seen an example of it done in the context of infringement, of course, for design patent, that ought to mean that it could just as well be done in the context of anticipation, visual comparison between the claimed design and a prior art design. So I think that the long range answer surely has to be yes, with all kinds of the corollary policy and other institutional questions that would entail.
Because on my phone, I can snap a photo of a leaf, and my phone will tell me the genus and species of that plant. So
I think now, again, I wouldn't purport to be an expert in the technology, but I would say that my instinct is that when people say it's coming, I think it might be coming. And I think the first instinct might be to be overwhelmed by the apparent objectivity of it. And I think that would be bad. I think that we ought to look at that technology critically. If we do use it, I think there are going to be lots and lots of normative assumptions built into it that I would hate to see get erased.
I mean, I think the office might be looking at using AI for like some trademark searching and things like that, right?
AI, I think will probably start in trademarks. Well, it's in classifications now, and I think the idea of AI in designs is probably a little later than in utility, but the tools exist for visually identifying and classifying images. Just haven't seen them applied into design patterns.
Mark, what would, in your thinking, what would be considered in the consumer survey or the empirical survey from the design standpoint? If trademark, trade dress, trademark survey, you know, can this be identified with a single source? What all would be included in the, you know, is it just like stripped down design side by side? Is it within the product, how it appears in the, you know, in the product as a whole, perhaps? And I'd be interested in how that might look, because it's interesting for sure. I mean, you know, on one hand, it might make things easier. On the other hand, putting aside the cost effect, but
right.
I
So
guess it depends.
Let me answer at a general level. You might be asking specifically what the technology does. That's a different answer. But at a general level, I think it's interesting because it does force you to ask, how seriously are we supposed to take that language from Gorham versus White? Is that just an embellishment, or is this really saying that in some way design patent protection is about consumer reactions to the visual aspects of these designs? So, you know, for example, in the likelihood of confusion calculus, of course, there's similarity of the marks as a factor. And in a trade dress case, there are all sorts of rules about contextualizing that similarity comparison. So are you supposed to do it side by side? Well, if people aren't side by side in the market, that wouldn't be probative. Are you supposed to do it at the point of sale or afterwards? If you do it afterwards, then the design might be disassociated with packaging or labeling, just to come up with a labeling issue for you that might be relevant to you. So all of those considerations have been thought about, at least in the context of trademarks. Of course, you could say, well, that's different because in trademarks, at least in the US, we have use requirements. So both parties are going to be in the market or in a market, whereas in design patent, they wouldn't have to be. Maybe that's the endpoint to say, well, so a similarity of marks comparison as it's used in likelihood of confusion actually sounds like it would have been probative, but it really isn't as probative given the different orientations of the system. That would be fine. I think it would be constructive for the Federal Circuit to go through that exercise and perhaps come to that conclusion. Or maybe the Federal Circuit would say, no, we really are supposed to take that language seriously of our reviewing court. And so when we say things like, oh, it's automatically a side-by-side comparison, the Federal Circuit just says that reflexively in design patent infringement cases. I've often wondered, like, well, I mean, is that really probative? If consumers never encounter the respective designs that way, Why should that be the rule? So I don't know where the endpoint is, but I think the process would actually be useful. I think it could make the design patent infringement jurisprudence more coherent. Now, one other point, I see Perry has got a question in the chat, and that's about, I knew he would ask this, and he and I agree on this one. He said, well, does this mean that we'd like to incorporate the trade dress functionality rule into design patent? Is that consistent with this whole idea of the kind of intersectionality that I'm talking about? I would say that's an example where the Federal Circuit should have said the goals of those respective functionality doctrines are different, and there is no good reason to interject a factors analysis of functionality that we see in trade dress into design patent. So I agree with Perry on that
one. You made a passing comment about the intersection of trademarks and design patents, particularly on a product. We all kind of smiled because I think we knew what case you were talking about. It's actually a case that Adam's company is famously involved. Thoughts about what should courts be doing with trademarks when they appear on a product and you're doing the trademark and the design patent analysis?
I would like to add a practical issue related to, because sometimes for the trademark owners, it's very important the approach, not a final decision of a court, but also how can you obtain an injunction. From this point of view, sometimes trademarks can be more effective in some way to obtain injunction, at least in Argentina. The process normally involves less quantity of work court experts. Really is a practical matter. How can you obtain from a court, and how can you combine all the rights, owner rights, to be more effective before the courts? Normally, when you have a case that the same IP asset is protected with 2 or 3 kind of rights, like a copyright and trademark, or copyright, trademark, and design patents, is because the owner of the rights consider that this asset is very important. As practitioner, as a lawyer, you have to try to choose what is the best court. For instance, one of the options that you have is, for instance, in South America, in Argentina in particular, you have the court's action for trademark and patents are in federal courts, and copyrights are litigated in state courts. Normally, you should to be careful to choose which is the best option for obtaining an injunction in general. I remember a case where all the case rely on the office of the court that have to seize one sample of the pirate product. We arrived to the representative of the court say, well, I don't recognize this item because it's very different of the original one. Yeah, but the problem is that the quality is different, but the look is the same. And finally, the decision was taken by a person that, while we were talking about this issue, say, I want this product with the brand that was involved. And the officer of the court say, I have now a witness that say that this is the infringing product. That means that beside the court action and the main court action, it's important to see with the client how is the best way to enforce the right in injunction level.
Thank you, Ariel. We are down to 1 minute and 51 seconds. So I am going to quickly go around the table here and ask everyone for the one takeaway they would like everyone to kind of remember from the discussion today. Let's go in reverse order. Damien, you want to go first?
Sure. I think from an enforceability standpoint, but even a prosecution standpoint, if the attorneys were involved early in the process, you greatly enhance both. It makes life so much easier. So if this is useful for in-house counsel, and if outside counsel can somehow partner closer with design product development of companies, they'll have a better relationship and a better outcome.
Great. All right. What's your takeaway?
Well, it's just the closing my previous comment that it's very important to have clear, if you have the possibility to choose between different rights, to try to analyze what is more effective and cost effective to obtain the enforcement of your rights.
Great, thank you. Mark?
I just simply say the Federal Circuit should be more ecumenical in its design patent infringement jurisprudence. It should be willing to entertain arguments. It should be informed by trademark infringement jurisprudence, even if at the end of the day it decides that the analogy isn't strong enough and it rejects the inclusion of doctrines from trademark.
Take the blinders off. Sounds like you're saying. John, I can't see you. Are you still there?
I'm here. I can see everyone on my end, but
Okay,
yeah,
so it must be on my end.
I would say a key takeaway is recognizing that, you know, while we may develop expertise in certain types of regimes, you have to know how all of them work together to be able to bring these, you know, to deal with the infringement issues, especially. You know, so don't stay too much in one swim lane if you want to do the best job possible. Make sure you branch out and understand all three regimes that we're talking about.
Especially in-house.
Absolutely.
And finally, Adam Kelly. I see Adam Arnett has joined us, but Adam, what's your parting comment?
Yeah, a little piggybacking a little bit on Damien and John. I think it's you know, don't forget about the other two, meaning trade dress and copyright when you're looking at a new product or a product technology that may be eligible for both, so that you're again, as John said, coordinating but thinking about it from that layered protection and the real advantages it can bring at fairly minimal cost, adding those two on the back end as far as obtaining the registration cost. Litigation costs may go up, but you know, at least you have the option.
Good point. Well, it's been my pleasure to be here with everyone today. Thank you for your insightful comments, and I think we probably could have kept going, but Adam is going to tell us we need to stop.
Yeah, that's unfortunately my job. Thank you, Tracy, and thank you for the rest of the panelists. It was a wonderful panel discussion. I know I can probably say all the attendees greatly appreciated it. So right now, as we clear out, what we're going to be doing is we're going to be going back to the tables. And if any of the attendees want to discuss any of these details or any of the specifics of anything any of the panelists said, please feel free to join their table and ask them questions if they're willing to stick around. I'm sure they'd be more than happy to continue talking about this subject. So I will see you back here in about 15 minutes. Right. Welcome back, everyone, and I'd like to welcome you to our final panel discussion of today, and that is our panel on entitled Intersections at the Supreme Court, Google v. Oracle. This panel will be moderated by Kevin Todis. Kevin is founder and managing partner of Todis Law here in Chicago, and I will let Kevin lead the panel. Take it the rest of the way.
Thanks, Adam. We're going to do a very quick introduction of everybody, and as I explained to our speakers before, because we do have a number of partisans here in the Google versus Oracle case, I'm going to ask people to very briefly introduce themselves and identify their affiliations. I will start with I'll start with Tom. And then we'll go to Dale, and then Kevin and Peter. And then I know the other Dale is on her way because I was just chatting with her at a table. So we'll have her introduce herself as well. All right, Tom, why don't you lead off?
Just in terms of introduction
Just
to
in terms
myself.
of, yeah.
Sure. My name's Tom Goldstein. I'm a lawyer in Washington, D.C. I have a little boutique, and what I do is mostly Supreme Court litigation, and I have the privilege of representing Google at the Supreme Court. I also teach Supreme Court litigation at Harvard.
Okay, and next is Dale C.
Hi, everyone. I'm Dale Sedale. I'm at Kirkland & Ellis in New York City, where I head our copyright, trademark, internet, and advertising practice. And I am very proud to have represented and be representing Oracle at both of the Federal Circuit Appeals and at the Supreme Court. And I guess I also teach at Harvard, as it turns out. I teach copyright and trademark litigation.
Kevin?
Yeah, hey everyone, I'm Kevin Madigan. I'm a VP Legal Policy and Copyright Counsel at the Copyright Alliance here in DC. We have filed amicus briefs in this case, both at the Federal Circuit and Supreme Court level. I do not teach at Harvard.
Hey, Kevin, just so the audience is clear, did you file in favor of any party?
Oh yeah, we are supporting Oracle.
Okay. Peter.
Hello, everyone. I am a professor at University of California, Berkeley. I've been working on this case for about 35 years. I wrote about these issues when I was a law student at the aforementioned law school before Tom and Dale were teaching there. But my advisor on the project was a First Circuit judge named Stephen Breyer. But I don't represent any party. I did file an amicus brief that supports Google's side of the case, but I may have been supporting either party. No, it was in support of petitioner. Yes.
Yeah, those distinctions sometimes vary. And finally, we have our nonpartisan, Dale Nelson. So Dale will be the cool head of reason in this discussion. So Dale, can you briefly tell us about yourself?
Sure. Thanks, Kevin. I'm Dale Nelson. I'm a partner at a law firm in Los Angeles called Donaldson & Califf. We do a lot of fair use work for independent filmmakers and documentary filmmakers. I'm not exactly nonpartisan to this case because prior to joining Donaldson & Califf a couple of years ago, I spent over 25 years in-house at Warner Brothers in the intellectual property department. And during that time, Warner Brothers did file a few amicus briefs in this case in support of Oracle. One is a member of the Motion Picture Association, and the Motion Picture Association is also a member of the Copyright Alliance. So there you go. But now I'm still representing filmmakers, but a different type, and do a lot of fair use work in the motion picture field and entertainment field. So I'm by no means an expert in software copyright or anything that comes up in this particular case. So I was invited to join the panel just to sort of give a point of view from a fair use practitioner who is not in the software space. So hopefully I can do that.
Okay, so we're going to start off, and in moderator school, they tell us that we really want to keep our keep our comments brief. It's sort of like Mel Brooks' highlights from Hamlet, I guess, particularly with this case. So if I cut any of our speakers off, it's not because you don't have interesting things to say, but I have been instructed to sort of keep things moving along. So when we start out, why don't we, my job would have been a lot easier if the Supreme Court had issued a decision. So last night I stayed up reading every single brief filed in this case so I could be prepared, and that's a lie. But but I didn't have to read.
Put you to sleep, but okay.
I didn't have to read just one opinion. So, Dale Daly, can you start and just kind of give an overview from your perspective of the argument and where you saw the court focusing? And I realize that this starts getting a little bit touchy because you're waiting for a decision on behalf of your client. I know you didn't argue, but I'm guessing you were there. And Tom, you'll get equal time. So, Dale, why don't you start off?
Sure. I mean, my co-counsel Josh Rosenkrantz argued, and I think did a great job for our side. And Tom, I thought you did a great job for Google's side. And one of the nice things about the Supreme Court is it's a very collegial place to be arguing. Fortunately, I've had my other own arguments, so I don't feel totally deprived. And I think it's very difficult to comment too much on oral argument because they're still making up their mind. That said, it was very interesting to see their questions because a lot of things that people felt very strongly about, they seemed to get. In other words, there were a lot of questions about, well, why did Google need to do what it did and copy all of what Oracle did? Why couldn't they do what Apple did and come up with something new on their own? Or why should they be able to break into the bank and steal what's inside the bank and take it? And I don't know, those were, we thought, the right kinds of questions to align themselves with what the facts are in this case. That being said, you really can't predict from the questions what's going to happen.
Tom?
So there are two big issues in the case, and then a twist on the second. There's the copyrightability question, and I think the conventional wisdom is that there weren't 5 members of the court who are going to take the view that the copyright protection does not extend to application programming interfaces, which is kind of the meta framework for the case. With respect to fair use, I think that Dale's exactly right that it's a very, very difficult call. The twist in the fair use question is the standard of review. This is a case that came from a district court judgment from reviewing a jury's verdict. And before oral argument, the court asked the parties to provide additional briefing on what that should mean to the case. And so there was some of that in the oral argument as well. And so there are really 3 off-ramps here. You could decide the case on the basis that the APIs are not subject to copyright protection. You could say that there is essentially per se fair use, or you could say, well, this jury found that there's fair use and there's an insufficient basis to overturn that. I think Google's perspective is that is the opposite of Oracle. Oracle's view is that it should win on all those, and Google's view is that it should win on all of them as well, and that Google's position represents a long-standing perspective of the industry, and Oracle's perspective is that this is outright theft. And so they're just competing visions of the value of the intellectual property, the value of the work was done here. We can get further into it, but I just couldn't agree more with Dale C. that it is an extremely difficult call, other than I think that we probably are not going to win copyrightability.
Right, and I will say that as much as we think to be clear, we think the argument went well from our side, for our side's perspective, but you just, until they make up their minds, that's not worth anything, right? Everybody could have their own judgment on it. We did think, though, it was interesting that on the copyrightability point, that initially a lot of the case had been focused by Google's side on their 102B argument and the idea that this was just a means to do something and therefore wasn't copy method of doing something and therefore wasn't copyrightable. And at oral argument, that was not the argument that Google was talking about at all, and was instead arguing Verger and other things. And I think that the court picked up on some of those points, and we'll see what they mean.
And I'm going to open this up for volunteers to the extent anybody else was at the argument. Did you get the sense that that the court got the technology? And maybe either Peter or Kevin, if you were at the if you were there and aren't represented.
Nobody was there.
That might be helpful.
Everybody was on the phone. Nobody was there.
Well, okay, they're in the same sense that you are here right now. Okay, Kevin, go ahead.
Yeah, I was, there were all these analogies offered, and I've sometimes heard it said that the side that wins the analogies will win the case, but I'm not so sure that works in this case, because the justices, what they were offering weren't always super helpful, I don't think. Justice Thomas brought up this football playbook. Justice Kagan talked about grocery store shelf organization. There was talk of spice racks, restaurant menus, and then, of course, the QWERTY keyboard, which I believe Justice Breyer kept bringing up. And, I'm not sure it serves us to go through all these analogies today, but, just in response to the QWERTY keyboard one, that the keyboard doesn't incorporate underlying expressive elements. So I think there was a little confusion there on the part of Breyer. He sort of kept going back to the QWERTY keyboard, but on that one, just for the sake of argument, I guess, like, let's say the elements on the keyboard are copyrightable subject matter. Having come up with the QWERTY arrangement doesn't really mean that one would control all the typewriters. There's a number of different ways that keyboards could be arranged, and typewriters could continue to be produced with all kinds of variations. And the fact that today the QWERTY format is the one we all know and use doesn't really mean that there is now or ever was just one workable keyboard arrangement. So I feel like there was a little bit of confusion on the technology on part of the justices from the analogies offered.
If anybody, in the olden days, before we had personal devices, and if you were in Europe and went to a cyber cafe and tried to send a message, you found out the benefits of the QWERTY keyboard, I guess, but whether it was protectable or not is a whole other question. Peter, what are your thoughts in that regard?
Well, I am concerned that the court is not really in command of what's going on. In the case, I think, reveals some of the broader problems of our judicial structure. This case wound up at the Federal Circuit for, I would say, unplanned reasons. Congress never intended the Federal Circuit to become our national software copyright court, but because of the way in which the Federal Circuit's jurisdiction was created, they wound up with this. And I think the Federal Circuit did not apply Ninth Circuit law, but that's no longer the issue. And I don't think the Supreme Court would have taken it had it gone up to the Ninth Circuit and the Ninth Circuit affirmed. So we're in, I think, sort of this kind of worst case scenario in terms of this being organized judicial. I think there's a lot of what I call forum selection problems that trouble me about this whole story. But we could rewind it 20, 25 years, and we see Lotus Borland had other sort of issues that divided 4-4, and we're still, I think, trying to sort out some of that. But after that case, things did settle down. And now, not because Sun Microsystems was seeking to enforce, but because Oracle saw this opportunity, they're in there, we're going to have this battle. I don't think it's going to completely upend the industry either way, but I do think that the principles around copyrightability and Baker versus Selden should govern. And that's why I'm disappointed that Tom is worried about the copyrightability. But I think he's probably right. He leads better than anyone. But I think there's some fundamental misunderstandings about, where these things fall. I think APIs are protectable. I think Tom said they're protectable. It's just that you can't protect them down to the functional specification level. And that's the subtle issue here. And no one's claiming that, Google re-implemented the declaration. And, people talk about things like declaring code, but people in the computer industry don't think of these things as a code, as definitions, prototypes. And so for me, if we were talking about a machine, there's no doubt you couldn't get copyright on this if it were an adding machine. But because it is a digital adding machine, we're having this battle with people who are talking about, playbooks and other metaphors that don't work.
Peter, with respect to the copyrightability argument, gun to head, is there a stronger argument you think versus in this particular case, functionality or merger? If you had to pick one.
I did pick one, and I picked functionality. And I, this is my first time I've seen Tom since the argument, and I was a little concerned when he didn't lead with that, and then he was asked about it, and I thought there was an opportunity to reinforce it or preserve it, but I think some of the justice who was asking seemed to think that Google was placing all of its bets on the merger argument, and this is the same issue that came up in Lotus versus Borland, exactly the same. And I'll say the larger academic brief, which I didn't wrote a separate brief, I argued went up too weak. And the First Circuit went with my argument. They didn't go with what was the equivalent of the merger Altai argument. So I would have preferred, and I think Justice Breyer will probably go for one of the arguments. I have reason to believe from the Lotus case that he probably, but whether others will follow, I worry that we are dealing with people who just aren't really able to think in this kind of machine-like way. I mean, software is a machine. You used to be able to patent cash registers and all kinds of devices by claiming the lever.
Excuse me, Peter. We're having a lot of trouble with your audio. Do you think perhaps other people? I don't know if other people mute. If that will help at all.
Okay. Well, let me know if this is working better. So I do think that we used to protect devices that did the functions of APIs in machine hardware, and I would love for the court to be able to see that we're just carrying things over into a software world that can do it more seamlessly, and that the utility patent system remains there, but we wouldn't want someone to lock up under copyright the method of operating, unlocking, doing the kinds of fairly functional things that are going on at the declaration level as opposed to the full API level.
Kevin, do you have any thoughts on this? And you're muted. Just
yeah. Sorry. Just I guess quick response. With copyrightability and a merger, so you start with the law that that recognizes that computer programs qualify as protected literary works under 102A. I've heard this argument, okay, well, what Google copied was functional. In a way, all software is functional. And so for this reason, there are these built-in limitations to computer program copyright that, say protection doesn't exist to purely functional elements that are the only and essential way of accomplishing a certain task. And I think that's a very important limitation that sort of gets to the heart of the issue in this case, and the merger questions that were discussed at length during oral arguments. It's whether Oracle's declaring code is truly the only way to accomplish the goal of the APIs, or are there other expressions that can do it? And as I think Dale said, there are some things weighing in favor of Oracle here, that the justices seem to recognize that some companies licensed the underlying code. Others, Apple, Microsoft, developed their own competing declaring code. Google decided it didn't want to do that. It initially entered into negotiations to license, but then stepped away, decided to use it anyway without permission.
So if I can just quickly ask Kevin a question. In Baker versus Selden, there was a particular method of double entry bookkeeping. There are other methods available. And didn't the Supreme Court say that you can't protect that method, even though there are other methods?
Well, I mean, I'll defer to you on what it said, but I heard these arguments that Baker v. Selden teaches that the merger question needs to be considered at the time of infringement rather than at the time of creation, and that I've heard a lot of conflicting things there. I don't know if there's something. I went back and read the case. I don't know if there's something specific that either Peter or Tom would point to there that teaches that.
Yeah, Dale, just to jump in at this, I mean, I really think Google was trying to misuse Baker v. Selden. Baker v. Selden is very simple. It's the idea expression dichotomy. We all learned that in copyright class in law school, and that's all it is. And similarly, the Supreme Court in Golan v. Holder has already said that 102B also codifies the idea versus the expression. And so the question is what is the code, the Java code in question, the 11,000 lines of code plus the entire structure, sequence, and organization that Google admittedly copied, is that protectable expression or not? Well, 102B fails because it could have been written many, many, many different ways. That's an undisputed fact. Everyone agrees with that. Google's own experts said it was a very elegant way of writing it. So they're left with merger. But again, it could have been written very, very many different kinds of ways. And that's not merger. And the idea, which is what Google's arguing for the first time in this case, that merger should be assessed at the time that somebody wants to take something, and effectively saying, because it's become popular, because it's become something people like, they should have the right to do it and take it, is antithetical in my mind with the whole purpose of copyright law, which comes from the Constitution. You're supposed to be granted copyright rights in order to have the incentive to create new things. Where's that incentive if you want to ultimately take away your rights, have lesser rights, if you come up with something simple? And
you're going to get, that is as accurate description as Google's argument as you would expect from Oracle's counsel.
It's accurate though.
As I promised this Google's lawyer, I'm pretty capable of describing Google's argument. I appreciate your sense that you have a better sense than I do of it, but you may not quite have captured it. The first is the question begging.
Well, let's let Tom respond now. Okay.
Yeah. So there's a big question here, and it's a level of generality. Is the legal question, and that is, do you ask in merger, is there another way to write declarations that will accomplish a general thing or the very specific thing that's happening here? And that's just a legal question that the parties disagree about. There is a sense that if you ask the question, are there multiple ways that write a declaration that will allow you to access the subprogram that will determine the larger of two numbers? Then yes, there's no question there is. If you instead ask the legal question, are there multiple ways to write a declaration that responds to the particular input from a programmer, max paren 4, 6 in the Java language, you will get the answer no. And which is the right one is the legal question in the case when it comes to merger, and that is what's the right level of generality. But Google's argument has nothing to do with at the time of the infringement. If you accept Google's view that what you're asking is, are there multiple ways to write a declaration that responds to max 4,6, a very particular declaration? There was only one from the very beginning. If you instead ask the question, were there multiple ways at the beginning to write a declaration that accomplishes that general purpose, then from the very beginning that there was. The idea is not at the time of infringement, but in any event, that would describe Baker versus Selden. In Baker versus Selden, there were, as Peter says, there were lots of ways to come up with these methods of accounting. But the question was, after the book was published, when you wanted to use Selden's method of accounting, which existed, and so it was out there, the book was published, and if you wanted to use Selden's method of accounting, were there multiple ways to do what Selden had published out and put into the public domain? And there weren't. There was just one. Kevin, you're now muted.
Okay, Dale, I'll give you, a quick 30-second response if you'd like, or reply.
Or it's basically Google's argument is completely circular. It's, well, because we wanted to use the APIs, we had to use the APIs, and therefore there was merger. I think the court saw through that. And going back to something, for many years, Dale Nelson and I worked together or aligned in protecting Harry Potter. And it reminded me of when I was trying the Harry Potter lexicon trial, which is a fair use trial in New York. And the other side made the argument, well, if we wanted to use Harry Potter, we had to use Harry Potter, and what else could we do? And Harry Potter's so popular, nobody could really hurt it, and so you should have lesser rights. And she testified on rebuttal, and I think in a very heartfelt way as a creator, that if she would have thought in creating those books that she'd have lesser rights because they were popular and people liked them, it just wouldn't follow. It would be a tremendous disincentive with regard to creation. It makes no sense that because it's popular, you'd have lesser rights. And
okay, so I think that's a great segue then into the fair use issues. I mean, sometimes I just, go ahead, Dale. Sure.
I just
briefly, Dale, if I can just briefly say, so Dale, that was a very clever argument that Oracle made at the Federal Circuit. Did not emphasize as much in the Supreme Court with the comparison to Harry Potter, but it's completely inapt. Harry Potter is not a machine. It's an embarrassing argument in my view, because there is nothing functional in a technical sense. You could not patent anything related to it. It's not, it's an argument that a lawyer can make, but not anyone who's thinking about what Java and what these APIs are doing. 11,000 lines of code. It's not true. These are unexecutable function definitions that are interspersed within millions of lines of code. Tom knows the specifics. So, it's when you have a Supreme Court that doesn't understand computer programming, you can push those arguments. I was disappointed the Federal Circuit bought into it, but really, Harry Potter is not a good argument for you, except that people love Harry Potter. But it's just a completely different situation, and I support, and I get in trouble for this because I think copyright should be enforceable. But this is a different situation, and I credit the cleverness of the argument, but not the persuasiveness.
Dale Nelson. Wait.
I think Dale Nelson was going to say something.
Yes.
Yeah, I was just to Dale's defense. I had the exact same thought when Tom was explaining about, the API focus, the Java focus. If you want to use Java, you got to do this. And so it's interesting because it's exactly what popped into my head was what Dale said about, and again, Kevin was talking about the Supreme Court as any court or any person searching for analogy. See, let's try to grasp something that, we can analogize and understand this. And so in response to what Tom was saying, I had the same thought that Dale did when I dealt with at Warner Brothers, not just the lexicon case, but more specifically the argument by a lot of fans that because they're part of a fandom and they want to do things around the fandom, that it's necessary and that should be, somehow a fair use. Not that the property is uncopyrightable, which is what we've been talking about, but this is kind of getting more into the fair use realm. And I think as soon as you say, oh, well, I can operate a Harry Potter themed cafe because it's for Harry Potter fans, so it necessarily has to be Harry Potter themed, then you're just, as Dale said, stripping away the original intellectual property protection and disincentivizing the creation.
I think I can explain that.
So I
hold
what
on, one at a time.
More about that distinction when you say Harry Potter is not a machine. I'd like to understand that distinction better, because I think I'm not just the only one struggling with the analogies here.
I think I can explain the difference, and that is,
great.
Take Harry Potter. I loved Harry Potter. I read the books. I read them to my daughters. I don't have the right as a reader of Harry Potter to go make a work about Harry Potter. I don't. But think of yourself as a Java programmer. You're a Java programmer and you know all of these instructions. Those instructions are not copyrighted by Oracle. You've learned them. That's the whole point of copyright, of course, is that something was published and you learn something. And if I use the instructions that allow me to invoke the Java API, then I'm doing something that's perfectly legal. I can write wonderful creative computer programs. And so that's the huge difference, is the programmers here have the unquestioned right to do what the reader of Harry Potter has the unquestioned inability to do. And that is, those programmers want to write incredible things and use the knowledge that they learned. And the only way for them to use the knowledge that they learned, these thousands of instructions that they know that are core to the Java programming language, which is not copyrighted by Oracle, is to be able to communicate with declarations on the other side. And so it's radically different to say, okay, to compare it to a situation where the user here is legally disentitled to do something, to the circumstance in our case, which is that they have the absolute legal right to do the thing, to use all the instructions that they know. It's like this sentence that's coming out of my mouth right now. I'm speaking to you and hopefully in some semi-comprehensible way. If Oracle was able to say, aha, but you don't understand, we have a copyright on the only language that will allow you to understand the words that are coming out of my mouth right now. That would, I think, be radically different from the Harry Potter situation.
Let me back this up just a little bit to a sort of more basic question about this case. When you're describing the use of code, are there specific factual determinations? Have specific factual determinations been made with respect to each code, with each line of code, the 11,000 lines of code that Dale referred to? Is that something that really the Supreme Court should be passing on? Is this or is it something that should be remanded? I don't know. It's not rhetorical. Dale or Tom?
There's no reason. I think that it's important to remember that there is a whole body of facts that were developed and were part of the record that people, and I'll say my friend Mr. Goldstein, sometimes don't like to mention, but the inconvenient truth, it's already an undisputed fact in the record that the only little bits of code that were necessary to use the Java language are not part of this case. You can use the code that you need to use the Java language. Not part of the case. They want to use things that they want to use because they wanted to migrate people who were, for the sake of Google, too quickly because it was suffering an existential crisis. Apple was getting out ahead of it, and it desperately wanted to rush to market with something to be able to use search on mobile phones, because that's where they saw the business was going. This were a trade secrets case, and someone had walked into Oracle's offices, taken all their trade secret protected code so they could get a big head start against a competitor. Even if they knew it, there's no way anyone would think that you'd be allowed to do that. It's like twisting and turning arguments. This isn't about the language. This isn't about what was necessary to be used. They used it because Google used it because it wanted to use it, because it had a commercial.
Okay. I'm going to jump in now because we're sort of making a natural segue to some of the fair use issues. One of the arguments is here. I frequently characterize arguments I hear about fair use as I really, really, really want to use it. And so I'm curious as to sort of fair use question A and fair use question B that was raised here. One is this fair use? And then the question, and then the sort of subsidiary question regarding the jury's ability or invading the province of the jury. So Tom, why don't you start out talking about fair use and the position? Let's sort of take it from the last question, which is what are the risks of the jury of invading the province of the jury?
I mean, that is the bitter and funny irony of DLC's view of like things that people don't want to talk about on our side, given when it comes to factual development, the argument that she just eloquently described is the same one that Oracle eloquently attempted to describe to the jury, and the jury said was hokum and ruled in Google's favor, right? This entire narrative of like, oh, we had to steal it, and oh my God, we're afraid of Apple, and all of those sorts of things is exactly the fair use case that was put on by the parties, and exactly the question that was put to them at Oracle's insistence of, a general fair use verdict. And so there's not a specific fact by fact verdict. There is a general jury verdict here that the parties agreed would be what was put to the jury, and the jury found that there was fair use after considering all of this. And so that is the question, the follow-up question that the Supreme Court asked the parties to provide supplemental briefing on. Oracle's view is that there's a categorical per se inability to find fair use here. Google's view is that there's on the opposite side, categorical per se fair use. And then the middle ground is that, well, it's just going to depend on the particular arguments and facts that were put before the jury. And I think we all have to agree that there is there's a higher bar, a materially higher bar when you are faced with a jury verdict, particularly when you've insisted that the question be put to the jury. And so I do think that that's going to be probably the easiest and most likely off-ramp for the court, is to say, this is going to be a very fact-bound question that's case by case that the industry is frankly going to find dissatisfying. I think that people on both sides would prefer a greater level of clarity than that. But it wouldn't be surprising, given the point that you made and that others have agreed with, that the court was not, despite 100 briefs, did not seem entirely comfortable with the technology, and I think is concerned about getting, fully embracing Google's view of the world or fully embracing Oracle's view of the world as being too dangerous to the longstanding programming practices, or being too invasive and too much of a deterrent to innovation if you give too broad a right to be able to reuse certain instructions. So I would say that the court is going to be very, very, very interested in whether there is sufficient evidence to, overturn the jury verdict here.
Sort of tied to that question with respect to fair use, to the extent that you think that fair use principles may come out of this case, should we get a decision and there's not sort of a complete punt, kicking it back to the jury, how applicable, and I'll ask for volunteers on this and then we can go from there, but how applicable do you suspect, and this is reading tea leaves obviously, but do you suspect that a fair use finding by this court will be sort of across the board, or do you expect more of a discussion of fair use vis-a-vis software? Are we going? Is this decision, put another way, is this decision going to shed more light on Campbell? So, anybody want to take that? No, Kevin?
Yeah. So, you know, I don't know if they're going to issue some far-reaching fair use factor analysis, but I think at oral arguments, like as far as the transformative fair use issue under the first factor, you know, there wasn't a lot of discussion around it. I think Justice Thomas raised it, and Oracle's attorney talked about, you know, the difference between permissible infringement in the context of reverse engineering or studying code as opposed to incorporating code in a competing product. So, you know, there might be some discussion of that in a decision about when, you know, does transformative use mean that you are, you know, using it for a directly competing product? You know, does transformative mean that it just goes from a desktop or laptop to smartphone and tablet, you know, which would be more specific to the software industry, but, you know, there could be more far-reaching implications about, so this, you know, is this just a mere change in the underlying medium? And then for the fourth fair use factor on the existing potential markets, you know, I could see them coming out and you know, issuing a decision that says, no, this is about potential markets. Copyright owner need not enter all conceivable markets at once. You know, just because someone wasn't successful, like Oracle at the first go round, doesn't mean that they lose the right to enter the market again. You know, and just say that copyright law protects the ability of creators to choose whether and when to enter the particular market, or when to create a derivative work. You know, whether someone has immediate plans to exploit that opportunity should have no bearing on the fair use analysis. So maybe that's wishful thinking, but some of the justices at least seemed receptive to those arguments.
So related to that, since we're sitting, or I'm sitting in the Seventh Circuit literally, and you are virtually, when I hear people talk sort of mechanistically about factor 1, 2, 3, and 4 in the fair use analysis, I've sort of been guided in this circuit by Posner's Tie versus Publications Inc. case, where he emphasizes that, and this is nearly 20 years now, that the statutory language and the factors used in fair use are illustrative and not exhaustive. And given that, and given that what Kevin was just sort of getting toward, is there any appetite, do you think, by the court to give more guidance regarding application of the factors and sort of how slavishly you need to follow them? I see Dale Nelson's mic is off, so I'll ask her to jump.
Yeah, so it's interesting for me. You know, as I said before, I'm a non-software fair use practitioner, to look at Google's arguments here, and, you know, all the parties' positions on fair use. You know, the way I tend to look at fair use is just as the jurisprudence in general is there's categories of fair uses, right? I mean, you know, there's the classic, you quote something to comment on it, commentary cases, you have the parody cases, of course, Two Live Crew and guidance from the Supreme Court on that. That's another kind of commentary involving expressive works. And you have lots of other cases involving expressive works You have the Carey case where there's an artistic transformation where the court explicitly says you don't need commentary, okay? And then you have this whole line of what I'll call the social utility cases where, you know, Google has actually been in the forefront as, you know, being the disruptor that it is. In this Perfect 10 versus Google and Google Books, you know, as a classic example of that, of really pushing the line of fair use in the social utility area. And so I find it interesting because I think that, well, first of all, my first thought was, you know, this would be Google's area to argue to the court, you know, a tributary of fair use cases involving social utility, social purpose under the first factor with things like, you know, the Kelly versus Ariba case and Google Books. But in Google Books, for example, Google took great pains to limit itself. And I think that really helped Google in its win in that case by making sure that the service was free to use, that it took care to only include public domain works, and for the works that were not public domain, only snippets would be returned. But in addition, made sure that through its algorithms or whatever, it's my understanding, a user could not return snippets to reconstruct the entire book. And for those reasons, it avoided things like poetry and recipes or, you know, short works of that kind. There were other limitations that I think helped lead the court to find that it was a fair use in this kind of social utility area. Here, I don't really see it fitting the same model. So I asked myself, you know, where is Google going here? Is it trying to create a new category? And if it's a new category, what's the test? You know, is it an interoperability argument that's really at the core of this? And I, you know, saw mentioned in one of the briefs, the Copyright Office in 2016 talked about interoperability as being a fair use, should be a fair use purpose to be considered. I'm guessing that was sort of in the wake of the Lexmark case and the garage door openers and those kinds of things. But I'm interested, you know, and Tom, maybe you can speak to this, why Google didn't focus more on those kinds of cases. Well, there's Betamax too, right? But it seems like rather than rely, at least in the briefing before the Supreme Court, rely on those cases like Betamax and the Lexmark cases and Google Books, the emphasis was more on the traditional transformative cases like the Swatch case and the Seltzer versus Green Day case. And so I wonder why. I think I'm getting a little far afield of whatever the original question was, Kevin, but those are some of my thoughts on the fair use arguments.
Thanks, Gail. I think that's great. Tom, since she called you out by name, you get first crack at this.
No, I think it's extremely thoughtful. And there is this question of, okay, we do have a history in the Supreme Court of fair use jurisprudence. I think Dale Nelson accurately conveys like where the law had been. I think the difficulty that we point out is like, okay, if those are going to be the boxes, then we're really not going to have fair use for computer software as a practical matter. I mean, people very rarely parody computer instructions. They don't tend to turn them into art. There isn't a lot of political commentary about the Java APIs. You know, that those kinds of things, if those really are what we're going to determine to be the boundaries that we attach to fair use more broadly, it means that there's not going to be fair use for computer software, which would be impossibly ironic, given that computer software is the closest that we're going to get truly protected as in appropriate circumstances as a literary work. But it, you know, is clearly quite functional and is the thing that you would think is most likely to be subject to fair use, because it's not literature. We aren't making a movie. The things that Dale Nelson has so creatively worked to protect throughout her career don't look a lot like the Java API. And so, you know, we do think that there is, and Justice Kagan in the end asked this question, it's like, you know, are we really asking kind of the wrong questions when we're talking about computer instructions? In treating them as if they were literature or a movie, or, you know, does transformative use need to be reconceptualized when we're talking about computer code? And the difficulty when you're advocating is, you know, how much are you willing to say, all right, I can make my case fit within the boxes that you've previously identified, or am I going to simply say you need new boxes? We do talk a lot about Lexmark as a good example for us. We talk about the Ninth Circuit cases involving, say, Genesis and that sort of thing. And I think our general view is the one that people understand, and that is, okay, this was a set of instructions that were written for desktop computers, and we are now using them for something to create a mobile operating system. And then Kevin Madigan says, well, you know, why isn't that something that Oracle gets to do? Like, why do you get to say that you're now going to do it? And then there was a bunch of evidence about whether Oracle was capable of doing it. But I do think in the end, the Supreme Court is likely to say, and who knows who they'll say wins, but that you can't just treat computer instructions the same way you're going to treat a novel for fair use purposes. Maybe they'll say this isn't fair use, but I don't think they'll say it's the same thing.
Go ahead, but I also have a follow-up question for Tom, and then Peter, you haven't spoken in a while. We will get to you right after Dale, I promise.
I think that this is another one of Google's skies falling arguments to try to argue, oh, well, maybe there won't be fair use at all for computer programs. That's you know, ridiculous. And the 4 factors, absolutely, which are non-exclusive, but people all the time use them for all kinds of cases. That's the whole purpose of the Copyright Act. And factor 1 is it exemplifies that. If this case was more like Sega and Sony, when someone analyzed a code and studied a code and copied it for that purpose, that could be fair use. But if you just copy somebody's code and slip it in verbatim in a competing product, that's not going to be transformative. And factor 2, which the Federal Circuit said went Google's way, is a way of saying, okay, well, I think that this might be you know, more functional. Frankly, I think the Federal Circuit should have acknowledged more that there's different kinds of computer code, and that just because it's code, they shouldn't win factor 2 all the time. And code that's really complicated and thoughtful and elegant might be entitled to broader protection under factor 2 than shorter other kinds of code would be. And factor 3 applies to computer program as much as any other literary work. You know, are you taking the heart of the work? You're taking the most important part. That applies. And then factor 4 applies to everything too. So I think that the existing fair use parameters are more than able to deal with any kind of work, and that we shouldn't forget that Congress had its opportunity. They had a whole analysis in Cantu and concluded that computer software would be protected by copyright as a literary work.
So along those same lines, Peter, as soon as I ask my question, I promise I'll have you jump in too. But I do want to ask Tom about additional boxes. You mentioned maybe there are additional boxes. So what are any additional boxes that you think the statute could support?
Well, I think that Dale Nelson properly focuses on interoperability. And we think, and this is of course putting the jury verdict to the side, so we're just going to pretend that we had a bench trial when we didn't. But I do think that a big part of our fair use inquiry is, all right, the point of fair use is to maximize expression. It says, look, we're not going to apply copyright where the on-net effect would be to reduce the amount of expression rather than increase it. And so I think our point with respect to this case in particular is, what we did was we allowed the Java programming community, millions of people, the opportunity to write applications for a path-breaking mobile operating system that didn't exist and wouldn't have otherwise existed. And if you were to instead say that copyright applied here and Java prevented those computer programmers from using the language that they already know, over which Oracle has no copyright whatsoever, then you would have eliminated not just Android, but also all of the other programming. And so I think that it's a notion of, if what you are doing here is something that is going to facilitate unleashing a huge amount of creativity by people who aren't subject to the copyrighted issue, then that would be, you know, archetypical fair use.
So I want to just come back to the proposition that Google broke into the Sun factory and stole code. The declarations are all published and have been published for decades for particular APIs. And the declarations are really like the first letters of the commands in Lotus. And they are then implemented through a rich body of code, which, Tom can correct me if I'm wrong, Google implemented in a clean room. Early in the case, there was some dispute over whether the clean room was in fact clean. As I understand it, Oracle dropped that. It never got very far. And that would have been a legitimate claim that I think Dale, you know, could have ridden that horse on. But in fact, you know, when you say 11,000 lines, they're not executable code. They're just following the conventions that are part of the programming language, and they were public and they were implemented in a clean room. So I think that is really conclusive for me with respect to the copyrightability issue. And as regards Cantu, the Cantu report says very clearly that you're allowed to implement a particular machine, not a machine that does the same functions, a particular machine. That means a machine that can, at a very detailed level, achieve the exact same specifications, so long as you don't copy the code. And in this case, they didn't copy the code. They only copied that which was necessary. And this is, you know, this was what was argued about, and Google prevailed on this. They only implemented, you know, those specific hooks that are necessary to achieve the functionality of the particular machine. And they wrote it all from scratch and only used the glossary, which was necessary to achieve the particular machine. So I think it goes to copyrightability first and foremost, and I'd like to see it in there. If we get into fair use, the fact that they didn't copy the API, they copied only the glossary, declaration, function prototypes, whatever you want to call them, implemented themselves. They didn't. It's true that Google wanted to get to market, but it took them a lot longer because they decided not to do the shortcut. They did the long cut, and they did the, you know, what was not just industry practice, but I think is consistent with the Baker versus Selden model and other sort of case law, especially from the Ninth Circuit, but some of it is in the Second Circuit, some of it's in the First Circuit. So that's how they approached it. And so it could enter fair use. But here's why I'm worried about fair use. As was developed later in this case and ended up not getting resolved before it went up to the Federal Circuit and up to the Supreme Court, is the fact that Google has, as I understand, they've migrated this stuff to Chrome and to the desktop. And so if you're doing fair use, you know, so if they win now, does that mean we have to go back and have another trial if Google wins to say that it's not fair use to do it on Chrome? And that's why I think fair use is really a terrible resolution for everyone, because it just means we're never over and we don't have any general principles.
Delson Dally, I'm going to give you a chance to respond if you like. Otherwise, I can ask some more questions. And I do want to tell our audience that, oddly enough, we haven't gotten a single question from anybody. But if anybody has questions, please do post them.
Well, I just wanted to say that leaving aside, I respectfully disagree as to the facts of the record, but I think that factor 4 is getting a lot more attention today in many courts. And we, even in this discussion, And I think properly so. Remember, initially, factor 4 in the nation, the Supreme Court said maybe it's the most important factor. And then people started talking more about transformativeness and the like. And there was a big discussion going on in the bar, including with our academic colleagues about, well, wait a minute, it's for a lot of folks, if you win on transformativeness, then you win on all the factors, right? Because you only took as much for your transformative purpose, and you can't have a market and your transformative purpose and all the rest of it. And that seems to be ebbing a little bit. And actually the Seventh Circuit Scotty Nation case, Kevin, going back to what you were saying, was a case that more recent than I think the case that you were citing, that says, let's look at these 4 factors. Yeah, they're non-exclusive, but let's not forget these 4 factors and come up with something, be it transformativeness or something else, that eats it up. And I just wanted to kind of end my little comment with, if ever there was a dramatic, heinous example of factor 4 decimating a company, it's the impact on the market harm with regard to Oracle. All the facts are in the record. They had a business, they had customers, and they went to nothing on actual markets because they were already in smartphones, zip, not even having to get to potential markets. And I don't think that should be overlooked. And I think jury verdicts are reviewed all the time. And the idea that anyone would want to suggest that jury verdicts should not be reviewed and reviewed with regard to the facts, especially on mixed question of long facts, I think is just wrong.
It's interesting in this case, when we're talking about, so there are 2 primary issues in this case, are idea expression and fair use. And I think, is it Eldred and in Golan, when Justice Ginsburg, I think in both cases, says that copyright is supposed to be the engine of free expression, and that but for fair use and the idea expression dichotomy, there was a question about how far the 76 Act could have extended when the publication requirement was removed. And I may be butchering that in an attempt to summarize it. But the point is, I would like to go around very quickly, and then we'll go to some of the specific questions, to ask folks to tell me, and you don't have to if you don't have a particular thought on this, but how is it that either Google or Oracle in this case, with their respective positions, in fact, are contributing to the engine of free expression? So let's
quick before that, Kevin,
yep.
if I could. Yeah, just there's 15 minutes left in the panel,
Yep.
but I think Dale Nelson also pointed out there were a couple questions as well. Just we'd like to get to those if you can.
So as soon as we go through this, we're going to get to those questions.
Thank you, Kevin.
Yep. So anybody have any thoughts on that? And it's fine if you don't.
From Google's perspective, it's the obvious tension that has to be resolved in copyright law is that we don't want to disincentivize somebody from creating in the first instance. That's Oracle's focus. And we want to make the most of what is published in order to generate additional creativity. That's why we're trying to incentivize it in the first place. And Google's view about this is that the very unusual feature that comes from something like an API, from the declarations, is which legal rule is going to unleash the programmers, who are the kind of innocent third parties here and are the hero of Google's version of the case. That those people know the Java programming language, have the right to use it. We want them to. Everybody should want Java programmers to be creating the most incredible stuff ever. And so Google's view is that its rule is very much the one that is going to make that more likely, because if more people can recognize the if Oracle is the only one with the right to recognize the instructions that the Java programmers know, then it has a holdup right. It can adopt enormous constraints. But if other people are able to recognize the instructions the way you can hear the words coming out of, when Dale says something, just imagine if her client was the only one who had the right to the translator that let anybody understand the words coming out of her mouth, and see how much she would like it. and how much expression would result from that.
Okay, Dale, and then I think Kevin, you have thoughts too. Okay.
This is really a serious point. On panels I try to be, friendly, but I'm really concerned here about the future of American law. If ever there was a company that had the ability to do what Apple and Microsoft did and come up with something creative and wonderful, Google could have done that. It did not need to do it on the back of Java, and it did that. It created fewer opportunities for programmers, not more. There are more enriched folks in the world because Apple went through the effort and creativity to create iOS. Google could have done that too. It chose not to. And I think a fundamental thing that's missing from this, that's shockingly missing from this, is the entire purpose of Java. Java was created at a time when there were a lot of programs that didn't work. That I'm sure Peter Manel would know better than me, that it was really hard. People were writing to all sorts of different media all the time, and it was a pain in the neck. And so Java created something which was called the write once, run anywhere. And that was the whole point. You could write a program, it could run on anything. And when other people were allowed to use Java, including it's offered with open source, they just had to do this, agree to do the same thing. But Google didn't even want to do that. Google Android is not compatible with Java. You cannot run a program on Java on Android, or vice versa. They broke the write once, run anywhere for their own purpose. And they're literally crying to the bank now. I think that's wrong. I think it's wrong as a matter of copyright law. I think it's wrong as a matter of American business, when the software industry is incredibly important. And who, going to your question, Kevin, is going to invest billions of dollars to come up with something and to keep improving it and making it wonderful for people, if somebody can just come along and take it and make their own billions on it and leave you with a rock?
Okay, we have to get to questions, but Kevin Madigan, I'm going to give you 1 minute.
Yeah, just really quickly, I think Google's sort of advancing this adverse possession theory of new markets, where a secondary user is rewarded for quickly being able to create a derivative work or enter a new market by copying the original. And I think this would really favor large companies with greater resources over smaller individual creators who may not have the financial resources or ability to immediately enter all markets. And so, I think a finding in favor of Google in this case could disrupt that balance by making it not only too difficult for creative software to be recognized as copyright, but too easy for well-resourced companies to convert a copyrighted work from one medium to another and claim that the adaptation is fair use, which would be very harmful to smaller copyright owners, smaller businesses, especially in emerging industries where it's not always clear where the next market will be.
I do want to get to a couple of questions that have been posted. The first one is, does it matter that there is a choice in using a given language? Tom seems to suggest that coders are necessarily restricted to using that language and must therefore be able to use however they want. Okay, Tom, you've been called out, so there you go.
It's true that, as with everything, I could now speak in French or German if I only knew them, but that is not the law. And Baker versus Selden didn't say, well, you could have written a book about copyright in Russian. Copyright is always understood to operate from the language that is at stake. And so if someone has invested their effort in learning Java, right, you learn thousands of commands, including these shortcuts that are only accessible through the declarations. And our point is that that's not copyrighted, and we want to encourage those developers to be able to write for whatever it is that they want to. And to Kevin's important point about, we don't want people just to be able to take works, supplant them, and move them to another platform. That is Peter's point, that all of the actual operative code here, Google didn't take from Java. Google wrote its own instructions, which make up 99% of Android and the equivalent of 99% of the Java API. So people do compete on implementations. That's how the industry has always operated. And the irony of Dale saying, you know, this is really important to the software industry is that the software industry overwhelmingly supported Google in this case. And so I think Google, Dale, I mean, well, people can read the briefs and see that you're wrong. The way that the industry has operated, including Java, which re-implements earlier declarations itself, is that if there's a set of instructions that is the link, the interoperability between instructions in one program and instructions in another, that has been reusable so that we have effective communication. And we don't say, well, you know, Apple made you learn a new programming language, so everybody we should just have 28 different programming languages. It's nonsensical to say that millions of people who know how to use Java should just stop using Java and Google should make them learn a new language or 1,000 new instructions in Java, which would be, Oracle says would be perfectly appropriate here.
Do we have a counter to that? No. Oh,
no sense is the counter. It's like create your own language. Or why didn't Google? Let me ask you this question: take the license. It's in the record that Oracle offered them the license to do just what they wanted to do. They just had to make it compatible, and they refused. It's in the record that negotiations didn't break down because of money. They broke down because Google wanted to have its own proprietary system, getting the benefits of Java without having write once, one anywhere. Why didn't it just take the license is the question I have.
No. So there are three answers to that. The first is your legal position is that Oracle doesn't have to offer the license at all and could just tell everybody tough. The second answer is that the negotiations were over using all of the Java API, including the implementations. The third answer is that because it wouldn't work. So what happens is you have this proprietary old system for running on desktop computers. And you take an early smartphone. Does everybody remember their early iPhone? It's like this little device. It has very little RAM. It has much less processing power. It would have been metaphysically impossible to take all of Java. And that's why Java's own mobile version doesn't include a huge number of the implementations that are an issue here. You couldn't take all of those instructions. Like, why in the world would you want to insist on the 1,000 instructions that relate to an external mouse and an external monitor and make them for a smartphone? It would just be programming idiocy. It's a completely different platform, which is why there are lots of different parts of a computer in the traditional Java sense that have nothing to do with a smartphone. And it wouldn't have been possible. Now smartphones are a lot more.
Everything you said is not in the record and it's inconsistent with the facts. Or Google didn't want to take it, and it's in the record because it did not want to have to give back and didn't want it to be compatible.
Right. I give you either Oracle's lawyer or the jury verdict. You can choose which one you believe.
Well, I'm just going to go with the facts. It's in the brief. Send me an email where in the brief that what you just said, and where in the record what you just said is true, because it's not.
That is not right.
Peter, I think you wanted to say something.
I think Tom covered it pretty well. I've written a monograph length sort of history of the case, and I think it's not just the case of the technology, and it's a fabulous story, one of the most interesting stories. I hope Aaron Sorkin writes the film. And, we would all, I think, benefit, Sun was a very different company than Oracle. The story is very intricate. Google did not want to have a proprietary operating system. In fact, it wanted to have it created the Open Handset Alliance around Android to create a competitive alternative to iOS, but it wanted to avoid the general public license. That was seen as a non-starter in terms of building this alliance. And it's an interesting story of business and economic history. And I'll just say, I can't say as Dale might or Tom might exactly what was in the record, but I know a lot of the story was in this decade-long record.
Okay. One other question that
highly ranked is, who on the Supreme Court do you think is going to be the most interested in the outcome? Anybody have any thoughts about that?
So I'll just add, I think Justice Breyer will definitely be interested. He wrote an article in 1969 where he started to explore these issues. I, had the opportunity to study with him and in the 80s, and he was very, very interested in these issues. The Lotus Foreland case was one that arose while he was on the First Circuit. He was on the panel. Ultimately, he recused himself while he was nominated to the court, and he didn't recuse himself when he was on the court, and that's an interesting, just historical. But there's no doubt that he is very interested, and I think has some comprehension of what was going on technologically. Justice Kagan is also somewhat interested in that some of the Lotus case came up while she was in the Office of Legal Counsel or some other office during the Clinton administration, and I suspect she'll be interested as well. I worry that some of the other justices are probably not really comfortable with it, and hopefully their clerks are helping them to sort through that right now.
Did anybody else want to weigh in our remaining 40 seconds?
I guess I just wanted to say I would have liked to have seen the justice who would have been very interested, which is Ruth Bader Ginsburg. And I don't, honestly, whether she was for us or against us, I just would have liked to have had the opportunity to weigh in. She really knew copyright, and I would believe what she wrote. And one of the unintended accidents of the argument being pushed later was that she was no longer on the bench, and I'm sorry she didn't have that opportunity. However, she would have decided it.
That sounds like a perfect way to end. Panel, thank you very much. This was a very engaging discussion. Thanks.
Thank you.
And thank you to Kevin and our panelists for an incredibly interesting panel. So with that being said, as we sort of clear out the off the stage here, let me go through this real quick. Bye. Let's see how long he keeps waving. No? Okay. With that being said, I'd like to thank all of the panelists and our moderators and sponsors of this event, as well as our student ambassadors for joining us today and with their assistance in making all of this happen. I will say, if you requested CLE for this event, we will have those certificates prepared and mailed out to you in about 3 to 4 weeks. I would ask that you would complete the evaluation form. There's a link to it that will actually it'll link to the materials and the link to it's in the link from the Eventbrite page, but also there's a link to it at the bottom right hand side of your screen once we go back to the tables. I will also post the link in chat. We've transferred it to a form, an online form, as opposed to the paper copy that we've used in the past, so to make it easier for everyone to fill out. We will now be transitioning to the closing receptions. So as previously mentioned in our 2 other virtual receptions, feel free to join a table, chat with speakers, panelists, other attendees. And again, if you need any technical assistance, I will be available, and I'll be making my rounds, as well as the student ambassadors. We will also have, as we had in the past, student ambassadors manning the help desk. And again, thank you for joining us, and I hope you have a great rest of your day.